ಸೌಂಡ್ ಬರ್ತಾ ಇಲ್ಲ. ಕೋರ್ಟ್ ಆಲ್ 4 ಧಾರವಾಡ ಬೆಂಚ್. ಕೋರ್ಟ್ ಆಲ್ 4 ಇಲ್ಲ.
ಅದೇ 4 ಅದೇ ಓಪನ್ ಮಾಡಿದೆ.
ಬಂದಿತ್ತಿಲ್ಲ, ಇನ್ನೂ ಬಂದಿಲ್ಲ. ಹಂಡ್ರೆಡ್ 403 ಇಲ್ಲ.
ಕನ್ಸ್ಯೂಮರ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಕ್ಟ್ ಪಕ್ಕದ ಕೋರ್ಟ್ ತಂದ್ರೆ ನಾ ಇಟ್ಟಿನಿ. ಅವು ತಂದ ನೋಡಿಲ್ಲ ಅಲ್ಲ 3 and ಕ್ಯಾಟಸು ಫ್ರೆಶ್ ಮತ್ತೆ ಫೋನ್ ಎಲ್ಲ ಮೇಡಮ್ ಕ್ಯಾಕ್ ಮೇಡಮ್ ಅವ್ರ ಹತ್ರ ಕೊಡ್ರಿ ಅವ್ರ ಹತ್ರ ಕೊಡ್ರಿ ನೀವು ಕೊಡಬಾರ್ದು ಅವ್ರ ಹತ್ರ ಕೊಡ್ರಿ ಮೇಡಮ್ ನೀವು ಕೊಡಿ ಆಮೇಲೆ ಏನಪ್ಪ ಇಲ್ಲಿಂದ
ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಬರ್ದಿಲ್ಲ ಅವರು
ತರಿಸ್ತೀನಿ ಅಂತ ಫೈಲ್ ತರಿಸ್ಕೊಡು ಇದು ಅದು ಇದು ನಿನ್ನೆ ಆರ್ಎಸ್ಸಿಗಳು ಹಾಕಿದ್ವಲ್ಲ ಆರ್ಎಸ್ಸಿ ಏನಾಗಿದೆ ರಜೆ ಅವ್ರು ಬಂತು ಅದಕ್ಕೆ ನಾವು ಇಲ್ಲ ಅದಕ್ಕೆ ಇಷ್ಟ ಹೇಳ್ಬೇಕು ಕಾಮನ್ ಇಲ್ಲೇ ಇಟ್ಕೊಂಡ್ಬಿಡ್ರಿ
GMFC
ಎಷ್ಟು ಯಾರ್ದೈತೆ 4 ಫೈಲ್ ಇದಾವೆ 4 ಇಟ್ಬೋದು ಸರ್ ನೀವು ಇಲ್ಲಿ ಇಂಡಿಯಾ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು ಬರ್ತದೆ
GM
ಲಿಸ್ಟ್ 2 ದಾಗ ಅದಾವ
ಇದು ಫಸ್ಟ್ ಡೇಸ್
ಅವರು ಟೈಮ್ ಕೇಳ್ತಾರಲ್ಲ.
Is all fresh matters, give it to
Yes.
the court officer. Other than that,
fresh matters
one submission, my lord.
Lord's kind permission, my lord.
So let this be completed, then we'll, yes. Fresh matter, give it to the court officer, it will come. No, give it to the court officer. All fresh matters, please don't mention, yes. Anyway, it is rejected now. We'll see. Yes. Extension of interim order. We'll see. Yes. Give it to the court officer. We'll see. Yes.
GMCPC matter, my lord, next week any day.
What is
GMCPC
that?
matter. GMCPC matter, temporary injunction is passed against me, my lord.
When?
It is in 2025 only. The matter is also 2025, my lord. I am for the petitioner.
No, it will be like this.
My house.
Wherever the memo is, wherever you mention, then that matters only we will take up. Then what will happen to the other matters where the stays were granted and pending from a long time?
My house construction is stopped, my lord. That's why. Next
We
week.
will
any
see.
day.
Yes.
Lordship and submission. Your Lordship is service matter. Your Lordship, there is a covered by judgment. There is service matter. Your Lordship, there is a covered by judgment. Your Lordship.
Yes, Tuesday.
My lord, in this case, my lord, that motor vehicle accident case, a suspected fraud case, we have someone in the CCTV footage. Emergency notice has been issued. Now the matter is posted for the respondent argument. Now can it be considered the interim application, my lord, and
Yes, Wednesday.
my lord's kind permission. Apologies, my lord. Fresh matter. Urgency for seeking tomorrow is this, my lord. The deputy registrar has stayed, my lord, the process of election after, my lord, conclusion of the election for board of management. Now, my lord, the election for the president and vice president is, my lord, scheduled. That has been stayed, my lord, against the settled legal position that he cannot interfere, my lord, during the process of election. Therefore, my lord, yesterday also I moved it, my lord. There is some.
No, because there are so many.
No, I
There are
understand, my lord,
130 move of-
one matter, my lord, tomorrow. The process of election, my lord, please.
With your Lordship's kind permission.
And there is one pending matter. Correction of.
memo. Yes.
Please.
Impleading I have filed. The matter is that, Lords, I have filed a complaint before Deputy Commissioner that there is land encroachment. Subsequently, Deputy Commissioner has ordered to inquire. Now, what has happened is, Lords, they have approached this Honorable Court and got interim stay without making me as a party to it. Also, there is a public interest litigation filed before the principal bench, which is pending. Since there is a stay in this case, I am not able to prosecute in that. May I request for please?
Listed on 28th. Yes.
I'll
My
be
lord,
able-
one matter, my lord, cooperative election matter, my lord. Petitioners are seeking right to vote, my lord. My lord, election
when-
is on
when the election?
18-1, my lord.
When is the election?
My lord, 18-1. My lord, may kindly have it tomorrow, my lord.
Tomorrow.
Please.
No, it's one MFA matter, my lord. Next week, any day.
MFA, MBC.
Please.
Yes.
Monday.
Lordship, family matter.
CPC matter against order 39 rule 1 and 2 order, my lord. At instance of defendant, my lord, not to disturb possession order is passed. The matter was heard, my lord, and it was posted for final hearing on the, my lord, understanding that it will be heard finally. However, my lord, on last bench.
Yes, this is matter on 29th of January. Yes.
One matter.
9th.
My lord, it has become infructuous any day next week.
Yes, tomorrow. Yes.
Lordships.
Not tomorrow. It's on Monday. Yes.
Yes, please.
Yes.
GMCPC fresh matter, my lord. I am the defendant before the suit. The trial court has refused to grant an interim order to the plaintiff.
Fresh matter will come.
This is third memo, my lord. My house is construction.
When did
is
you give
start.
the 1 and 2, first and second memo?
Day before yesterday.
So it will come. It will come. If your memo is already there, it will come. Yes.
My lord, its wife's maintenance is stalled in the district court. So respondent is seeking to.
Which year is the writ petition?
24. She is not having any maintenance now.
February 1st. Yes.
Lordships, 498.
Fresh matter, give it to the.
Lordship,
court officer.
498A, Lordships.
Huh?
Lordship,
List that memo for withdrawal on Monday. Yes. What is that? MFA covered by judgment. What is that?
Lordship, 498A, Lordship, in-laws have filed a petition, Lordship, 498A matter.
Why it will come before this court? What is that?
Writ petition, Your Lordships. In-laws have filed. GM rest, Your Lordships.
Huh?
In-laws have filed, Your Lordship, writ petition.
Questioning what?
Questioning.
Registration of the complaint.
Yes, Your Lordship.
Why it
Yes,
will
Your
come
Lordship.
before this court? Verified. Yes.
My lord, the petition one, the application filed for, petition filed under 166.
This will apply to you also. Already one memo is over. Yes.
That matter posted for argument, my lord. That's all. Next week, any day.
We'll see.
Next week.
Labor matter, my lord, 2018 matter.
Yes.
That's cooperative society election matter. This, my lords, this court has granted an interim order of stay for the further election process. My lords, I being the impleading respondents in this matter, my lords, we are, my lords, we have been elected, my lords, unanimously elected, my lords. Now, by the virtue of the stay, my lords, my result has
When
not.
was the stay granted?
My lords, it has been granted in the month of February 2024, my lords.
We'll see.
My lords,
Yes.
tomorrow.
No.
My lords, one
But
MFA
we are having no objections for
February
the.
2024. Why should we take it up now?
Now, my lords, elections are getting early, my lords. In the month of February, my lords.
We'll see.
DCC bank elections.
Yes.
One MFA matter, my lords. It's a case of injury. MFA, my lords. It's a
Take
case
that.
of injury. Monday, my lords.
Next date, next week, any date, my lord.
Next week, we can't decide now. We will see next week. Yes.
One minute. Sir, the last application, I have filed a last application, my lord.
What is that?
NCPC matter, my lord.
Huh.
I have filed a last application. Respond number 3 expired, my lord.
Which year is that?
2024.
Take it, list it in the month of February. Yes. Call the list.
On pending matters, my lord. Only correction of name, my lord. It's
Huh?
pending matter, my lords. Covered matter, my lords. Any date may be given.
List it on February 15th.
February 15th.
February 16th.
That's next week.
No. Yes.
No.
My lord, next week, any date, my lord. Interim order
Here
passed
is
by
that. Here is the writ petition.
24, my lord. James.
No urgency, no. Yes.
Page wise adjournment, list number 1, page number 1, serial number 1 to 5, page number 2, serial number 6 to 8, page number 3, serial number 9 to 13, page number 4, serial number 14, page number 5, serial number 15 to 22.
Lords,
Page
I
number
beg
six,
to appear
number
for,
23.
Lords, I beg to appear for respondent 3 in item number 24. Your lordships may kindly have it next week itself, preferably on 21st, my lords. There's some personal inconvenience for the instructed counsel. A
Cyril,
short
have you
accommodation,
informed
my
the other
lords, till next
side?
week.
Have you informed the other side?
Please, my lords, I'll
Then
inform.
please wait till the matter reaches. Yes.
Page number 7, serial number 24 to 26.
My lord, serial number 26, ma'am. Seek a week's accommodation. Kindly on Monday, ma'am. I have informed other side.
Wait for the response. Monday, my lord. Urgent.
Monday, it is not possible to take up all the matters on Monday. List this matter on 23rd
Please.
at the request of the counsel for the appellant. Yes.
Page number 8, serial number 27 to 34. Page number 9, serial number 35 to 40.
My lord, serial number 38. I appear for appellant, my lords. Already informed the other side. I seek a week's accommodation.
Yes, at request of the counsel, the petitioner, say informed to the other side, our list the matter on 10th of February.
Please.
Page number 10, serial number 41 to 50. Page number 11, serial number 51 to 60.
My lord, serial number 54, my lord. I have informed other side, my lord. Kindly next week, any date, my lord.
Yes, at request,
Please.
date 9th of February. Yes.
Oh, bless.
Look at it in all the matters, interim order is there extra. Yes.
Page number 12, serial number 61 to 70. Page number 13, serial number 71 to 78.
Lord, 78, my lords, appear for petitioner. The respondent husband has deposited the arrears. I'll file withdrawal application, my lords. One date may be fixed, my lords. Any date in the next week. 78. The respondent husband has deposited the arrears of maintenance. I'll file withdrawal application, my lords.
It requests, does this matter on 29th of January? Yes, next.
Page number 14, serial number 79 to 81. Page number 15, serial number 82 to 85.
Please, Lordship. Serial number 82, Lordship. That pertaining to JM Police, Lordship. Parole is concerned. Already all cases are listed on 20, Lordship. This also may be pushed on 20, Lordship.
Give that number, list along with so and so on Monday, on Monday?
20, Lordship.
20th.
20.
20th along with so and so. Yes.
Number.
Give that number.
Already dated.
Yes.
Number. Page number 16, serial number 86, 87. List number 1. List number 2, serial number 1. List number 2, serial number 2, 2 to 6.
Serial number 3.
3. A Kalebute.
Yes.
List after service of
Awaited
notice.
For
Yes.
extension of interim
Interim
order.
orders.
Yes. Next.
Page number
No,
3, serial
in
number
this page, 3, then 4 also await service of notice, which in all these matters await service of notice. If the interim order is there, extend it. Yes.
On submission, my lord. See, in this case, seal number 6, my lord. In this, interim order is granted subject to deposit of 50,000 rupees, my lord. But the bank is not ready to take the deposit, my lord. I am permitted to deposit before this court, my lord.
Yes. Petition is permitted to deposit the money before the registry.
Please.
Yes, deposit the DD on before the registry. Yes.
Page number 5, serial number 8 to 12.
My lordship, serial number 8 and 9. My lordship.
Hmm.
May I seek short accommodation?
Wait, RSA is listed.
Senior is disabled, my lordship, before the honorable.
List this matter on 11th of February at the request of Land Council, the appellant. Yes. Hmm. Huh? Inform the other side.
Yes, Saudagar.
Yes, at request, after 2 weeks, it is submitted that already informed to the other side. List on 10th of March. Interim order only granted is extended. Yes.
Serial number 9 also, my lordship. 8 and 9 both. Serial number 8.
8 and 9.
Please, grateful, my lordship.
Yes.
Page number 6, serial number 13 to 15.
Number 13, my lord. 1 week time.
13.
Interim order extend. my lord. Serial number 13.
No other side.
No other.
Hmm.
Interim order extend. my lord.
Interim order only granted is extended. This is a matter on 16th of March.
Please. Serial number 15, may I mention, my lordship?
That whatever date given by me, the matters, is to keep it here. List matter, so that I'll be understanding like when, how many matters to be granted. Yes.
Serial number 15, my lordship.
Hmm.
In list number 2. May I seek accommodation, my lordship?
Same like in the other matter, 8 and 9.
Grateful, my lordship.
11.
Yes.
List number 1, serial number 1, orders matter. P. Ravi Kumar.
Wait for the petitioner, must. I request for 1 week time, the other side has filed a memo. Producing the judgment of.
Memo for dismissal of
My
petition.
lord, they have challenged the validity of the constitutionality of Domestic Violence Act. And in the meanwhile, my lord, he challenged second prayer that the compensation awarded maintenance of rupees 50,000 per month is on the higher side. But similarly, he got settled the matter before division bench in a matrimonial where he have paid crores of rupees to his wife and children. I produced that copy also.
He is appearing
So now-
representing the Union of India, mode.
Yes.
Because I challenge the constitution.
Matter, but he can bring the facts to the court.
No,
notice
no,
of the
I am
court.
not saying that.
So just for the purpose of not paying the maintenance, you question the act virus and why should the matter be pending?
No.
If that's your
Yes,
case,
sir.
why did you pay the money before the division bench?
No, because I want to settle the matter, the entire family dispute is settled, that is not that apart.
And now you want the act virus for what purpose?
Now, I challenge the constitutional validity of the Domestic Violence Act. That is the only purpose I am before this honorable court in this particular writ petition, not the main, the grievance.
No,
Yes,
validity
my-
itself is upheld 10 years back.
My learned friend has
On-
produced the memo
In which judgment?
along
I
with the
produced that,
judgment.
Page 3, my lord, in the
Page
memo.
number?
Page 3, my lord, in my memo for
That's what
disposal.
I submitted. I have to
2016-10 SEC.
go through the judgment, I will make submission.
No. Where is the question of going through the judgment when it is?
Section, it was described, 2Q was set aside, adult male person, my lords. Para 39, 40, 41 notes.
Paragraph number?
My lord, 39 onwards, at page 30, 35, my lord. The judgment leads to the result that the microscopic difference between male and female adult and non regarding being held to sought to be achieved by 2005 Act is neither real or substantial, nor does it have any rational relation to the object of the law. In fact, as per judgment so and so, the words adult male person are contrary to object afford protection to women who have suffered from domestic violence of any kind. We therefore struck down the words adult male
from the word person in section 2Q as these words discriminate between persons similar situated and far from so and so. Having struck down these two words from definition of respondent in section 2Q, the next question is whether rest of the act can be implemented without aforesaid words. That brings us to domestic so and so. After that, my lord, their lordship's last question, it was held that it was held that the other act has been continued itself, my lords. And in the first prayer of the writ petition, see that
Very same provision he has questioned.
yes, he says that this is a discrimination. It is a affect to the male member, and it is a gross violation. And the first prayer, my lord, in the writ petition, what is see? Article 14, 19, and 21 of the Constitution.
You know, the purpose is about what, for what,
Yes,
for what
and-
purpose it is filed? It was
Yes,
not-
in the second next page, my lord, I produced the copy, and at page 41, my lord. He paid substantial amount to his wife and children. Page 41, my lords, the order, division bench. It was settled. So this,
My reverend says is correct. I am not disputing it. He has produced judgment of the Honorable Supreme Court where the constitutional validity, my lord, is discussed. I will, my lord, take it next week. Lords may kindly take it on Monday. I am not seeking any more time.
No,
Just
this judgment, the judgment of the Appeals Court is not like, that was passed yesterday. When was this? 2016, 10 SCC 165.
Yes,
You filed this writ petition in the year 2021, and now you seek time to go through the judgment.
no, I will find out if any other judgment, not that's what. my lord.
That you should have done it
Yes.
before filing the writ petition
No,
and obtaining the interim order. This.
There is
he
no
has-
interim order.
He has filed it on 16/12/2025.
Yes, my lord, I am not.
This is matter. Finally, on 21st of January, no further time will be granted.
Please.
Seal number 2.
I have to find out either any subsequent judgment or this judgment is considered in the higher
the
bench.
act
not-
is being implemented, being challenged, everything is there. In fact, my lord, substantially he paid the amount in the division bench in matrimonial matter, which is I produced the copy, certified copy. So this doesn't survive for, it is abuse of the process.
That we will consider on the next 3 days.
Please.
Number 2.
My lords, I have filed a memo for wit.
Seeking to withdraw the petition, memo is taken on record and dismissed as withdrawn.
Please.
Yes, next,
Seal number 3.
give the report. Considering with the principal district and section judge Belgavi seeking extension of time. No, principal senior judge and JMFC Goka seeking extension of time. That is for another 6 months to dispose of voice number 51 of 2016. The same is considered for the reasons stated. Hence, another 6 months time is granted for disposing of voice number 51 of 2016.
Seal number 4. Case Patil.
Lords, kindly post this matter before division bench.
It is stated that the value of the appeal is more than 15 lakhs. and hence the same has to be placed before the division bench. ST is directed to list this matter before the division bench. 5.
Seal number 5.
Memo for withdrawal of the petition.
Withdraw, not pressed madam.
Memo is filed seeking to withdraw the petition as not pressed. Accordingly dismissed as withdrawn. Memo is taken on record. Next.
Till number 6.
Your Lordship, kindly have it tomorrow, Your Lordship.
Permitted, okay?
No, he says value of the appeal is more than.
Please, Your Lordship, because the execution petition has been filed, Your Lordship, so it may kindly.
One submission, my lord. I am for respondent. MFA is not maintainable. It's a commercial dispute. Award passed to the challenges as an MFA. It is not maintainable. Let it be posted before the division bench as the commercial appeal, my lord. As per Ambalal Sarabhai Enterprises.
Yes.
Number 7. Yes, Saudakar.
I appear for the cross objector in this case. IA is filed for withdrawal of amount. Case of death, Your Lordship. Till.
First of all, we are looking at first one. Notice to R5.
R5.
Process shall be paid within the period within 1 week, or else the appeal shall stand dismissed against R5. Then what do you say about IA 2 of 25? Withdrawal of amount.
Next week, ma'am.
Huh?
Next week.
They can withdraw.
Next week, my lord.
No, withdrawal of amount to next week.
Now the insurance company is before this court on what ground?
It's on quantum, Your Lordship.
Quantum.
Quantum only.
The IA number 2 of 25 is filed. Seeking withdrawal of the amount. As the insurance company is before this court questioning the quantum. IA number 2 of 25 is allowed, and the respondent is at liberty to withdraw the amount.
And in cross objection, I filed, notice may be ordered. I'll take out the notice.
So 1 in 7, the educator shall take notice on behalf of the respondent number.
All the respondent except this cross
You
objectors.
appears for the insurance company.
Yes, Your Lordship.
Only insurance company will take.
Insurance company, 2 insurance companies are there and 1 owner is there. I'll take out notice and I'll serve the copy to.
Give the file. Prop.
Except National Insurance Company.
The second respondent, Mr. So-and-so, is directed to take notice. Respond, issue notice to 1, 3.
1, 3 are claimants, Your Lordship, from 4 to others. Claimant. Yes. I'm sorry, Your Lordship.
1, 3, 4, 5.
Please.
Notice, issue notice,
Emergent notice I take out.
emergent notice. Yes, 8.
Seal number 8.
My lord, I am appearing for the petitioner, my lord. My lord, office objections for this, my lord. There is a page number 37 is blank, my lord. In the original documents also it's blank, my lord. We have produced the certified
What is
copy.
this petition?
My lord, petition is about the award passed by the Assistant Labor Commissioner, my lord, in the complaint lodged by the Labor Inspector, my lord. Annexure E is the impugned order, my lord. My lord, may I submit, my lord, facts? Facts of the case is like this, my lord. My lord, petitioner is an autonomous institution, my lord, running a medical college, my lord. My lord, they have invited tender to supply manpower on outsource basis, my lord. My lord, various posts are involved in that tender notification, my lord.
Oh, please come to the award.
On wages.
Please come to the award.
Award, please, my lord. Annexure E, my lord. Relevant
Page
portion
number?
is at, relevant portion is at
145.
Page number 164, my lord. That is the
I
operating
am on
portion of
office
the order.
objections. Please come to the award. Where is the award?
145. Your
Award
Lordship.
is at
140?
5. Your Lordship. Adesh.
87. It starts from 87.
145.
145.
Please, Your Lordship. It is in
45
Kannada,
is
Your
not
Lordship.
the award. Where it starts?
It starts from
87. 86.
87.
starts from, please, Your Lordship,
No,
67.
the office objection is, as per the impugned order, Srimati K. Kavitamma and 303 people are not made as parties to the writ petition to be clarified.
My lord, regarding this, my lord, this
Counsel
complaint was.
submission is all 303 members are not party before authority.
Please,
Case
please, ma'am.
initiated by Labor Department,
Labor
impugned
Dis-
order passed, hence not made party here.
Please, ma'am.
All of them are parties, Your Lordship. It starts from page number 67 and page number 74, it starts, Your Lordship, all the claimants, but the persons who are employed in that institution, they were the parties in this.
In the impugned order,
Page number
it
7.
is mentioned, my
No,
lord, it is the complaint lodged
Must be agreed
by
with
one
the
Mr.
limited extent of
Devdas.
this case is concerned. Huh?
Please, Your Lordship, as they have sought for a quashing of that order, Your Lordship, office is,
Their order he asked for crashing.
please, Your Lordship, they are seeking.
May I submit, my lord?
See, where
May I
is the-
submit, my lord? My lord, in
Crashing
the
the
impugned,
impugned order dated passed to the first respondent, declaring the same as illegal.
my lord, may I make one submission, my lord? The complaint was lodged initially by a person by name Mr. Devdas, claiming that he is the secretary of Vijayanagara Vaidyakiya Vignana Samsthe, Guttigedarara Naukarara Sangha. There is no such organization recognized by the institution, my lord. He has lodged the complaint before the inspector, labor inspector, my lord. In turn, labor inspector has filed a claim petition before the assistant commissioner of labor, my lord.
Who are
Therefore,
the,
my lord,
who are the
all
beneficiaries of this order?
other parties are not required, my lord.
No, who
Please,
are the
ma'am.
beneficiaries of this order? If this order is set aside, who are the affected parties?
The beneficiaries, the details of that is what my case is, my lord. There are only 116 laborers working. In this case, they have made 309 candidates. The details, because it is outsourced employees claim, my lord. We have given it on contract, rates are fixed on the basis of government orders.
No,
My lord,
whom you made the parties? You have not made anybody parties except
No,
the
my lord,
official
only the
respondents.
official respondents, my lord, because this is the claim petition filed by the labor inspector.
No, that is true. The query of the court is, if the order, the prayer as sought by you is granted, who are
Please.
the affected parties?
My lord, in turn, my lord,
And without
the
notice to
laborers
them,
are,
without
but they are
notice
not
to
the
them,
actual
we
laborers.
cannot.
They are not the laborers working in this institution, my lord.
No,
They
if
are-
this order is set aside, what will happen?
My lord, the third respondent is the contractor, my lord. He is the private respondent to whom we have given the contract. Now, my lord, the only ground in this case is, my lord, without providing proper opportunity to the institution, my lord, this is during the COVID period, my lord, the administrator of the institution has appeared before the authorities. He has made his submissions. In the meanwhile, my lord, he has expired. And no further notices are issued by the labor office to the institution. Because of that, my lord,
All this is
though, and we have requested
Is this
while
matter-
annexure F, my lord, to review the order.
Is this matter for the other court? You are obtaining the registry orders from non-bill judges. Yes.
Please.
Seal number 9. Creation new open.
Date may be fixed, my lord.
Madali.
Now the
Yes.
execution of
It will
the
come.
Seal number 9.
award.
Last occasion I submitted with regard to office objection at serial number 3. Since the order is passed by the Work Tribunal, Lord Kalburgi, so this writ petition is not maintainable is the office objection, my lord. Since the property is situated within the jurisdiction of this honorable court, that is Koppala, The petitioner is from Koppala. So the property has been declared as a work property, which is situated within this jurisdiction, my lord. So the writ petition is maintainable, is my submission.
My lord, last time it submitted, but the petition is maintainable according to us also.
So, all the matters pertaining to Dharwad and all, the tribunal would be there in, where it would be Kalburgi.
Yes, my lord. In respect of Belgaum Works Tribunal, though, my lord, Bijapur is included in the work tribunal, since Bijapur comes under the jurisdiction of work tribunal Belgavi, the writ is applicable to Kalburgi bench because it is a property situated at Bijapur. So,
How come the jurisdiction is no, for all the districts, it should be within the
that is the wrong.
jurisdiction of the Dharwad.
Even Ballari is included in Lord the Kalburgi bench.
So where from, let's look at the work fact.
Please.
No, the order is passed by bench. That comes within the jurisdiction of a particular bench, High Court bench. So why should we again fall back on where is the property situated?
Or otherwise, it may be disposed of statistical purpose. It may be transferred to Kalburgi bench. We have no objection.
The present
Senior counsel is there.
Yes.
No, this is an office objection. Your lordship is transferred to Gulbarga bench. All our contentions can be kept open there itself.
Then comes for the office objection regard to maintainability. This order by the work tribunal at Kalburgi, and writ petition lies to the bench.
Appeal lies.
Appeal lies to the bench at High Court bench. Counsel's office. Property is situated in Dharwad.
Koppal.
This court is having jurisdiction. Considering the fact that the order passed by the work tribunal is within the jurisdiction of Kalburgi bench. The appeal lies to the bench at Kalburgi. According the MFA is for the statistical purposes disposed of.
Can I make one submission to your lordship's kind consideration?
Registry may be directed to transfer forthwith. Regarding registry may be directed to transfer the file forthwith because we have sought for the interim order.
This the very maintainability of miscellaneous first appeal is
We have filed an appeal for that. That your lordship may say that all contentions are left open.
This may be posted for
maintainability of against order passed by the.
Please.
Seal number 10. Adiraj. You are the Sinanda Pachapure.
I'm appearing for the petitioner, my lord. Proxy counsel. R2 is dead, passed away. There are lots already on record.
Where did you say so? Where is the memo in that regard?
We have filed a memo, my lord. R3 and R3 to R7 are already on record. The council is held up in
He's seeking dispensation of notice.
Yes, please, memo is not served, my lord, but however, he is not contesting.
Memo, I'm not able to understand that.
He is not contesting party. Only, my lord, I am respondent one is the contesting party.
Yes.
The memo is filed seeking dispensation of notice to R2. Memo is taken on record and notice to R2 is dispensed with.
Lordship, there.
Short date may be granted.
Execution proceedings have been.
On 9th of February.
Lordship, short date may be. Execution proceedings tall, my lord.
Not possible.
2006 suit, my lord, the suit.
11. We will see. Yes, 11. List after service of notice.
Harshvardhan Goda Patil.
As far as R2 and R4 are concerned, within a week, default order. Yes, 12.
R3 and R4, I have filed dispensation memo, my
It is a
lord.
memo.
They are the guarantors, hence.
Memo is filed. It's there. Seeking dispensation of notice to R2 to R4, dispense with at the risk of appellant. List after service of notice to R1. Yes, 12.
Seal number 12.
Filed and I had to recall the order dated 10/2/2018. The dispensation.
Why should an order of 18/10/2022 be recalled now?
No, by oversight, I submitted to dispense a notice to R1, my lord, but it is liability is in question. Therefore, set aside the order and issue notice, my lord. By mistake, I submitted by notice to R1 dispense because the claim petition dismissed on the ground that claim petition 163A.
Insurance company can't be so casual.
Sorry, ma'am.
It's by private party. It's by owner of the vehicle.
Yes, R1 is owner of the vehicle.
And
R2 is insurance company already appeared, my lord.
I appeared for the respondent number 2.
a memo, an order was passed on 18/10/2022 basing on the memo filed by the petitioner seeking dispensation of notice to R1. R1 is the
owner of the vehicle.
R1 is the owner of the vehicle. As now the IA is filed, recalling the order dated 8/10/2022. It is submitted that by oversight, a memo is filed seeking dispensation of notice, considering the submission of the land counsel to the petitioner, and as the respondent number 1 is a necessary party to this petition, and number 1/26 is ordered, and the order dated 18/10/2022 is recalled. Issue emergent notice.
Please. Much
to the respondent. Yes.
Number 13. Jagdish Patil.
Lord, there is a delay of 253 days in filing the
This is recalling the order.
My lord, it was dismissed for non-prosecution, my lords, for non-compliance of office objection. If my lords permit, in a week, I'll comply with the office objection, my lords. They have already paid the court fee.
When is this IA filed?
IA is filed on 27/8/2024.
And you have not pursued it till now.
Please, now they have paid the court fee, my lords.
For that
2,43,000.
purpose, you are waiting. So that you will get the
Because
money.
the
you will
main
pay the
objection
court
is
fee.
of court fee, my lords.
And it can't be, these kind of inordinate delays can't be condoned. How many days?
253 days. 250.
Pending this IA number, IS 1, IA number 1, the appellant shall comply with the office objections. Once office objections are complied, list the matter.
1 week time may be fixed, my lords. I'll comply with
Never
it.
you comply.
Please.
Yes, 14.
Seal number 14.
May I please, my lady? Yeah, IA 2/23, they are seeking condonation of delay. That is within the permissible condonable limit. We have no objections.
I number 2/23 is filed to condone the delay of 53 days in filing for the reasons. The respondents have no objection. For the reasons stated, the delay is condoned. Next, IA number 1/25.
IA 1/25, we are seeking withdrawal of the deposit they have made.
IA
And
number 1/25.
to consider IA 1, there is IA 2 that needs to be considered simultaneously. IA 2, we are seeking correction in the name. The cause title says Vijay Kumar, but my record says Vijay.
No, that is not the problem of the appellant, isn't it? Whatever is there in the award, that will be there.
Exactly.
Why-
Award,
You have to see correction of the award, not in this.
my lords, what happens generally is they locally call me Vijay Kumar, but my records say Vijay. And also there is a correction of residential address.
And the award needs to be corrected, not this order or the cost title here. So unless and until you see correction of the award, we can't do it now.
And also they have acknowledged that I have received the earlier compensation. They have issued a letter that that's the same person.
It will create unnecessary complications. We cannot do like that. The award needs to be corrected.
My lady, that complication, if I have lost the land and I should wait for all these procedure to complete to receive the.
It is a procedure, of course. We can't
They
go
have paid. They have paid. The SLO had paid the.
You take, but we will not say that just like that Your name will be corrected in the here in this cost title.
But the compensation is lying with the execution code. The first award they have paid to me, now the 50% is lying with the execution code. The records I have adduced that shows that I am Vijay,
That I will not do.
that Vijay Kumar flows from nowhere.
That has to be done in a systematic manner, not like just like this. IA 1 of 25 is filed seeking withdrawal of the deposited amount filed by the deposited by the petitioner. Accordingly, the learned counsel for the appellant submits that he has no objection. Accordingly, I number 1 of 25 is ordered and permitting the respondent to withdraw the money. I number 2 of 25 is filed seeking amendment of the name of R3.
Please.
It is stated that earlier,
This honorable court earlier directed me to produce some documents.
to amend the name of R3 filed with the name of R3, it is stated that his name is Vijay.
Yes.
It is shown as Vijay Kumar. In fact, the amounts are paid to him. If anything that is mentioned in the award, the name is not properly mentioned. It is for the petitioner, for the party to seek to file an amendment petition and to get the clarification in the award. But this court cannot do all that exercise. If already, with that name, if the respondents have already filed, had paid the amount, it would not come in the, as well, this amount also, it would be permitted to withdraw.
Grateful. Great. 15 also that delay may be condoned. In 15 also they are seeking condonation of delay. They are within the limit.
SIA number 2 of 23 to condone the delay of 53 days. Same. Yes, next 16.
Much obliged.
Seal number 16.
Notice.
Madan Mohan Kannur. Notice.
Who appears in 16?
16. Kannur.
Yes. My lord, it's a corporation appeal, my lord, and the challenging the liability and the contempt award, madam. It is a
On
nature
what
of,
ground the liability is questioned?
It's a nature of injury, my lord, and it's a nature of injury, my lord. There is a delay of 8 days filing the appeal, my lord, and they all already filed an EP, my lord. My lord, I requested for stay, my lord.
There are two issues here. One is quantum and one is the liability. You are saying liability. What is the ground? If it is only quantum, we will permit them to withdraw. If it is liability, I'll not pass such order. So you have to say on what ground you are before this court. What is that liability?
My lord, liability is mainly on the buster.
You are only on the ground of quantum, not liability. The insurance company is before this court questioning the quantum. Learned counsel appearing for the insurance company submits that the court has taken the disability at 11.66% and the income at 13,250, which is on the higher side. Considering the submission, they shall be stay 50% 4 weeks. On such deposit, the respondents are at liberty to withdraw. Next.
Seal number 17. Gita claim.
Number 1 of 25 is filed to condone the delay of 26 days in filing the appeal for the reasons stated. Delay is condoned. Admit final hearing is here. Next 18.
This is claimant appeal.
Number 18.
Records are necessary.
Is here.
Yes, 18.
Seal number 18. Appellant.
Yes.
I have filed two applications. IA number 1 for condonation of delay of.
No, what is an MFA of 2024 till now without even hearing an IA for stay?
Pardon?
No, I'm saying you didn't even press for the stay from 2024.
I have challenged the order only in MEC number 52. 53 I am not challenging. 53 because a small amount is involved.
No. It's an appeal of 2024.
I have explained the delay in my affidavit.
What is the reason for the delay?
Reason in para 5 of my affidavit I have explained. On page 58.
And one more thing is delay is 808 days. Appeal is filed in the year 2024. We are in 2026 now.
Well, earlier, it was the order dated 21/7/2025 may kindly be perused. Order of this court,
21?
21/7/2025. It was earlier, it was dismissed for non-prosecution. And again, I had filed an application for restoration.
I think insurance company doesn't deserve any interference in this case. Notice to the respondent.
And I have prayed for a stay.
Not entitled. Yes, 19.
Number 19.
Claimant's appeal for enhancement. There is 594 days delay, my lord.
On condition?
Interest may be over.
That's what. I number 1 of 2024 is filed to condone the delay of 594 days. Reason stated, condone on condition that they will not be entitled for interest for set period. It's a case of death or injury.
Injury, my lord.
Injury.
Injury.
Yes, call for the records. Admit. Course for final hearing, call for the records.
Please.
20.
Seal number 20.
Please like to appear for the appellate. My lord, seeking for enhancement of compensation and pay and recovery, my lord, has to be ordered. And this why, my lord, I have filed an early hearing application.
No, nobody appears. Who is
Next, Kayak Mati is appearing.
I am appearing for the respondent insurance company.
Are you ready?
Yes, madam.
Yes.
My lord, in death, my lord, age of 55 years, the tribunal has awarded a compensation, my lord, of rupees 14 lakhs, my lord, 56,260.
Accident which year?
Only accident, my lord, that is
2021
notional income has been taken, is correct. Only that is correct. So far, in two heads, my lord, love and affection, my lord, there are two sons are there.
No, 1 minute, come to the table.
Yes, your lordship, kindly page number 29.
As far as loss of dependency is concerned, there is no dispute.
Yes, my lord.
13,86,264. Then consortium.
My lord, 40,000 is awarded to the wife.
Two sons.
Two sons. So 48 has to be awarded.
Let's see who are the claimants.
My lord, your 47 years,
So,
Sambhava.
consortium. 3 into
48.
3 into 44.
Yes, my lord.
It comes to 1,32,000.
And my lord,
36,000 funeral expenses.
yes, my lord. Yes.
That's it.
Yes, my lord, liability has to fix the pay and recovery, my lord.
That we will go to.
Yes, please.
It comes to 15,64,264. Then where is the liability?
Liability, your lordship, kindly take the judgment.
Para 16 minutes.
No
16.
license, my lord, that is,
Please read.
my lord, the respond to contention, examined advocate so-and-so, company R111, mark so-and-so IO, services, which is marked exhibit R3, also produced reply given by the respond number 1 so-and-so. Clearly shows that the respond 1 admitted that the driver was not having a driving license at the time of accident. IO has also filed a charge sheet against the respond number 5. These documents disclose
Please
that.
come. Agreed with award passed in MSC number 275 of 2022 dated 24 June 2024 by so and so. The claimant is before this court seeking seeking enhancement of the compensation and also questioning the liability fixed on the owner of the vehicle. The claim petition is filed seeking compensation for the death of the deceased in the motor vehicle accident that took place on 13/8/2021. The tribunal has granted the compensation as per the table given below at paragraph number 20. Land counsel appearing for the claimant submits that as far as the loss of dependency is concerned, the tribunal has rightly granted the compensation. However, when it comes to the loss of consortium funeral expenses, the compensation that is awarded by the tribunal is not just and reasonable. It is submitted that the liability is fixed on the owner of the vehicle on the ground that there is no driving license. It is submitted that in the light of the settled law, in the light of the law laid down with the Honorable Apex Court in Saransing's case, though there is no valid driving license to the driver of the offending vehicle, still the principle of pay and recover will apply, and the insurance company is liable to pay the compensation and record the same from the owner of the vehicle. Next, for land counsel appearing for the respondent insurance company submits that the tribunal has rightly granted the compensation and also held that the owner alone is liable to pay the compensation, and there are no grounds to interfere in the with the award passed by the tribunal. Next part. Though notice is served on the owner of the vehicle, no representation, no wakalat is filed on his behalf. Next. Having heard the counsels on either side, peruse the material on record. First, coming to the aspect of liability, considering the judgment of the Honorable Apex Court in Saransing's case, and by applying the principle of pay and recover, this court holds that the insurance company is liable to pay the compensation and record the same from the owner of the vehicle. Then coming to the compensation, there is no dispute on the loss of dependency. Due to the consortium dependents, there are 3 dependents, 3 into 44, that is 2 sons and wife, 3 into 44, 1,32,000, and funeral expenses 36,000. In the light of the law laid down in Mekala or so and so, legal expenses 10,000. Altogether, the claimants are entitled for an amount of rupees 15,64,264. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 14,56,264 to 15,64,264. The enhanced amount shall carry 6%. The insurance company shall pay and record the same from the owner of the vehicle.
Please.
Yes.
21. P. Reddy. Reshma Madiwala.
Next week.
Who appears for this SBI General Insurance Company? Panel counsel.
SBI General Insurance Company.
You appear. So and so is directed to take notice on behalf of the insurance company and counsel for the appellant shall serve the copy of the appeal memo on the counsel. This is matter on 3rd of February. Yes, next.
Still number 22.
Lordship's beneficiaries appeal minutes challenging enhanced compensation.
Yes.
There was delay, Millards. Notice was issued. The respondents have been served, Millards. They're not represented through any advocate.
The delay?
Delay. It is new act, Your Lordship.
That's why.
New act, it will not condone, Your Lordship. What is the delay, Your Lordship?
Was it decided by the Supreme Court?
Not yet, Your Lordship. It is
I think because
pending.
of this, in all the matters,
Please,
some
Your
orders were passed, if I remember last time also.
Please, Your Lordship, those appeals were dismissed, Your Lordship, which were filed after a delay, Your Lordship. But as matter is pending before the Honorable Supreme
That's why, because the matter is pending in some matters, if I remember, in view of the division bench has dismissed.
Please, Your Lordship,
All
all appeals were dismissed. Please, Your
So
Lordship.
then how do we condone
No,
that?
those dismissed Millards, they were appealed against. And those appeals are pending before the Honorable Apex Court now. That issue is not yet decided, Millards.
What is done now? We'll dismiss this also. You also have to go before the.
Thereafter, Millards, that has been stayed. So the dismissed appeals, Millards.
Yes, adjourn this matter. For list in the month of March. Yes, 23.
23. 3 schedule open.
Not big to
Shall
appear
I
for
start
me.
there?
My lord, pertains to overlapping of the 2 cooperative societies in one area, my lord. Lord, the matter came up before this honorable court, and since the similar matter, my lord, have been referred to full bench with regard to whether what is the locus standi to question of the another cooperative society for establishment of another cooperative society in that area. Since the matter has been referred to full bench, my lord, this matter was heard and the respondent was also heard, and a rule has been issued, my lord. After rule having been issued, my lord, they raised, my lord, the locus standi of the present appellant being the president of the cooperative society to question the issue, my lord. Lord, since he questioned the locus standi of the president, we filed an interim application seeking impleadment of the secretary chief executive officer on behalf of the, my lord, the society. My lord, they preferred a writ appeal, my lord. Though, my lord, the locus standi was considered by the dishonorable court, they preferred a writ appeal. In the writ appeal, my lord, an order has been passed saying that since, my lord, it touches the very root of the, Lord, the jurisdiction of the court, locus standi of the petitioner, my lord, the division bench of this honorable court has directed, my lord, to consider, my lord, both the, my lord, the stand taken by the respondent with regard to the locus standi of the petitioner, and as well as, my lord, the application filed by the petitioner, that is chief executive officer, the secretary, to represent on behalf of the petitioner, my lord.
So the matter is remanded.
Yes.
It is the only point.
I have filed memo.
What do you have to say on that?
Lord, now, anyway, we have filed an application for impleading, Lord Secretary as a party to the petition, my lord. So their, Lord, stand is met by filing an application, my lord. Even we have got, Lord, authorities to say that the even president can, Lord, the maintain the very writ petition. He can be sued on behalf of the society.
What is this vacate petition?
Please.
What is the vacate that is a stay that is granted?
No, the Learned Singh division bench observed that first locus standi has to be heard. Not we are ready for, he filed an application for impleading.
No, it's a simple technical one. The society has to be represented by the
board.
And so,
yes.
So according to you, president cannot represent it.
Yes.
So that has been clear. That is a defect which can be
cured.
Which is
No, it is not cured. The application is filed. We have filed an objection. Your lords may hear the application for impleading as well as the locus of the petitioners. We are ready for the argument. This is only covered by decision of this honorable court. Locus has been considered by this honorable court. Two coordinate benches have held that the president has no jurisdiction.
No, we say that president has no locus.
Then
that is
whether the application filed by the individual person is maintainable, whether it can be treated as representing the society, you lords has to consider this aspect of the matter. That's the only point.
No. In the light of the implead petition that is filed, and they also accept that it is represented, it will be represented by the chief executive officer or whosoever is a competent person, then there is nothing to be questioned. We can say that president cannot maintain the petition.
Yes, my lord, you also kindly see, application filed by him, we have filed an objection. You lords may consider this aspect of the matter.
Let's see.
Please.
Where is the application?
Please. We have filed a detailed objection to that application also. But so far as my case is concerned, my lord, 22, my lord, before that, my lord, 23.3 already disposed of, my lord. 23.3, the petitioners have withdrawn the writ petition, but wrongly it was, my lord, listed.
Which one?
23.3.
3.
Not, I will furnishing, my lord, the hard copy.
Take that.
It was already not, they have withdrawn the petition.
23, that is WP number 10607 of 2024 was dismissed as withdrawn on 19th December 2025. Yes.
Lord, no, I have, Lord, kindly take 23.2. Lord, I am appearing for the response.
23.2.
Lord.
Take 23.
Lord, so far as locus is, my lord, concerned, my lord, the statement of objection, para number 2, Lord, I'll permit it to it, my lord. Statement of objection, my lord, para number 2 regarding maintainability of the writ petition.
Paragraph number?
Paragraph number 2, my lord. 2.1, it starts, my lord. Lord, may I read, my lord, this? The present petition filed by the petitioner is not maintainable either in law or in fact. The chairman, president of the society has no locus standi or authority to file a writ petition by representing the society, that either under the statute or under the bylaw of the society, the chairman or the president of the society has no power or authority either to sue or to be sued in the court of law for and on behalf of the society. That the provisions of under section 29G4J provides that the chief executive of the society is having a power either to sue or to be sued on behalf of the society. That part 8 of the bylaw, number 30 of the bylaw, the petitioner society provides a power of the chief executive to file case. Further, bylaw number 23 deals with the powers of the chairman. It does not provide any power to the chairman to file the cases on behalf of the society or to represent the society. Therefore, the writ petition filed by the chairman representing the society is a defective without authority of law. Hence, the present writ petition is liable to be dismissed with the cost. Under the provisions of the Act, the chairman has no power to institute any suit or defend the case to represent the society. In view of the provisions of the Act rules by law, the society, the present writ petition, though chairman is not maintainable on the ground, the present writ petition.
I have seen that. Now you're taking two grounds. One is the alternative remedy and the
Yes.
one is the
Yes, ma'am.
maintainability of the.
Now he filed an application. Now he filed an application. One of the person filed an application.
Yes.
The
Let's see that impleading
application filed by, my lord, please.
Yes.
The, my lord, dated 18/6/25.
Yes.
My lord, para 2, page 2, for the reasons stated in the accompanying affidavit, it is most suitable submitted to the Honorable Court. Please kindly be pleased to permit the following person applicant soon. The details of the proposed petitioner number 2 as under Guru Shantaya Sangaya Hiremat. ये जो occupation, the cause title, the individual person wants to come on record, but it is not amounts to rectifying the defects representing the society. This is my the primary contention. The representation to be made like
To paragraph number, this page number 2 of that implead petition, details of the
proposed petitioner number 2, Guru Shantaya Sangaya Hiremat. But it is an individual name. The impleading application must be such that the primary
the petitioner's
yes, my lord. Petitioner is my lord, like petitioner.
Society's name is.
Society's name is Prathamika Krishi Patina Sahakari Sangha Niyamita Hiparigi, represented by the application to be the Prathamika Krishi Patina Sahakari Sangha Niyamita represented by its chief executive. The individual person, he can't the represent the society. 1, 2, any person wants to file a writ petition, there must be authorization.
Before you go to the next point, this is, if you look at the details of the proposed petitioner, it is so and so.
Individual name, secretary's individual name is not a cure the defect. The application must be Prathamika Krishi Patina Sahakari Sangha Niyamita represented by its chief executive. If it is done, then it is rectified. If it is individual name, then individual person, he can't be a represent as a representing the society. Let me kindly say Guru Shantaya Sangaya Hiremat. This name is an individual person.
No, I didn't get your submission.
My lord,
He says so and so society represented by so and so.
Yes, ma'am.
Where is the individual person here?
Here the proposed person's name, you asked me kindly see proposed person's name. Page number 2, application for impleading, my lord. My lord got it, man. Page number 2. Application for impleading. Details of the proposed petitioner number 2. Guru Shantaya Sangaya Hiremat, age 50, occupation so and so. But this cause title, it will not cure the defects of representing the society.
Are you reading this?
Yes, my lord.
This is the proposed party.
Yes.
Proposed party is a society represented by the secretary.
No, he has not.
Give it to him.
My lord, the copy has been served. without, my lord, the correcting, and when it was corrected, there is no signature, your lordship may kindly
But how
note
can you
this
show
one.
papers like that to the other
No,
side?
no,
Is-
they are
my lord,
not.
what has happened is, my
There
lord,
is no signature, my lord, after
before-
filing a objection, after filing a objection, it was not incorporated, this is
before filing, my lord, we will serve the copy, my lord. Once office raises objection, we make corrections.
my main objection in the objection statement to this application is like this. Now, after filing my objection, they might be, my lord, rectified this one, corrected. But my objection statement, you lords may kindly see. Objection, what I have stated that the name,
The copy that is served on you.
based on this, I have filed an objections contending that Sangaya, the individual name.
How can it be like this?
Lord,
If it is, you should serve him the copy after the objection, after you have, whatever the corrections you have made. And now he is, he argues on his own.
I apologize, my lord, because what we do is, my lord, before filing, Xerox copy will serve, my lord.
My lord, with great
Thereafter-
respect, I will make submission. I have filed an objection. He ought to have rectified or file a rejoinder to that. They have kept mum. My lord, my objection statement, you lords may kindly see. For a moment, first para itself I stated, the name, person, individual, my lord, it is not the rectify the defect, cure the defect. Therefore,
When we have stated that the occupation is secretary Prathamika Shikshana,
What did you say?
Lord, occupation, my lord.
That's not the way the society will be represented.
It's a, my lord, a clerical mistake, my lord.
How can it be? First time I can understand it's a mistake by the president. When they are taking a specific objection, are you not supposed to be careful in filing the implead petition? Because society has to be represented by so and so.
this issue has been not covered by two decision coordinated.
That's true, but what you have to be on the merits of the matter. This technicality, which can always be cured now by this, what you have seen from that, he has said so. This is fine. I think that.
No, not, your lords may, my objection statement, your lords may kindly see, I'll read more of the objection statement, how I state.
I'll rejoin to his objections. The land counsel for the respondent submits that the writ petition is filed. Now the implead petition is filed by the individual, but not the, but not representing the society. The office copy, that is the court copy, shows that it is represented, so society represented by the secretary, but the copy that is served to the respondent is only shows the name of the individual.
Yes.
Basing on that, the respondent has filed his objections. Land counsel submits that when the office has raised the objection, they have filed, they have corrected the same. The
No, your lords, sorry, man. They are not, office raise, thereafter they are not corrected.
After office raising of objection?
No, office was not raised. It is I have raised the objection. Office never raised the objection. Office.
Now they have corrected the copy.
No, without court permission, they can't, interpret.
They have corrected the copy. Instead of that, I'll say them, I will ask them to file a fresh petition.
Yes, let them file a fresh petition.
Shall clarify the same and shall file the rejoinder to the objections that are filed by the respondent. Yes, this is matter on 18th of February. Yes, next.
18th.
Whereas in serial number 24, I appear for the respondent number 3 company. We shall be filing our objections today itself, my lords, over the counter. Your lordships may kindly have it next week itself.
It's only 36 days delay. No counter is required. I number 105 is filed to Karnataka.
Submission, ma'am.
36 days in file.
My lord, I am appearing for the appellant. I have a submission to be made, ma'am.
Submission ಮಾಡಿ sir.
Yes. My lord, I have deposited the compensation amount. In the month of May, my lord, the claimants must have already taken the amount. There was no stay, my lord. Stay was not granted. So, kindly consider the merits and dispose of this matter, my lord.
No, it is not possible. I number 1 of 25 is filed to count on the delay of 36
Because I
days
am submitting,
in
my lord,
filing
that
delay.
it deserves to be dismissed, your lordship.
It has to be dismissed.
It deserves to be dismissed. Little merits are there, my lord, I will submit. Because it has
We will
become
see.
Your lordship
of
may have it
academic,
next week itself, my lord.
academic interest
This
only,
is
my lord.
matter. This is matter on 28.
28.
Yes, 25.
Seal number
Please, ma'am.
25. Subhash.
Sir, insurance company has challenged the negligence in connected material stays is granted. In this case, my lord, that the vehicle, the petitioner was parked his car in the middle of the road and he slept on the front of the car. At 2:30, he was parked.
Case of death or injury,
It was injury.
the land counsel for the insurance company submits that there is contributory negligence on the part of the claimant which was not considered by
The
the.
contributor, entire negligence we have challenged.
It is submitted that there is entire negligence is on the part of the claimant, but the same was not considered by the court. Considering the same, there shall be stay of all further proceedings, 50%. No permission to withdraw. Notice to the respondent. Yes, next.
Please.
Seal number 26 urgent. Seal number 27. IC Patil.
See, corporation appeal is a case of injury. We are challenging liability and quantum of compensation.
Liability on what ground?
Liability is he was traveling on footboard of the bus. Negligence is fell down from the bus. At least the honorable tribunal have to have taken contributory negligence.
That is land counsel submits that the claimant was traveling on the footboard of the bus.
Footboard.
There is negligence on the part of the claimant which was not considered by the court. Same, stay 50%, no permission to withdraw. Next notice. Then 28.
Seal number 28.
Stay granted. Please.
Stay. 50%.
My lords, appeal by insurance company, my lords, channeling liability, my lords, on the ground that, my lords, the rider of the offending vehicle, my lords, was not having any DL to drive the vehicle, my lords, and moreover.
Date of accident.
Pardon, my lords?
Date of accident.
12/8/2021, my lords.
For amendment.
Please, my lords. My lords, moreover, my lords, he was intoxicated while driving the vehicle, my lords.
Insurance company, it is submitted that they're questioning the liability and the driver of the offending vehicle is not having a valid driving license. Considering the submission, 50%, 4 weeks. On such deposit, they are entitled to withdraw.
Obliged.
Yes, 29.
Seal number 29. Holy what?
Lord, insurance company appeal, madam, challenging the liability, madam. As on date of accident, the rider of motorcycle had no DL, my lord. Even charge sheet is filed section.
Date of the accident.
2014, my lord.
2014,
my lord. 27/2/2014.
In that case, still pay and recovery will apply.
But nothing, pain recovery is not done, my lord. Even
It's a case of death or injury.
injury case, my lord.
How much is,
My lord, his employment service
how
here.
much is granted?
1,50,000, my lord. There, my
The same, it is submitted that there is no DL. It's a EC case, not a EC case.
not, my lord.
It is submitted that the driver of the offending vehicle was not having a valid driving license. And the tribunal has failed to apply the principle of pay and recover. Considering the same, they shall be stayed on the condition that the petitioner, the appellant shall deposit the entire amount within a period of 4 weeks. On such deposit,
Before tribunal, tribunal will deposit.
There, wherever you want.
Please,
On such
please,
deposit, the respondents are at liberty to withdraw 50% of the amount. Notice to the respondent.
Please.
Seal number 30. GN
I appeal to the appellant.
My lord, I am for the appellant in this case. And the appeal is filed challenging the negligence because my vehicle has parked in the good manner, but whole liability has been fixed on us and also on quantum, my lord.
Case of death or injury?
Injury, my lord, in the case of injury.
It is submitted that there is contributory negligence on the part of the claimant which was not considered the record. Same 50%, 4 weeks, permission to withdraw. Notice. Yes, 31.
Seal number 31. Rajshekar.
Please, my lord. Impugned order is passed by presiding officer in the tribunal, my lord. There is a delay in filing of the appeal, my lord. 721 days. Emergency notice may be issued, my lord.
Urgent notice.
Please, my lord.
Yes.
Admission matter. Seal number 32.
It is injury case, my lord.
Pachapati.
It is injury case. My lord.
Why 2021 appeals also notice not
In
issued
the
till now?
connected two cases were already stayed, and here in this case the EP is not filed. Not madam. That the matter is not listed.
EP is not filed, you will not seek
No,
stay.
that matter is not listed. Twice we have moved the matter, but the matter is not listed.
We will not grant stay in these matters. Notice to the respondent.
Notice.
Issue notice.
33. Issue emergent notice.
Issue emergent notice.
My lords, it's a ECA matter, my lords. 33, we have deposited the entire award amount, my lords.
Notice to the respondents. 34.
Emergent.
34 also notice.
34.
Notice.
In 34, my lord,
Notice.
have deposited the already entire award amount.
Notice 34.
If it is, my lord, they have withdrawn, my lord.
Let them
My
withdraw.
lord, it
What
will
are you
affect
doing
us,
for
my lord.
22?
34 notice.
Yes, 35.
Seal number 35.
Notice.
Lord, already notice has been served. My lord, in the 35, my lord, I am appearing for the appellant in the connected appeal. Connected appeal filed by the corporation challenging the negligence and quantum, and the claimant also filed the appeal. In the first matter, my lord, 35.
What is this extension of interim order?
My lord, this honorable court, my lord, initially granted, my lord, 4 weeks to deposit the 50% of the award amount. Due to scarcity of fund, my lord, the corporation has not deposited the amount. Subsequently, it has been deposited. That's why, my lord, the trial court, my lord, they have filed execution petition and pressing for the withdrawal of the amount, my lord. That's why, my lord, I have filed the application for extension of interim order granted by this honorable court in the earlier on 18/7/2022.
What is that extension of time for depositing the amount?
Please, I have already deposited, my lord.
Line number 1 of 23 is filed seeking extension of time for depositing the amount earlier by order dated, which is the order?
18/7/2022.
18/7.
2022.
18/7/2022, an order was passed directing the appellant to deposit the amount. Within a period of 4 weeks, they could not deposit the amount within 4 weeks. Later, they have deposited. For that, this IA is filed. Accordingly, IA is ordered. Yes, admit final hearing, call for the TCR.
TCR already received.
It's there. Yes,
Please.
post for final hearing. Yes, 36.
Bill number 36. Very good. Okay, for the appellant. Preeti Shashank.
The claimant appeal, my lord, case of minor death.
Case of?
Minor death, my lord. The appellant is, my lord, the father of the deceased boy. And my third respondent, my lord, the maternal grandmother of the, my lord, the deceased boy. The trial court, my lord, awarded 50% to the, my lord, the appellant, 50% to the grandmother.
No,
That
no.
is challenge.
Who is come to the cause title of?
Please. The present appellant is a father of the, my lord, deceased Gursuddaya.
No. Come to page number 6. There are so many MVCs. Which MVC?
Please, 2297.
22?
97.
2297.
Please.
Filed by whom?
Please.
Filed by?
Filed by father of the petitioner.
Father of the petitioner.
Father of the deceased.
Father of the deceased. Then 3 is?
3 is filed impleading application to that
That is Sri Shanur.
Civilila.
Shanur, so and so.
Please.
Respondent in MVC number. No, something is wrong with this.
Not the 2297 filed by the present appellant. The third respondent also filed a claim petition on 1653.
1653. Who is the third respondent?
Third respondent, the maternal grandmother of the deceased. The great grandmother.
No, this person has no wife.
No wife. Wife already deceased.
Probably grandmother is taking care of the child.
Please.
Probably grandmother is taking care of the child after
The
death of
maternal
his
grandmother.
mother. Huh?
Maternal grandmother.
That's what I'm saying. Maternal
Mother, the-
grandmother after the death
Please.
of the mother must be taking care of the child.
Child in care of the appellant.
Where is the finding with regard to this?
Please.
Come to that.
Page 30.
They have not preferred any appeal.
Please.
They have not preferred any appeal. Notice is served to them.
Not sir. He appeared, my lord, the advocate.
Who appeared by advocate?
Prashant is appeared.
Preeti Shashank.
Preeti Shashank is insurance company.
madam.
That's insurance company. Prashant.
Prashant. Respondent number 3.
Prashant Matpati.
Bill number 36. Prashant.
Heard counsels in part. No representation on behalf of respondent number 3. Mrs. Matter on 2nd of February.
The interim order may be.
Interim order, only grant. What is the interim order in this?
Interim order in apportionment of payment is concerned.
Interim order, only granted is extended till then. Next.
Seal number 37, Harish S. Maigur,
My lords, it is a ECA claim.
Agrassi Kalluri.
So disability, my lords, for more than 100%. My lords, tribunal has, commissioner has taken 80% to the limb. So, my lords, my only contention is about the disability. So I am relying upon the judgment of the two honorable judgment of the apex court, my lords. So wherein he was a driver, my lords, the apex court has taken, my lords,
Functional disability.
100%.
That's what I'm saying. Functional disability, 100%
Yes,
will
yes,
be taken. What do you say?
My lord, as per the WC, my lord, the schedule, as per the schedule, the injury is amputation below knee. As per the WC Act, item number 19 and
No, in
20
the
and 21.
ECA, what has
Photographs.
been taken under that? No,
My
the
lord.
judgment you are relying on is arising under the Motor Vehicles Act or the?
No, EC Act,
Take that.
please. Here, in case of 50% disability, consider 100. And I have produced also photographs, exhibit P. It shows above knee, my lords.
Which is this judgment?
My lords,
DK
2008
cases.
judgment.
Where is that?
My lords, may kindly turn to, my lords, para number 5, my lords.
Yes,
I am sorry, my lords are reading 2008 judgment or 10.
I'm looking at this S. Suresh and Oriental Insurance Company.
Before that, my lords, by following this K. Janardhan, the apex court has written this thing.
Janardhan.
Yes. My lords, may kindly see, my lords, here, my lords.
Have you
Here.
given him a copy?
No, I will give.
It's all right.
Give.
No problem.
Yes,
I am sorry.
Read,
One
read.
copy is, 1 second. I am sorry.
One
Once.
submit, my lord. No problem.
In this case, Janardhan case, he was also driver.
Paragraph number 6. Court has considered 100% because there's a driver and leg is amputated.
My lord, I will draw the attention of the lordship to the pair number 6.
Yes.
Last 3 lines.
Yes.
Additionally, a perusal of the section 8 and the 9 of the motor
Where are you
vehicle
reading? Paragraph number 6 starts with applying the ratio of the cited judgment.
100% disability
Uh,
and incapacity of earning the his keeping as a tanker driver as his right leg had been amputated
From the knee.
from the knee. Additionally, a perusal of the section 8 and 9 of the motor vehicle act would show that the appellant would now be disqualified from the disqualified from even getting a
No.
driver's license.
Before that, the court has considered the expression total disablement, section so and so of the act. Now, he is an employee, is working as a driver.
My lord,
Now, because of this disability, he will not have he can't even have the
my
driving
lord,
license.
he may not get the driver's job, but he can do other works. It doesn't mean that he is a paralyzed or totally living vegetable. He is on the bed. He is not in a position to move. Then it is acceptable, man. He's lost his job. It's acceptable one. The thing is that he's not totally disabled. He was not any bedridden. He do other works also. Basing on that, this act is clearly speaks about the whatever the disability is to be considered for the person who had the different types of injuries and amputations.
This is also arising out of the Workmen Compensation Act.
I do agree. I do agree, madam. If he has established that he has he has surrendered the driving license, he is not in a position to do any other works.
Forget about any other work.
My
A
lord,
driver is
100,
expected.
my lord, calculating 100% means he is
That's
totally.
what, but that's the settled law. A person who is working as a driver, we have to look at it, whether he'll be able to do the driving job or not.
I do agree, my lord. I do agree. The thing is that, my lord, whether he can do other works or not.
That's not.
If he is, no, my lord. If he is doing other works, he can earn lesser than the amount what he is getting from the driving.
The line of judgment of the Supreme Court or the other way around than what you're submitting.
My submission is that considering
I
this.
understand, but that's not the line in which the Honorable Apex Court has
my
considered
lord.
the total.
I am not disputing the order passed by the Apex Court or not interpreting this one.
Not
The
about this
thing
judgment.
is that, my lord, he is not a totally disabled. He can't do any other works. He can do other works. That means that if he is getting 10,000 rupees income
That's why
for.
it is interpreted as functional disability. Functional disability is 100%. Yes. Yes. Come to that calculation.
My lords, I have calculated. Comes to future earning 19,37,520.
Pass on that.
In rough, my lords, I have calculated.
So let's calculate. So what is that 9,000?
No, my lord.
15,000 of 60% comes to 9.
What is that?
15,000 income.
My lord.
The accident?
21, my lords, after amendment. It comes to 9,000 into relevant factor is 215.28.
One minute.
215.28. It comes to 19,37,000.
9,000. What is the factor?
215.28.
5.28 into
100%. That we have to live. This it comes to 19,37,520.
5.8 comes to 19 lakhs.
37,520.
7,520.
Plus medical bills retained 55,100.
How much?
55,100.
Where do you get that?
My lords,
Considered,
my lords,
Plus 55,000.
100.
55,882.
No, it is 100 at paragraph 23.
Totally, it comes to 19,92,620.
Shall I submit one point, my lord, regarding calculation?
Regarding?
Calculation. Even though it's an injury case, when it is considered 100%, it is just like a death case, my lord. 50% is to be deducted towards the expenses.
No, where do you get that? Basing on which law, basing on which judgment?
My lord, the simple logic, my lord. Even though there is
No,
no.
and under the
My lord,
under the ECA, we have a different calculation. Under the Motor Vehicles Act, we have a different calculation.
Under WC, my lord, if it is a death case, 50%, my lord. In case of injury, 60%, my lord. Where in this case, my lord, even though it's an injury, 100% is considering. It is just like a calculating in the death case. Death case, we are considering 100%. It means that the considering 100% mean that the person was dead or
Calculate like that, how much?
Alive dead.
My lords, this point, Apex Court in the year 1996 in Charlie judgment, it has made it very clear. No 1/3 deduction or nothing in case of 100%. That Charlie case, my brother knows it very well.
That is MUC
So
case,
it
not
is
the WC case. So
I'll record the contentions.
My lord, my contentions are to be recorded.
Yes.
Also considering this point, my lord, as what the statute speaks regarding the consideration of the disability.
agreed with orders passed in ECN number 4 of 2021 dated 31st December 2022, whereby the tribunal has granted compensation of 16,05,116. Whereby the first additional senior judge and JMFC Angaletta has granted an amount of rupees 16,05,116. The claimant is before this court. When counsel appearing for the claimant submits that the tribunal has held that the petitioner has a total permanent disability of 75% in respect of the right lower limb and 30% in respect of the left lower limb. Further, the total permanent physical disability is taken as 80%.
80%, 20 plus 10%.
Taken as 80%. It is submitted that he was working as a driver and it is an amputation above the knee.
Below knee.
No. Photographs is.
Amputation.
It is below knee, that is
Below the
observed by the court below in para number
below the knee
14
or
of the
above the knee?
judgment.
My lords, photographs is above knee.
It is submitted that the amputation is above the knee. It is
My lord,
submitted
it's observed that below knee in para number 14 of the judgment.
I'll record that. It is amputation above the knee. The petitioner, the appellant claimant is 100% functionally disabled. He'll not be in a position to work or position to drive. As such, the court ought to have taken the disability as 100%. In this regard, he has relied on the judgment passed by the Honorable Apex Court in K. Janardhan versus United India Insurance Company Limited and another, reported in 2008 HCC 518, and the judgment of the Supreme Court in S. Suresh versus Oriental Insurance Company Limited and another. In K. Janardhan's case, the Honorable Apex Court at paragraph number 516 observed as follows, extract 516. It is submitted by the Land Council that the 100% disability has to be considered and the compensation has to be granted. Next para. Land Council appearing for the insurance company submits that in the judgment, it is observed as at paragraph number 14. It is observed as amputation below the knee.
No, it is above knee, my lords. Here observe.
At that,
Para 13,
it is stated that Exhibit P14, his right leg has been amputated at below knee. It is further submitted that it is not the case that petitioner, the appellant, is not in a position to do any other work. If he is not able to do the driver job, he would be able to do any other job. In that case, he is not entitled for the 100%.
He has not surrendered his driving license.
I'll continue that. I'm yet to complete it.
Please.
And it is not the case that he is not able to do any other job. Further, it is submitted that he has not surrendered his driving license. Driving license, it is submitted that question of taking 100% disability in this case would not arise. Alternatively, it is also submitted that if by any chance, if this court comes to the conclusion that the disability has to be taken 100%, then as like in the death case, the income has to be deducted 50% and the compensation has to be granted. Anything else? Has to be granted. It is submitted that on all the counts, the compensation that is awarded by the tribunal, by the court is just and reasonable and no enhancement is called for. Next para. Having heard the learned counsels on either side, produce the material on record. The issue with regard to what is a physical disability and how a functional disability has to be considered is no more res integra. The Honorable Apex Court and this court in series of judgments have held that when the court considers a disability, the court has to consider the functional disability. In case of a driver, if the leg is amputated, either it is below the knee or above the knee, it is clear that he cannot drive the vehicle. The submission of the land counsel appearing for the insurance company that there is nothing to show that whether he has surrendered the driving license or not, that is immaterial. Whether he has surrendered or not, it is clear that he will not be in a position to drive the vehicle. When the appellant is working as a driver and because of the disability that is sustained, when he is not in a position to do the driver job, it amounts to 100% disability as held by the Honorable Apex Court in K. Janardhan's case, referred supra. In that view of the matter, this court is considering the disability at 100%. Then coming to this next submission of the land counsel for the insurance company, that the court has to consider the has to deduct 50%, but not 60%. Even that submission also has no legs to stand. As is the case of the permanent disability, this court is inclined to take deduct 60%. Is inclined to take 60% of the income. Hence, in the light of the above discussion, this accident had taken place in the year 2021. As per the notification, the income has to be taken at 15,000. 60% comes to 9,000. The factor into 215.28 comes to 19,37,520. The court has already awarded an amount of rupees 55,100 towards the medical expenses. Altogether, it comes to 19,92,620. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 15,50,016 to 19,92,620.
Interest after 12% after 1 month of action.
Interest, it must have already been said in this. Yes.
Otherwise, my lord, say,
Interest, the interest part, whatever the court has said, the same thing. Yes, next.
Please. Otherwise, sometimes what happens? Don't mistake. They are not going to deposit.
No.
Please.
That
please.
record as
Please,
per the court, because that will come in the order whether
Please.
you ask or not.
Please.
Yes.
39.
Yes, 39. No representation in the month of March. 40.
Seal number 40. Subhash Jabati.
It is time to deposit the deposit. We have already no order.
Huh?
Notice served.
Sir, it is submitted by the land counsel for the insurance company that they have already deposited the amount. He will file the proof of the same. Yes.
Please.
Call for the TCR, admit fine layering.
Please.
Yes, 41.
Seal number 41.
Who appears for Cholamandalam?
Clement, sir.
Who appears for Cholamandalam?
Cholamandalam.
Who is the panel counsel? You appear? So and so is directed to take notice on behalf of second respondent insurance company. Admit fine layering TCR. The counsel shall serve the copy of the appeal memo on the counsel. Next 42.
Number 42.
For appellant, my lords. My lords, in this, my lords, we have filed application for stay, my lords. That IA has been not put up by the office, my lords. Therefore, my lords, it may be.
Petition is not there in the file.
Lords, the application is filed on 19/12/2025, my lords.
What is call for that? What is this?
My
On
lords,
what ground you are
appeal by
deposing?
insurance company, my lords,
On the
challenging
ground?
liability, my lords. On the ground that, my lords, in spite, my lords, the tribunal has come to the conclusion that, my lords, it's a case of composite negligence, my lords. The driver of both the vehicles are equally negligent, my lords. In spite of that, my lords, the tribunal has fixed entire liability on the insurance one of the insurance company.
That it's a case of composite negligence and the entire liability is fixed on the insurance company. The appellant insurance company stay 50%. The respondents are at liberty to withdraw notice. 4 weeks. Yes.
Obliged.
IA number 43. Call for that IA. Yes, next 43.
Beneficiary appeal ಮೇಲಾಡಿದ್ದೆ. Similar matter ಮೇಲಾಡಿದ್ದೆ, stays ಮೇಲಾಡಿದ್ದೆ.
Give that same order. Next 44, so and so takes notice. That also same.
Up to 49 my lord, same my lord.
Up to?
49 my lord.
Yes.
1 and 2 my lord, government my lord take notice. My lord.
1 and 2, AGA takes notice with the respondent. Remaining respondents notice. Next 50.
Seal number 50, preliminary hearing. Seal number 50.
Please, Your Lordship. Challenging the annexure F, Your Lordship, the notification issued by the first respondent, my lords. My lords, the petitioner is a hereditary trust.
Yes.
My lords. Challenging the notification issued by the respondent number 1, Your Lordship, annexure F, Your Lordship.
Who is respondent number 1?
My lords, the government, Your Lordship.
Government. What
Yes.
is the notification?
Notification, my lords, to notify the temples as a public under the
Endowments Act.
Please, Your Lordship.
What is wrong with that?
My lords, it's not a public temple, Your Lordship. It's a private temple, Your Lordship.
What is the procedure that is followed before notifying the temple? What did you say? Please come to your grounds.
My lords, we are saying that it is not a, it is an individual temple, Your Lordship. It's not a
No.
private.
No, it might be a private temple. No, have they followed the procedure or not?
My lords, the issuance of notice was not within the knowledge of us, Your Lordship.
Which is this temple?
What's the temple is?
Rameshacharya M. Gudi.
Veera Narayana.
Hereditary Administrative Trustee of
Please.
Lord Sri Veernarayana Tour Group of Temples.
Please,
It should be the other way around, the writ petition. That is, Sri Veernarayana Group of Temples, so and so, represented by its Hereditary Administrative Trustee, Sri Ramacharya. That should be the cost title.
Please.
The petition is hereditary administrative. You have the instructions in this?
First time matter, Your Lordship, I'll take the
Get
notice and
instructions.
please.
The respondent shall file their objections within 4 weeks. Only one respondent, so AGA takes notice.
Please.
Yes, next.
Seal number 41, Rajshekhar Burji.
51.
51.
This petition is by the workmen, my lord, calling in question the order of the labor court, my lord, wherein, my lord, the petitioner has called in question the only to the extent of denial of, my lord, back wages and withholding of 2 additional increments.
Notice.
Please, my lord.
Notice
And
the
in all the 3 matters, my lord, the same is by the workmen, my lord.
Notice.
There are other matters, my lord.
Takes notice.
No, my lord, the Shivkumar Bhadarwadi appears for
So and so is directed to take notice on behalf of all the respondents.
the connected matters are there, my lord.
Yes.
Shivkumar Espadodi.
Along with the other matters are also.
Yes,
there.
my lord. The
List along
management
with-
has also filed a petition, my
List
lord.
along with so and so.
Please.
Yes, next.
Seal number 55,
Yes.
Dinesh M. Kulkarni.
Lords, I have filed Section 10 application in the FDP proceedings, my lords. Earlier in the year 1995, suit for partition has been.
Who are you?
I'm for the petitioner, my lords.
No, that I understand.
In-
Who are you? Are you a third party?
In the
Are
suit,
you
I
a-
was a defendant, my lords.
You are the defendant in
I
that.
was the defendant. Suit was compromised between the parties, and 2 parties have relinquished their rights in favor of other 2 parties, my lords. And in the year 1995,
Right is relinquished in favor of the defendant.
different number 1 and 3, my lords. In favor of different number 1 and 3. I was different number 3 in the suit, my lords. Plaintiff and different number 2 has relinquished their rights
We'll
in.
do one thing. Let's go to the impugned order. We'll see that. We'll read that order. Then you can make your submissions.
Please, my lords.
Which page?
Page 70, running page 70, my lords.
70?
70 is the application, my lord, section 10 application.
No. Please come to the order.
Please.
Impugned order.
Annexure L, my lords.
Page number.
Page number. Eighty-six, my lords. 86, my lords.
86, sir. 86, what is the order? Please read that order.
Please, my lords. Pardon, my lords. Page number 82, my lords.
Read that. Read from 81.
The concerned staff has also secured the file bearing OS number 58 of 2019, which is connected to the present main petition. The present FDP arises out of the compromise petition before the DLSA Bagalkot in OS number 152 of 95, my lords, on 16/4/96, wherein the subject matter of the OS number 58 of 19 is one of the suit schedule property of the suit at OS number 152 of 95, my lords. Therefore, the rights and liabilities of the parties to the main petition in respect of suit schedule property have been declared in the aforesaid compromise petition. Therefore, a fresh suit in respect of the same does not arise, and therefore, apparently, it appears that the suit at OS 58 of 2019 is not maintainable in view of bar contained under section 11 of CPC. However, the respondent has ventured into filing of IA number 1 seeking stay of the present main petition on the ground of pendency of OS number 58 of 2019. But as already stated in the rights and liabilities of the parties to the main petition have been declared in the compromise petition as stated herein above. Therefore, it is subsequent suit at OS number 58 of 2019 which needs to be held as barred under section 11 of CPC and not present final decree proceedings. Therefore, the IA number 1 submitted by the respondent is liable to be rejected, and the same is rejected with cost. It seems the respondent has made a futile attempt to drag on the case. Hence, the objection if any of the respondent to the main petition are liable to be ignored, my lords.
So, if OS number 58 of 2019 is pending,
please,
how can you say this FDP proceedings which are arising out of some other decree has to be stayed?
Please, my lords, the decree is of the year 95, my lords.
Whatever it is, no, listen to the court. Now, FDP number 2 of 2024 is filed.
Please.
Whatever are the rights of the parties, whether that FDP can be proceeded or not, will be decided by the court basing on the petition. That's why the court said for steps on the main petition. This FDP cannot be stayed because OS is pending.
My lords, the thing is, after the compromise decree has been drawn, the parties have entered into a family arrangement, my lords. And the defendant number 1 in the present 58 of 19 has played fraud upon the present petitioner and has obtained some of the properties, my lords.
So in that regard, to stay the FDP proceedings. FDP proceedings have to be independently dealt with. The court has rightly said.
Also, it is of the year 2024, my lords. FDP is of the year 2024.
Whatever it is, now the court will decide whether the FDP is maintainable or not. If you say that it is not maintainable in view of so and so, that will be decided. But you can't say that you stay this because some other suit is pending, which is unconnected with this FDP proceedings.
I'll clarify, my lords.
Yes, notice to the respondents.
Still number 56.
Yes.
Please.
So writ of mandamus, my lords. To respondent number 2 and 3, they are interfering in day-to-day business of petitioner's hotel, my lords. There is a notification by the government at typed copy at page number 39, my lords, allowing them to carry on the business till 1 a.m.
Other connected matters are coming up
on 20th.
On Tuesday.
Please.
This is matter on Tuesday along with, give that number if you have.
Please, Your Lordship.
Yes.
20.
Yes,
Serial number 57. Kiran Kumar Chittimat. 57.
No representation. List after 4 weeks.
4 weeks. Serial number 58.
This also same.
Mal Shetty. 4 weeks. Serial number 59. Ravi Kiran P. Pawar.
My lords, this matters pertaining to tender, my lords. My lords, respondent number 2 has called an invitation for tender, that is executive engineer PWD, my lords. My lords, now this tender is governed by KTPP rules and KW4. My lords, and this value of the tender is, my lords, 1 crore 42 lakhs. Now, my lords, this tender is in respect of resurfacing of the road in Karwar, which is about 34 kilometers from Kaika Karwar. Two places, my lords. But usually in the tender, there are two cover system. One is technical and one is financial. Whereas once the tenderer or the person who is going on for tender, once he's qualified totally for the technical bid, he'll be eligible for financial bid. And it is in accordance to KTPP rules. My lords, in Karnataka, it is Karnataka Transfer of Public Procurement and Karnataka verse 4. My lords, this particular tender, which is 1 crore 42 lakhs, it comes under KW4 clause bid document. My lords, now the technical.
When was the tender called for?
My lords, tender
Date
was
of
called
notification.
on 29/8/2025.
The papers on them.
We have served, my lords.
You have the copy?
No, Your Lordship, copy is not there, Your Lordship.
But we've already served the copy. We have the signatures of government. It is already in the cost list. It is served.
Password, Your Lordship. Kindly password, I will verify.
But it may be taken up because, my lords, there is a, please, my lords.
Pass. Seal number 60.
My lords, it's an externment order. My lords, the respondent number 2 has passed an externment order under section 55 of Karnataka Police Act.
Order is passed.
Yes, my lords.
It's appealable under 58.
Under 58, they have to afford an opportunity to the person who is to be transferred from one place to another place, against whom the externment order has to be passed. But my lords, they have not issued a notice to me, and directly they have passed an impugn order, which is at.
Get instructions whether notice is issued.
Please, Your Lordship.
In the AGA takes notice on behalf of.
My lords, in the meantime, there is a stay, my lords. 6 months he has been.
Get instructions, telephonic instructions. Password?
Please, Your Lordship.
Yes, password.
Grateful, my lord.
Only issue is whether notice is given or not.
Please,
If
Your
not
Lordship.
given, we'll set aside the order.
Please, Your Lordship.
61.
Yes.
My lords, previously the son of the petitioner went missing, my lords, and a complaint was lodged, and his other authentication has been.
Let me look at the prayer. What is that you're seeking? Quashing the endorsement dated issued by respondent number 1. Who
Please,
is the
my lords.
respondent?
Previously, an writ petition was filed and order was obtained, my lords, to get the Aadhaar authentication details of the missing son of the petitioner, my lords. While we approached the respondent to produce the details of.
Of mandamus directing the respondent to comply with the order. To comply with the order in WP number, another writ petition. How can you file another writ petition?
My lords,
What is this order on order in WP number 1055?
Order in WP, that is the directing the respondent to produce the give the other authentication details of the missing son, my lords. But when we approach the respondent with the order, the respondent has issued the endorsement annexure L, my lords. Annexure F.
Respondent number 1 is directed to furnish to respondent number 2 only the details of location of the usage of Aadhaar card of the missing son of the petitioner from the date of filing of the missing complaint till date, within 15 days from the date of receipt of the copy of this order, so as to facilitate the investigation by respondent number 2. It is made clear that apart from the location of the usage, no other details shall be furnished. Respondent number 2 shall not share such details information with anyone else apart from that required for the purpose of the investigation. Now come to the endorsement of the respondent number 1.
It is at page number 39, my lords, annexure F.
Read it.
Clause 2, my lords.
Yes.
It is to intimate that UIDAI shall retain authentication data for the period of 6 months as per regulation of 27 of the Aadhaar regulations 2021, which reads as under, my lords. Regulation 27, duration of storage. Clause 1, authentication transaction data shall be retained by the authority for a period of 6 months. The authority may prescribe procedure to archive and perform analysis for research purpose from aggregated and anonymous authentication transaction data in the form of circulars. Clause 2, upon expiry of period of 6 months specified in sub-regulation 1, the authentication transaction data shall be deleted except when such authentication transaction data are required to be maintained by the order of the court, not inferior to that of the judge of high court, or in connection with any pending dispute, my lords. So in compliance of the order dated 23/9/2025 of the Honorable High Court of Karnataka, Dharwad Bench, UIDAI RO Bangalore has made all efforts to provide information in accordance with the provisions of Aadhaar Act 2016 and amended thereto. It is to intimate that no authentication data of the resident found from 1st April 2025 to 28/9/2025. Please, my lords. I kindly take your attention to Annexure D, my lords, page number 16. The typed copy is also produced at page number 17, my lords. The Aadhaar authentication history was sort of the year 2023. That is 26.
No, what is wrong with this? They said they will preserve it for 6 months.
Please, my
If
lords.
there is any order, they will further keep it.
Please, my lords.
Now, when by the time this order is passed by the in WP number so and so, that period is lapsed,
Please,
and
my
they don't
lords.
have any other details with them.
Please.
How do you expect them to give?
That's
them?
what I'm saying, my lords. The clause 2 reads as under that or in connection with any pending dispute. If there is any pending disputes, the authority shall retain the data, my lords.
Pending dispute, and if there is an order from the court to retain it, then they will retain it.
Please, my
By
lords.
the time this order is passed, when is this order passed?
In the year 2025, my lords.
This order is dated 23rd September 2025. You are seeking that Aadhaar card authentication. When is the date?
26/12/2023, my lords.
26/12/2023. So 6 months time.
Please, my lords.
Elapsed by
26/5/2024. I agree, my lords. But I have given a written representation on 10/5/2024 to the authority, my lords. I have given them a written representation, my lords. So the dispute arose on 10/5/2024. That is within 6 months of the other authentication date, my lords. So they shall have to retain the.
Come back again to that the endorsement. Given. Again, read it.
Please. I shall read from clause 2, my lords, of Rule 27.
Yes.
Upon expiry of the period of 6 months specified in sub-regulation 1, the authentication transaction data shall be deleted except when such authentication transaction data are required to be maintained by the order of the court, not inferior to that of the judge of a high court or in connection with any pending dispute.
That is all by the high court. There should be an order from the court, then only
Please.
it will be retained. Now, it is not available with them. How can we compel them to give something which is not with them?
One thing I want to mention, my lords, when we approach the authority, they have stated that if we get an order from High Court
But
regarding.
you couldn't get it within the time.
No, my lords. On that, they want to mention a particular date of which we want the authentication history, my lords. If that date is mentioned in the order portion, they are ready to furnish the details. They are saying that they are maintained the records with a private agency. So they'll intimate them if the particular date is mentioned in the
Court
order.
can only consider what is there at page 39. What is the interstate, what has transpired between you, that we can't take into consideration.
My lords,
When they can't do it, they can't do it because it's not available with them.
On perusal of Annexure D, it is clear that the dispute has arose on 10/5/2024, my lords. That is.
You are reading it, that you can't read that sentence in isolation. You have to read it along with the prior sentence. Please come. The present writ petition is filed, seeking the following prayer. Extract the prayer. It's a case of the writ petitioner that the petitioner's son went missing on 19/12/2019 by sending a message to his younger brother about leaving his home. In this regard, they filed a missing complaint on 20/12/2019. Basing on that, crime number 73 of 2019 was registered. Meanwhile, on 26/12/2023, the Aadhaar card of the missing son of the petitioner has been accessed and a demographic authentication was done. The petitioner has informed the same to the police authority. The police have tried to get the authentication history of the son of the petitioner, but the UIDAI, having contained the confidential information of an individual, the police could not access the authentication history of the missing son. Then the second son of the petitioner has made a written representation to the respondent number 1 on 10/5/2024, seeking to furnish the details of authentication history. When the respondents have failed to disclose the same, the petitioner has filed WP number 105596 of 2025. And that came to be disposed of by order dated 23rd September 2025, whereby this court has directed the respondent number 1 to furnish to respondent number 2 only the details of location of the usage of Aadhaar card of the missing son of the petitioner from the time of filing of the missing complaint till date within 15 days from the date of receipt of the copy of the order, so as to facilitate the investigation by respondent number 2. It is made clear that apart from the location of usage, no other details shall be furnished. Further, the respondent number 2 shall not share such details information with anyone else apart from that required for the purpose of investigation. It is the case of the petitioner pursuant thereto. The first respondent has issued the impugned endorsement. In the endorsement, it is stated that in compliance of the order dated 23/9/2025, the first respondent has made all efforts to provide information in accordance with the provisions of Aadhaar Act 2016 and amended thereto. It is intimated that no authentication data of the resident and authentication data of the petitioner's missing son is found. Missing son from 1st April 2025 to 28/9/2025 is not available with them. In the intimation, it is also stated that the authentication transaction data will be retained by the authority for a period of 6 months. It will be deleted after 6 months, except when such authentication transaction data are required to be maintained by the order of a court, not inferior to that of a high court, or in connection with any pending dispute. It is the intimation of the first respondent that they have not preserved the data, and as such, they are not in a position to give the details to the petitioner. Now in next para, the land counsel appearing for the petitioner submits that the Aadhaar card was accessed on 26/12/2023, and the order, and on which date? On 10th May
10/5/2024.
2024, they gave a requisition to the first respondent. As the dispute is pending, they ought to have kept the data. And the second relief that is sought is to implement the orders that are passed by the coordinate bench of this court in WP number 105596 of 2025. First, the relief that is sought to implement the order passed in writ petition. For that, another writ petition cannot be filed, and the remedy of the petitioner seeking implementation of an earlier order passed in a writ petition is not by way of this writ petition. Next, the second relief, that is questioning the proceedings, that the endorsement that is issued by the first respondent is concerned. The first respondent, relying on the regulations number 27 that pertains to duration of the storage has categorically mentioned that generally the data, they have to preserve it for a period of 6 months. And if there is any order from the court, it will be preserved for a further time. Admittedly, in this case, the order is passed in the writ petition on 23rd September 2025. And the Aadhaar card is accessed on 26/12/2023. Hence, it cannot be expected that the same information will be with the first respondent. And the first respondent has explained the reasons why they could not give the information as per the order passed by the court in the writ petition. Hence, this court finds no reasons hence this court finds that the information, the endorsement that is given by the first respondent is in consonance with the regulation number 27 of the Aadhaar within brackets authentication and offline verification regulations 2021. And hence this court cannot pass any orders in this writ petition. Accordingly dismissed. Yes, next.
Dismiss.
Yes.
Number 62.
Yes.
Suit for positions, my lord. Suit for position, my lord. The suit has been dismissed, my lord. In the RA, the defendant number 1 has filed for appointment of court commissioner, which came to be allowed, my lord. Earlier, defendant number 1 has filed in OS, my lord, which the IA is rejected, and even the suit also dismissed, my lord. And they are relying that there is one sealed, my lord, that is exhibit.
Impugned order. Page number.
My lord. Page number 88, my lords.
Yes. Come to the reasoning part. Please read it.
The appellant has filed the present appeal against the judgment and decree passed by the civil judge, wherein the trial court, after the finished trial, has dismissed the suit of appellant and plaintiff, my lords. In the application, the applicant has contended that he has filed a suit for possession before the trial court against the defendant, and he is owner in possession of the suit property. The defendants have encroached the different portions of the suit property, but they have claimed that they are in that position of the suit property prior to the purchase of the suit property by the appellant, and he has measured the suit property twice and found that defendants have encroached the suit property. In the application and objections of the respondent, it is admitted that before filing of the suit stated the suit property was measured by the Taluka surveyor. Both survey maps produced before the trial court discloses that there are difference in the area encroachment in both maps. It also brought to notice that of the court that defendant number 2 in the said suit has filed application under appointment of court commissioner in spite measured the suit property with the assistance of Taluk surveyor, but said application was rejected by the trial court. However, since the applicant plaintiff has filed the suit for recovery of possession, claiming its portion of suit property was encroached by the defendant, and it is also noticed that before the trial court, the application for appointment of court commissioner was rejected by the trial court. Since there was difference in the area of the encroachment in both maps produced by the appellant itself, the court feels that fresh commissioner can be appointed to know the exact alleged encroachment, if any, in the suit property by the defense. Further, the appellant relied upon so it for local inspection, which is impermissible, with delegations of adjudicating power. To cite an example, if both parties claim to be in possession of disputed property, the local inspection by the commissioner cannot be ordered to ascertain the recession. The question of possession is to be decided by the court. In para 20, examine the provisions referred to the above and given fact that order 26 of civil procedure code is often in the trial court. The court is of view, broadly speaking, the following cases. The said judgment honorable court clearly that commissioners can be appointed to inspect the spot of local inspection, whether dispute relating to the boundary or encroachment to case on, and also there was dispute regarding boundary and allegations encroached by the defendant. Hence, in view of the said citation, the order 26 rule 9 of CPC can be appointed for local inspection for the purpose of a certain boundary and encroachment with respect to suit property of any. In para 14 of said judgment, it is observed that discretion though lies with court as to appoint the court commissioner before the trial court or after the trial. The decision must be taken with due regard to the possibility of reducing or eliminating the need to record the oral evidence of witnesses to prove an issue which could be effectively decided with the effect of the report. More often, that is not dispute relating to the existence of pathways, team form.
You only asked for the appointment of advocate commissioner.
No, I not, we are not asked, ma'am.
You were the defendant in this suit.
Please, my lord. Defendant number one had filed the court commissioner, my lord. The application came to be rejected, my lord. Even the suit also rejected.
Who is defendant? What is the relation between you and the defendant number one?
The neighboring lands, my lord. Mine and his. Petitioners and defendants is the neighboring lands, my lord.
Hmm.
The suit is filed by the respondent number one, my lord, stating that the respondent number and petitioners both are encroaching his property.
So what's wrong with it? What will happen if this advocate commissioner is appointed?
No, my lord. Initially, the defendant number one has filed the court commissioner, madam, which can be dismissed. Again, in suit, they says that they have obtained the property by the registered sale deed. But in the sale deed, my lord, there is at the boundaries, the present lands are not there, my lord.
Respondent.
Bill number 63. Shekaragowda, Nagnuri.
Application for renewal of passport is rejected on the ground of pendency of criminal case, my lords.
Criminal case is pending, your lordship. As a criminal case is pending, your lordship, renewal, he has to be present before the India, your lordship, wherein he is not in country, as he has stated, he is in abroad, your lordship.
No, lords. He's staying, he is attending to the court proceedings.
The trial court.
What are the cases that are pending against you?
There's only one case.
498A?
No, lords. It is under section 302. It's a
Then?
sessions case. I had applied for renewal of passport. The same is rejected on the ground of pendency of this criminal case. This matter is,
What is the procedure?
let's,
There are some judgments in this regard.
yes, my lord, squarely covered by judgment of this
Where is
honorable
that?
court. Let's,
Password?
request for password.
Pass.
It is misplaced, my lord.
Pass. Cell number 64. Bibi Somapur. B. Shakanovali.
No representation after 4 weeks.
4 weeks. Cell number 65. Abhinandan.
Let's writ of mandamus, let's petitioner is a recreational club. Let's
Same club matter.
Please, your lord. No, recreation club, this is different, your lordship.
This is different. Give that.
it is established with all the due permissions and we have renewed for the present year also. Now let's respondent police authorities are there simply harassing the petitioner club just to close the club and not to conduct the day-to-day activities. Let's this is of the place Jamkandi. In Jamkandi, what has happened, my lords? There are several cases.
First time matter, your lordship. First time.
First time it's coming.
I will get in.
So and so is directed to take notice on behalf of so and so, on behalf of the respondent. Will get instructions. Petition shall have the copy on the AGA. Lissus matter on 22nd.
Please, my lords. In the other matters, my lords, we have there is an interim order granted.
Let's understand from them what is happening. Just like that, we can't grant interim orders. Get instructions 22nd.
Please, your lordship.
Yes.
Then I request for a short.
22nd.
It is a short date.
22nd.
Yes.
22nd.
Yes.
Tunja Tata.
I appear for the petition. Now, the second respondent is a borrower from the first respondent bank. Third respondent is the wife of second respondent.
Which is the bank?
Well, the first respondent is the bank.
Which bank is that?
But, it's a Maharashtra,
Who appears?
Bank
for
of
Any
Maharashtra.
panel counsels for Maharashtra Bank?
I'm not aware. Not very.
Because DRT matters without
No,
notice to the bank will not hear
No,
the bank.
that is not here. Second respondent borrowed a loan. He is in the first floor of the building.
He is in the,
First floor of the building. I am in the ground floor of the building. The bank makes an application under section 14 to recover possession. The permission is granted to recover possession. So far as taking possession is concerned,
they lock the premises on the ground floor. I am not the borrower, nor my lord,
The guarantor.
guarantor, nor my property is mortgaged.
Then how you are a guarantor
My lord,
without the mortgaging any
my lord, in the apartment, my lord, I am residing in the ground floor. My lord, right,
property is mortgaged to the bank?
my lord, this is on the first floor. My lord, I have produced, my lord, the order of the magistrate. It specifically says property at F1. I am on the G1. My limited interim prayer is, my lord, not to, my lord, proceed further. My lord, so far as,
Let's see the order under section 14.
please, may I request, my lord, the page, Annexure J, page 133, my lord,
100 and
133. The operative portion, my lord, is on page 140. Petition filed by the application under section 14 of Surface Act is allowed.
where do you get this names and numbers?
May I request, my lord, page 143. Apart from that, my lord, the application which is filed by the bank, page 121, my lord. 120, my lords have page 121. My lord. The petition states that the said housing loan of rupees so and so is secured by the registered mortgage deed of the deposit of the executed by the respondent in for the petitioner by registered mortgage deed bearing so and so of the flat bearing F1 block number 1. So far as I am concerned, my lord, I am on the ground floor. My lord, I have produced, my lord, my sale deed. May I request page 39, my lord.
Where is the notice under 13.4 to you?
There is a notice.
They have
No.
not issued notice under 13.4.
Nothing. My lord, second respondent is the borrower. So third respondent,
It also issued to you because you are a guarantor.
no notice is issued. I am not a guarantor, my lord. I am not a guarantor.
Then who are you?
I am residing on the ground floor of the building.
That belongs to whom?
My lord, the entire building, it's apartment.
Belongs to whom?
My lord, the developer who has sold the property way back in,
According to you, the borrower has nothing to do with the building.
my lord, borrower is on the first floor of the building. He has purchased a flat in the first floor.
That's what I'm saying.
Please,
Borrower has nothing to do with your floor.
nothing to do with my floor.
Where did you say so in your petition?
Yes,
When did you purchase the property?
my lord, I have purchased in,
What is the borrower's name?
22. My lord, I have purchased in 22 from the person who had purchased in 2014. My lord, first sale deed in respect of the properties in 2014. Building was completed in 2014.
You purchased in?
2022.
Where is that?
My lord, annexure B, my lord. Annexure B, my lord, it is from L. Narasimharaju. My lord, the purchaser is the petitioner. My lord, L. Narasimharaju, my lord, it was sold the builders.
L. Narasimha Raju
Yes, ma'am.
or this Shaila so and so
Yes, ma'am.
are not the parties in the sale deed of 2014.
My lord, Sadashiv sold it to, Millard, I don't have, Millard, I have stated in the petition, Millard, as of now, Millard, I don't have the copy of the sale deed between Sadashiv and Narsim Raju. Millard, I have stated in the petition, Sadashiv sold it to Narsim Raju. So far as, Millard, the sale deed which was in favor of the borrower is, Millard, I have produced even that sale deed. And entire, Millard, encumbrance certificate to the entire building.
Please come to the schedule of this property.
Yes.
Your property.
My property, please. East, common passage and parking thereafter. West, remaining portion of the property in survey number 72/1. Then north is plot number 10, south is 11A.
Even for this property also, north by plot number
No,
10,
it's-
south by plot number 11A.
It's apartment. Since it's apartment, Millard, the ground floor, Millard, properties will be numbered in the G1. First floor will be in the F1, third floor, second floor S1. Then, Millard, third floor will be T1. Here, Millard, the property measures, my property measures 911 square feet. The property which is mortgaged is 600 square feet.
Please come. When counsel for the petitioner submits that petitioner has purchased the property in the year 2022 by way of a registered sale deed. The bank, while executing the orders that are passed by the magistrate under section 14 of the Surface Act dated 13th August 2025, has locked down the premises belonging to the petitioner. When was it done?
Millard, December 19th, Millard.
Has locked down the premises on December 19th. It is submitted that the petitioner has nothing to do with the petitioner is neither a borrower nor a purchaser. In fact, the property belonging to the borrower is in the ground floor and the petitioner's property is in the first floor.
Petitioner ground floor, borrower on the first floor.
Petitioners is in the ground floor and the
Yes.
borrowers is in the first floor. It is submitted that the action of the bank is high-handed. Next paragraph. Though, no, generally this court will not interfere in the proceedings on the Surface Act as there is an effective alternative remedy available to the petitioner to go before the RT. However, in the facts and circumstances of the case, where the petitioner has nothing to do with he has no transaction with the bank, and it is a case of the petitioner's property is they have attached the petitioner property in pursuance of the orders passed under section 14. There shall be stay of all further proceedings. The respondent or restrained from enforcing the security interest in respect of the property bearing plot number G1 till the ground floor situated at RS number 72/2, Pale Kundri village, Pant Nagar,
Balekundri,
Belgavi district. Till the next date of hearing, the petitioner shall take out hand summons on the respondent bank and shall file a memo to that effect by 10th of February. If the memo is not filed, the stay granted by this court stands vacated.
Great. Lord, may I to take notice on the respondent 2 and 3?
Notice, issue notice to respondents 2 and 3.
Great.
Seal number 67. Pranande Pachapure.
Yes.
This matter, my lords, the commissioner of the Hubli Dharwad municipal commissioner of Hubli Dharwad Corporation, my lords, passes a general order directing the zonal commissioner to cancel the contracts of, my lords, the contractors who are discharging their duty through work order for disposal of waste management, my lords. Similar, my lords, order, the order under which is challenged, this honorable court has already stated the common order, my lords, at annexure E, my lords, your lordship put page 25. This honorable court has already stated that order. He is also one of the contractor. The lordship would find that at next page 26, the termination order does not speak any notice being issued to the petitioner, it is ostensibly passed on the instructions of the, here, the present case also, it is the same thing.
The present writ petition is filed questioning the order dated 22/9/2025 passed by respondent number 2. And also the endorsement dated 25/9/2025. It's a case of the petitioner. That petitioner is a contractor. And basing on general instructions issued by the Commissioner Hubli Dharwad, the respondent has cancelled the contract.
Terminated the, yes, madam.
Terminated the
Contract, my lords, work order.
terminated the contract. It is submitted that in batch of writ petitions, that is WP number 108168 of 2025 and others, a coordinate bench of this court on 4/11/2025 had granted the interim order as prayed for to the next date of hearing. Leonard, the HA takes notice for all the respondents.
Let's,
Number 1, your lordship. I'll
1
take.
minutes.
Only 1, your lordship.
2 and 3 minutes,
are,
panel advocates are there.
Is
madam.
there?
HDMC.
Takes notice for respondent number 1, 2 and 3.
Gachin Mat, your lordship.
Gachin Mat.
Gurudev Gachin Mat.
Sachin,
Gurudev Gachin Mat.
so and so is directed to take notice and the counsel for the petition shall serve the copy of the writ petition.
Please.
Considering the order granted in WP number 108168 of 2025, there shall be an interim order as prayed for to the next date of hearing.
Please. Great.
It's after service of notice.
Please.
Seal number 68.
Please.
Shabu.
For the petitioner. Petitioners are before this honorable court challenging the order, rejecting an application filed by them, or seeking their implement in the final decree proceedings. The property in question, which was
The
suit was one for partition and separate possession. The petitioners herein are also the sibling and daughter of a sibling of the plaintiff. That is respond number 1 herein.
You were not.
I was not made a party. We made an application in the suit that was rejected by the trial court. Then the suit was decreed. Now we have instituted a suit seeking that the decree is not binding. In the meantime,
When is the suit?
suit is of the year 2017.
When was it decreed?
It was decreed in the year 2022.
When was your application for impeachment? When was your application?
In
for
the suit
impeachment?
also I had filed an application.
Court, when is it?
That was rejected in the year 2018.
Then what did you do?
I did not challenge that application, that order. What has happened, what attracted me to this honorable court is, now I have filed a suit before the trial court seeking that this said decree is not binding, because the property was purchased by 3 sisters. In this part of there are some categories called as Devadasis, ladies who purchased the property in the name of their brother, who is none other than the ancestor, that is husband and father of respondent numbers, so and so plaintiffs who filed that suit. Therefore, we sought our impleadment. Now my suit is pending. The defendants
When you
have.
filed an IA,
Yes,
IA
sir.
is dismissed. Are you not supposed to take it to a logical end?
It should have been Unfortunately, we were not advised to challenge.
Application of that, not taking that order.
My
And
humble-
now coming up with an application for impleadment in a final decree proceeding.
Reason is, what happened in the final decree proceedings, the original defendants who were contesting the suit have not filed any objection to the main petition. They have not even filed objection to the application filed seeking appointment of court commissioner. My rights are since seriously prejudiced. I am before this honorable
So
court.
please come to the impleadment order, page number.
Yes, page 103. Reasons start from page 105.
Yes,
May I read it,
yes.
105.
Read.
Without repetition of fact, let me see as to whether the proposed respondent 5 and 6 are necessary parties for adjudication of the proceeding. Contention of the proposed respondent 5 and 6 is that they are members of Hindu undivided joint family of the petitioner and respondent 1 to 4. They have also share over the petition schedule property. Hence, they are pending. It should have been pleading that they have to be impleaded as respondent 5 and 6. On going through the records, the proposed respondent 5 and 6 had filed the same application in OS number 1051 of 17. But on 27/6/2018, application of the proposed respondent number 5 and 6 had dismissed. In the objection to IA, which was filed by the plaintiff in the suit, bearing OS 1051 of 2000, contention of the plaintiff was as follows. Suit schedule property was purchased by the Srimati Sugandha, daughter of Yellappa Mukhi, who is mother of defendants 1 to 4 and sister of plaintiff. The said Srimati Sugandha acquired the suit property through the registered sale deed dated 10/4/1981 executed by her vendors. Said property has been purchased by the plaintiff and mother of defendant number 1 to 4 jointly. Hence, the proposed defendant number 5 and 6 are not having any sort of right or claim over the suit property. Further, the proposed defendant number 5 and 6 are not belonging to the joint family, and hence the plaintiff sought for dismissal of the suit. After hearing both sides, court had dismissed the IA number 1, which was filed in OS 1051/2017 with the following reasons. At the outset, from the document produced, it is clear that dispute is between plaintiff and defendants 1 to 4 in the present suit in respect of suit property purchased by plaintiff and mother of defendant number 1 to 4 jointly. Said property cannot be construed as Hindu undivided joint family property of entire family of the plaintiff and defendants and proposed defendants 5 and 6. Hence, this court is of the view that the proposed defendants 5 and 6 may agitate their right in respect of any ancestral or joint family property, if any, belonging to the family of late Yamnapa Mukhi, and not in respect of the suit property, which is said to be purchased by the plaintiff and mother of defendants 1 to 4. As such, proposed defendants 5 and 6 are neither necessary parties nor proper parties to implead in the present suit, so far as it relates to right of proposed defendant 5 and 6 in respect of suit property. Hence, this court has come to conclusion that the proposed defendants 5 and 6 are neither necessary parties nor proper parties to be impleaded in the present suit. As such, the application does not survive for consideration and the same deserves to be dismissed. Hence, I1 is not maintainable. After completion of trial in OS 1051, court had dismissed it. It should have been decreed the suit for following reasons. Burden is on the defendants to prove that the suit schedule survey number so and so are joint family properties of the plaintiff and defendants 1 to 4. For proving the said contention, no oral documentary evidence produced by the defendants. Defendants contend that since the said properties are joint family properties, as such, the original sale deeds are in possession of one of the sister of plaintiff. As per the original sale deeds dated Exhibit D27 and D30, it reveals that suit shall property bearing so and so, purchased by the plaintiff and mother of defendants 1 to 4, Sugandha, and survey number so and so purchased by the plaintiff. In both the sale deeds, there is no recitals with regard to purchasing of said properties on the basis of joint family income. Under such circumstances, the contention taken by the defendants having not acceptable one. On going through the entire material available on record, it discloses that the plaintiff is having half share in the suit schedule property, survey number so and mother of defendants 1 to 4 also having half share in the suit schedule property. But the proposed respondents 5 and 6 have not preferred any appeal against the order dated so and so. There is no stay in RA number 125 of 22. Proposed respondent 5 and 6 should have challenged the order dated 27/6/2018 instead of filing separate suit. Proposed respondents 5 and 6 have every chance to challenge the decree dated 14/10/22, but they have not done the same. The conduct of the proposed respondent 5 and 6 clearly shows that they are trying to drag the proceedings. For all these reasons, the proposed respondent 5 had not made out any grounds to allow the application. This court is of view that presence of proposed respondent 5 and 6 is not necessary to decide the final decree proceedings. My only submission for my lordship's kind consideration would be, my application, though it was rejected, but it was by virtue of an interim order in the suit proceedings. My plea that my mother and that myself, 2 persons sought to be impleaded. I was never given a chance to produce any documents and lead evidence to show that we were joint purchasers.
Stop you from questioning
True,
them, because that order is a reasoned order. So many observations are made.
True, that's why
You can't get over that.
that's why I voluntarily made a submission that my application at the earlier point in time has been rejected. Now, what the problem is, the original defendants, it appears they have colluded with the plaintiff now to avoid our share. They have not even filed objection to the FDP and neither to the application seeking court commit. Now, today matter is posted before the final decree court for passing order on the report filed by the court commissioner. So it is that that drove me to this honorable court. Of course, I have instituted a suit. Now what they are doing is the plaintiff and respondents, both in RA and my suit, they are avoiding the notice. They are not receiving the summons there.
When a comprehensive suit is pending, how can you file an independent suit?
No, I was not made a party.
You filed an implead petition. You should have questioned it.
No, my suit is pending. I have also instituted a suit. My suit is pending.
Agreed with the orders passed in I number 2 in FDP number 9 of 2024 dated 8th October 2025 by so and so. The proposed party is before this court. The facts of the case are the
Respondent number 1,
who has initiated this?
Respondent number 1. The deceased respondent, deceased husband and father of my lord, respondents 1 to 7, 6.
Respondent 1 to 7 or the plaintiffs in the
No,
suit?
their my lord ancestor, that is Vasant. I have shown him my lord as deceased. Vasant had filed this suit.
Vasant has
he-
filed the suit.
He is the husband of
As
respondent number 1.
pendency of the suit, he has filed a suit for partition. During the pendency of the suit, the respondents 1 to 6 are impleaded as the LRs.
Yes, yes. Ma'am.
LRs of the deceased. The defendants are respondents 7 to 10. In the said suit, the petitioner herein has filed an IA seeking impleadment, that is in OS number
1051 of 2017.
OS number
1051 of 2017. my lords.
7. That's as filed an IA seeking impleadment. That application was dismissed. That is IA number 1. While dismissing the application, the court has observed as follows at paragraph number 9, only that inverted the quoted portion you extract. Then subsequently that suit came to be decreed. Thereafter, the FDP proceedings are initiated. In the meantime, the petitioner who has filed the IA seeking impleadment had filed a separate suit. That is OS number?
My lord, OS number 344 of 2025.
Has filed OS number 344 of
2025.
2025 seeking partition.
Partition, and that my lord a decree that the earlier decree is not binding on the petitioners.
This decree.
Yes, yes.
And filed a suit that this decree is not binding on him. That suit is pending adjudication. Now the petitioner has filed the IA and order 1 rule 10 in the FDP proceedings to implead himself. That came to be dismissed by order impugned, whereby the court has observed that when the IA, which is the filed under order 1 rule 10, was dismissed by an order dated
27/6/2018. my lords.
2018, the petitioner has not assigned the said order. And even after the suit was decreed, he has not questioned the said order, said judgment and decree. It is also observed that the proposed respondent 5 and 6 have every chance to challenge the decree dated 14/10/2022, but they have not done the same. The conduct of the proposed respondent number 5 and 6 clearly shows that they're trying to drag on the proceedings. The court observed that the proposed respondent number 5 and 6 have not made out grounds to allow the application. And the court has also come to the conclusion that they are not necessary parties to decide the final decree proceedings. If this application is allowed, definitely unnecessary delay will be caused to the proceedings and accordingly dismiss the petition. Learned counsel appearing for the petitioner proposed party submits that the court ought not to have dismissed the petition. It is submitted that the rights of the parties are involved in the case and there is collusion between the parties. As this being a suit for partition and the petitioner is having a interest in the property, he is a proper and necessary party to the final decree proceedings, irrespective of the fact whether the petitioner has questioned the earlier order dismissing his application for impleadment. Still the petitioner can file an IA, can be impleaded in the final decree proceedings as it is continuation of as the proceedings are still pending. It is submitted that without considering all these aspects, the court had dismissed the petition. Next paragraph. Having heard the counsel for the petitioner, peruse the material on record. There is no dispute about the fact that the petitioner has filed an IA in the original suit, that is, OS number 1051 of 2017, and that came to be dismissed on 27/6/2018. That order is not questioned. This court has perused the order order dated 27/6/2018, wherein the court has given a finding why the petitioner is not a proper and necessary party to the suit, and the suit came to be decreed. The petitioner now has filed a separate independent suit and pursuing the same. Now, in the final decree proceedings, with the same contentions, he has filed an IA under Order 1, Rule 10. The trial court, the executing court has considered all the aspects and rightly held that the petitioner, without assailing the order dated 27/6/2018, that's passed in the IA, nor questioning the decree that is passed in the RA, has filed an independent suit. And now his impleadment in the final decree proceedings arising out of the suit, that's OS number 1051 of 2017. He's not a necessary party, and impleading him will delay the will delay the final decree proceedings. This court is of the considered opinion that the order that is passed by the court is a well-considered one, and no interference is called for from this court. Accordingly dismissed.
Obliged, my lord. Wherever my lords are referred as petitioner, my lord, there are two petitioners. It may be so referred.
Yes.
Please, please.
Yes.
Obliged.
Number 69. Hegde Srivas.
Yes.
Lord, the petitioner made a request for registration of his vehicle under BH series and for levy of tax in accordance with amended Rule 51.
Grant BH series registration to the petitioner's vehicle
Yes.
and engine number so and so.
The condition precedent for qualifying for this kind of levy and registration, my lord, was that I should be,
Instructions
No, no, first time at
to appear
Lordship
for
notice.
all the respondents.
yes.
Respond.
AGA takes notice on behalf of respondents 1 to 4. She shall get the necessary instructions. This is matter on 3rd of February.
Yes. My lord,
Number 70.
I have bought this vehicle in the month of October 2025. The dealer has retained the vehicle because I have not been able to register it.
So this is matter on 28th January.
28. Still number 70.
One more request.
that's
I'm
not
sorry, my lord. In preliminary hearing, my lord.
It will be in the same, under the same caption.
Yes. Obliged.
Yes, 70. Yes.
So number 70, appeal for the petitioner's lordship. My lord, the respondent number 1, my lord, filed EP lordship against respondent number 2 for recovery of the, my lord, decree amount. My lord, we are the, my lord, petitioners are the, my lord, brothers of the respondent number 2. Now, my lord, by virtue of the order, my lord, public auction is, my lord, going to be held.
What is the suit?
Suit, my lord, is for decree of specific performance of contract. My lord, that is denied. That is denied, and the earnest money is, my lord, that is decreed. Annexure A, my lord, is filed, my lord, for recovery of the amount. Now, my lord, as per my lord's 3 lakh rupees is paid as my lord, page number 60 on my lord.
You're the judgment letter.
I am the brother of the, my lord, respondent number 2. It's a joint family property, 4 acres of land. It's an ancestral property. My only submission is this, lordship. Since it is a, my lord, joint family property, it cannot be held, my lord, put it to.
You should have questioned it by filing
That is one aspect, my lord. Another aspect, my lord, we are ready, my lord, we are, my lord, ready for compromise, my lord.
It's not that. When there is a remedy available to you to question the preliminary decree, you should question it.
No, it's not a final decree proceedings. It is a, my lord, execution proceedings.
The specific performance, whatever is the decree that is granted, you could have questioned it by filing an RA.
Lord, we are not the parties, my lord, in the.
You can, because you say that you are the affected party, your job.
Now, my lord, what has happened, my lords? It is decreed, my lord, in the year 2018. There is a lot of delay, lordship. My only submission is this, lordship.
This order passed.
My lords?
When is this order passed?
Please.
This order is passed on 12/2.
Lord, now, my lord, on it is, my lord, posted on 29/1/2026.
That's what are you doing from 12/2/2025?
Along with.
Let notice go to the respondent.
No.
Petition is permitted to take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect. Once a memo is filed, is the matter.
Please.
Still number 71. To ask you, someone.
My lords, appearing for petitioner, my lords, seeking extension of parole, my lords. The coordinate bench of this honorable court had granted a parole for
Parole
6.
matters, when are they coming?
That will.
Tuesday?
Please,
Tuesday.
Your Lordship.
List is matter also on Tuesday.
Please, my lords.
Seal number 72. Harish, is my good?
Amendment, amendment application came to be.
Amendment?
Application came to be dismissed, my lords. Only, my lords,
Suit is of which year?
suit is of the year, my lords, 2019.
What is the suit for?
Suit is for partition and separate possession. So in plaint, my lords, I have stated about this property, but due to oversight, not mentioned in Schedule A.
Then when was the amendment filed? Amendment, when is it?
My lords, recently in the month of December, 1/12/2020, I have, sorry, amendment application was filed on 16/10/2025.
16/10/2025.
Please.
What is the stage of the proceedings now?
My lords, now further chief of my lords PW1,
Trial has commenced for the chief of PW1.
please.
Come to the implementing order.
My lords may kindly see these properties, my lords, have.
We'll read the order and then you can make your submission. Where is the order?
My lords, at page number 77, my lord, 80. After both the perusal of the material evidence on record, it is pertinent to note that
Where are
the
you reading?
para 8, my lords, page 80.
We'll read paragraph number 7
So, please.
at page number 79.
Please. The plaintiff has filed a present application for amendment of plaint by inserting 3 lands properties in the plaint on the ground that proposed amendment scheduled properties are also ancestral joint family properties of plaintiff and defendants family, and the plaintiff has legitimate share in those properties. Also, the plaintiff recently came to know about the existence of proposed amendment scheduled properties, which was not known to the plaintiff at the time of filing of suit. Hence, the plaintiff intends to implead the proposed amendment scheduled properties by way of amendment. On the other hand, the defendant number 2 filed objection on the ground that the plaintiff had not produced any documents in respect of proposed amendment of properties and also not mentioned in whose name proposed amendment scheduled properties are standing as on that day. Hence, pressed to dismiss the application. After hearing both the side and perusal of the materials available, it is pertinent to note that the present matter is posted for evidence of plaintiff and the trial has already commenced very soon after framing of issues. On careful perusal of the application affidavit and documents available on record, it clearly shows that the plaintiff has contended that she intends to include proposed amendment schedule properties in Schedule A properties, and in support of this shared contention, the plaintiff has produced a document under I number 20 to show that proposed amendment schedule properties are available for partition, and also those are standing in the name of third parties to the suit. The plaintiff has produced the property extract register of proposed amendment schedule properties under I number 20. After going through the documents produced by the plaintiff in respect of the proposed amendment schedule of properties, it shows that said properties are standing in the name of third parties who are not parties to the proceedings. Further, the plaintiff also not clearly made out the proposed amendment schedule properties are in their joint ancestral.
Please come to your application.
My lords may kindly see application is annexure D, affidavit page 66, para 3, my lords.
Please read.
Please. That I submit that plaintiff has narrated in the plaint regarding the property bearing number 40A51+2, plot number 123 situated at Hunnur village. My lords, this I have claimed in my plaint, my lords, that I have got it is my ancestral and joint family property. But in schedule, my lords, due to oversight, kindly see my lords schedule. I have not.
Further.
Please. But the shared property is not mentioned in the Schedule A. Further, I submit that the plaintiff has also got legitimate share in the shared properties. The shared properties are also ancestral joint family properties, and the plaintiff having legitimate share in the shared properties, though oversight at the time of filing of the suit, the shared properties are not mentioned in Schedule A. Recently, we came to know about the shared properties as they are also joint family.
Properties in the plain Schedule A, after completion of serial numbers, following properties may be inserted.
My lords, page number 6.
17, 18, 19.
Yes.
According to you, these properties which you have already mentioned in the plaint.
Yes.
Now come to the plaint. Where is the plaint?
My lords, page 21, para 3. Last 3 lines, ma'am.
Two lines. Survey I'm sorry, 21, last two lines. Survey number 40A bar 40A 5/1+2, plot number 123 situated at Hunnur, joint ownership rental income. This property.
No, where is that? Paragraph number?
Last two lines, page 21.
Page 21.
21. Last two lines. Survey number 40A bar 5+1+2. Plot number 123 situated at Hunnur, joint ownership rental income.
Come and counsel for the petitioner submits that. The court, without considering the contention of the petition in its proper perspective, are dismissed an IA that's filed under Order 6 Rule 17. It is submitted that the suit is filed seeking partition. And these properties are mentioned in the plaintiff. However, when it comes to the schedule, they were not mentioned, hence this application is filed. However, the court had dismissed the petition only on the ground that the trial has commenced. Not only on the ground, has dismissed the IA on the ground that there is no description and it is filed after the trial has commenced. Considering the argument of the learned counsel of the petitioner, they shall be stay of all further proceedings. And so till the next date of hearing, petitioner shall take out hand summons on the counsel appearing for the respondent before the trial.
My lord, sir, only issue notice to 1 to 7 and others I will file dispensation application.
Petitioner shall take out hand summons on the counsel appearing for the respondents 1 to 7.
Please.
Before the trial court and shall file a memo to that effect by 11th of February, or else the stay granted by this court stands vacated. Where is the dispensation memo? Where is the memo?
I will file right now. I will.
A memo is filed seeking dispensation of notice to
8 to 29, ma'am.
8 to 29. The
Please.
memo is taken on record and notice is dispensed with at the risk of appellant, at the risk of the petitioner.
Please.
Yes, sir.
Seal number 73.
Hearing on behalf of the petitioner, my lords. Before I proceed with the facts of the case, my lords, one submission, my lords. Annexure C, D, and E is covered of the similar issue. Same order is passed, my lords. I'm also seeking for the same issue.
Let's see, what is the prayer that you're seeking?
My lords,
To quash the impugned order dated passed by second respondent.
Annexure B.
Floating of share amount of pre-registration society, so and so.
Please, your lordship, it is covered, your lordship,
is
as page
Annexure
number
B, my lords.
46, your lordship.
Interim
Impugned
order or
order.
final order?
Final orders, my lords. C, D, and E are the covered matters, my lords.
Impugned order is at page number 46, your lordship.
After lunch.
Please, my lords. Great.
Any signatures?
Kind submission, Lord, serial number 58 was held up in quota number 2. I apologize, my lord. Any date may be fixed, my lord. Today I am ready to argue. Lord.
Yes, after call that matter.
Please.
Pass.
All right.
Theatre. Babu. 58. ತರ್ರಿ ತೂನ್ ಬಾಯ್ದು ಹೋಗಿ 4 weeks ಅಂತ ಆಗಿದೆ. Content. Yeah, definitely. ಸರ್ ಹತ್ರ ಒಂದು ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಇಸ್ಕೋಬೇಕು. ಎಸ್ ಸರ್. ಖೇತಿ ಮೇಡಮ್ ಅಷ್ಟು ಕರೆಕ್ಟ್ ಹೆಸರು ಕೇಳ್ತಾರೆ ನೋಡು ನಿಮ್
ಸರ್ 64ನೇದು ಇತ್ತಲ್ಲ ಏನಾಯ್ತು?
64 ಸರ್ 4 weeks. 4 weeks. 4 weeks. 4 weeks ಅಂತ. ನಮ್ಮ ಕೊಡಿ. ಸಬ್ಮಿಷನ್ ಮಾಡಂತ ಬಂದ ತಕ್ಷಣ ಅಲ್ಲ 64 ಇಲ್ಲಿ 4 weeks ಆಗಿದೆ. ಮತ್ತೆ ಬಂದು ಮತ್ತೆ ತರಿಸ್ಬೇಕು ಈಗ ಇಲ್ಲಿ ಇಟ್ಕೊಂಡು ಬೇಡ. ಶಾಕು ನೋವಲ್ಲಿ ಅಂತ ಹೇಳಿ ನಾನು ಈ ಸಲ ಸರ್ ಕರೆದರು ಶಾಕು ನೋವಲ್ಲಿ ಅಂತ ಹಂಗೆ ಕರೆದೆ ನಾನು ಈ ಸಲ. ಶಾಕು ನೋವಲ್ಲಿ ಒಳ್ಳೆ ಏನಲ್ರ ಒಲ್ಲಿ ಅಂತಾರ ಒಂದು ಬೇಕಂತ ಒಳ್ಳಿ ಹೇಳಿ ಶಾಕು ನೋವಲ್ಲಿ
ಈ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ತಗೋತಾರೋ?
64 ಸಬ್ಮಿಷನ್ ಮಾಡ್ರಿ ಸರ್ ಮಾಡ್ರಿ. ಅಲ್ಲಿ ಇಲ್ಲೇ ಇಟ್ಕೊಂಡಿರ್ತೀನಿ ಮಾಡ್ರಿ 64 ಹಾಂ 188 ಅಲ್ರಿ? ಹೇಳ್ಬೇಕ್ರಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಸರ್ ನೀವು ಮಾಡಿ. ಈಗ ನೀವು ಕೇಳಿರಲ್ಲ ಆಗಳೇ
ಅಲ್ಲ ಕೇಳಿನಿ 230 ಕರಿತೀರಿ ಅಂತ ಅಂದ್ರ ಆ ಕಡೆ ಇನ್ನೂ ಕಂಟಿನ್ಯೂ ಐತಿ ನಮ್ದು ಎಕ್ಸ್ಪ್ರೆಷನ್. ಅಲ್ಲಿ ಯಾರನ್ನಾರು ಕುಂದಿರ್ಸ್ಬೇಕು 230
ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ರಿ ಪಾಸ್ವರ್ಡ್ ಅಂತ ಮಾಡ್ಕೊಂಡು ನಾನು ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಮುಗಿದ ತಕ್ಷಣ ಕರಿತೀನಿ. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಭಾಳ ಇಲ್ಲ.
ಓಕೆ
ಏನಪ್ಪ ನಮಸ್ತೆ ಸರ್ ತಮ್ಮ ಏನ್ ಕತೆ?
Sir, first password ಕರೀತೀರಾ?
Madam?
ನಾವು ಹೋಗ್ಬಿಟ್ವಿ ಅಲ್ಲೇ ಕಾಯೋದು.
ಫಿಫ್ಟಿ 54 ಅಲ್ಲ 58 58 ಅದು ಮಾಲ್ ಶೆಟ್ಟಿ ಅವ್ರು ಬರ್ದು ಕೊಟ್ಟಿದ್ದು ನೋಡ್ರಿ ಅವ್ರು 64 ಇಲ್ಲೈತೆ ನನ್ನ 51 ಬರ್ಸ್ಬೇಕು ನೋಡ್ರಿ ಹೇಳಿ ನಾವು ಬರ್ದು ಕೊಟ್ಟು ನೋಡ್ರಿ ಹಂಗಿಲ್ಲ ಎಲ್ಲೋದ ಹಲೋ ಹಲೋ ಫಿಸಿಕ್ಸ್ ಅಲ್ಲ ಪೊಲೀಸ್ ಮಾಡ್ರಲ್ಲ ಅವೆಲ್ಲ ಬರ್ತೀವಿ ಸರ್ ಆಲ್ರೆಡಿ ಬಂದ ಆರ್ಡ್ರ್ ಅವಲ್ಲ ಕೊಟ್ರೇನ್ರಿ ಅವ್ರು ಏನ್ರ ನಿಮ್ಗೆ ಲಿಸ್ಟ್ ಕೊಟ್ರ ಲಿಸ್ಟ್ ಅಲ್ಲ ಹೋಗಿತ್ತು ಅಂತಂದ್ರೆ ಮೇಡಮ್ ಪೊಲೀಸ್ ಮಾಡ್ರಿ ಯಾವ ಕೊಟ್ಟಿಲ್ಲ ಸರ್ ಅವರು ಅದು ಅಷ್ಟು ಹಾಕ್ಬಿಡ್ರಿ 58 ಒಂದು ಕೊಟ್ಟು ಕಳಿಸ್ರಿ ಸರ್ ಬೇಗ 51 52 53 ಡೇಟ್ ಇಲ್ಲಲ್ಲ ಇಶ್ಯೂ ನೋಟಿಸ್ ಲಿಸ್ಟ್ ಅಲಾಂಗ್ ವಿತ್ ನಮ್ಮ 3 ಅದಾವ ಹಾಂ ಅದೇ ಶಿವಕುಮಾರ್ ಬಂದ್ರು 58 ಕಳಿಸ್ರಿ ಸರ್ ಯಾವಾಗ ಬಂದಿಲ್ಲ ಮತ್ತಿಲ್ಲಿ ಮೇಡಮ್ ಅಲ್ಲಿ ಹಿಂದೈತೆ ನೋಡ್ರಿ
ಸರ್ ಅದು ನಿಮ್ಮ ಡಿಸ್ಪ್ಲೇ ಬರೋಬರಿ ವರ್ಕ್ ಆಗ್ಬೋದು ನೋಡ್ರಿ ಡಿಸ್ಪ್ಲೇ ಬರೋಬರಿ ವರ್ಕ್ ಆಗ್ಬೋದು
Now, what is their condition is no opportunity is afforded to them. There is no complaint from anyone that it is not viable. It is not a
Because
speaking
that
order.
is society. Respondent number 2 has to look out whether
So
overlapping.
let's see, let us read how this matter is different from the other matters. Where is the impugned order?
Impugned order is at annexure B, my lords, page 46, is the operative portion, my lords.
What it says?
My lords, therein, the impugned order talks about how it would affect the development of the other societies and how it, my lords, may I take your lordship to rule 3, my lords, in order to understand. Rule 3 is a,
Rule 3.
no, my lords, that is rule 3B. I'm talking about rule 3, my lords, formalities of registration. In that, my lords, subclause 3.
Yes.
Subclause 3 is the registrar, on being satisfied that the proposed society has reasonable chances of success and is going to be economically viable, may permit the chief promoter to collect such amount of share capital from such number of people intending to become the members of the proposed cooperative society within such period as he may specify. Now, my lords, herein only two conditions is prescribed. One is whether the proposed society is going to be economically viable and whether there is going to be a reasonable chances of success.
Where are you reading?
My lords, Chapter 2, Rule 3, Formalities of Registration, Subclause 3. The registrar on being satisfied. May I read, my lords? This
Then
is at
3B
the time of
relevant.
registration.
No, that is 3. Then you have to read it along with 3B.
My lords, 3B is at the time of registration. I am before the second registrar, pre-registration, my lords. That's why I made the submission in the beginning that there are two concepts that are involved. One is pre-registration and one is at the time of registration. I am not before him for registration. I have only made an application for grant of permission for collecting of share amount. The head note itself states.
There also, he has the satisfaction of the registrar is that there should be a reasonable chances of success
and economically
it's going
viable.
to be economically viable. May permit the chief promoter.
Chief promoter. Now in the impugned order, there is nowhere a whisper about either economic viability or chances of success. He is only arguing on behalf of the existing society who have not made any representation, who have not filed any objections
What
to
did
mine.
he say? No, if
He is
there are
only
other-
talking about how it
No, if there are other societies around, that in that case also it is not economically viable. Basing on the number of
population.
Well, that would come into picture only at the time of registration.
What would come in picture at this stage?
At this stage is subclause 3.
By economically viable.
Whether I am able to carry on my business in accordance.
It would be economically viable to you or not?
Please, my lords. And with regard to that, I have submitted a proposal wherein I have talked about how many sugar factories are nearby to the cooperative societies, how many what is the population, and why I am unable to be a part of the other existing cooperative societies, why we have resolved to have a separate society. Even in the impugned order, there is nowhere a whisper about what proposal I have submitted. He's only arguing on behalf of the existing societies, my lords. The similar issue is involved in the connected petitions as well, my lords. It is only, my lords, I am directed to appear before the second respondent itself. In the impugned order, my lords, at page 53, my lords, the impugned order is quashed.
No,
There
this order of Justice Pradeep Singh Arora is
Please.
based on an order in 100,493. Where is 100,493?
At 54, my
What
lords.
is discussed in this order?
Please, my lords. The application, para 3, my lords, the petitioner submitted an application only for permission to collect shares with an intention to establish cooperative society, and at this stage, respondent number 3 ought not to have rejected the application since the question of economic viability and chances
Where
of...
is this hearing is contemplated in this? Let's see, where is a hearing is contemplated?
Before passing of the impugned order, my lords, I have submitted a proposal.
Let's see what the provision says. Formalities for registration.
Clause 1, my lords, a group of persons, not less than 10 persons intending to form a cooperative society may join together and elect a chief promoter amongst themselves and a few promoters to assist him and to authorize to take further steps for registration of society. Such group of persons shall decide the name, the area of operation of the proposed society, adopt the bylaws of the proposed society, and also resolve the chief promoter to collect the required share capital from the persons intending to become the members of the proposed society. Number 2, The chief promoter shall approach the jurisdictional registrar along with the list of persons who have joined together to form the proposed cooperative society. A copy of the proceedings of the meeting of the group of persons containing names, addresses, signatures, 2 copies of bylaws, and a copy of the project report to show the proposed society has reasonable chances of success and is going to be viable organization. Subclause 3, the registrar, on being satisfied that the
Speaks about the subjective satisfaction of the registrar.
That is all.
About the proposal.
Please, my lords.
So, in his order, has he stated why that is not economically viable? Has he stated or not?
Well, as in the operative portion, there is only a discussion with regard to how it would affect the existing societies. Millards, the operative portion is in Kannada, Millards.
Read it, you can read it and translate.
ಪೀಠಿಕೆಯಲ್ಲಿ ವಿವರಿಸಿದ ಕಾರಣದಿಂದಾಗಿ ಕರ್ನಾಟಕ ಸರ್ಕಾರ ಸಂಘ ಕಾಯ್ದೆ 1959 ರ ಕಲಂ 7 ಸಬ್ಕ್ಲಾಸ್ 3 ರ ಹಾಗೂ ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ 6/12/2016 ಅಧಿಕಾರದ ಮೇರೆಗೆ ಬಾಹುಬಲಿ ಹಂಜೆ ಸರ್ಕಾರ ಸಂಘಗಳ ಸಹಕಾರ ನಿಬಂಧಕರು ಚಿಕ್ಕೋಡಿ ಉಪವಿಭಾಗ ಚಿಕ್ಕೋಡಿ ಆದು ನಾನು ನಿಯೋಜಿತ ಸಹ್ಯಾದ್ರಿ ವಿವಿಧೋದ್ದೇಶ ಪ್ರಾಥಮಿಕ ಗ್ರಾಮೀಣ ಕೃಷಿ ಸಹಕಾರಿ ಸಂಘ ನಿಯಮಿತ ಅಪ್ಪಾಚಿವಾಡಿ ತಾಲೂಕ್ ನಿಪ್ಪಾಣಿ ನಿಯೋಜಿತ ಸಂಘವನ್ನು ಸ್ಥಾಪನೆ ಮಾಡಿದಲ್ಲಿ ಈಗಾಗಲೇ ಅಸ್ಥಾಪಿರುವುದಲ್ಲಿ ಸಂಘಗಳಲ್ಲೂ ಮೇಲೆ
ಪರಿಣಾಮ ಉಂಟಾಗುವ ಸಾಧ್ಯತೆ ಇರುತ್ತದೆ. ಇದರಿಂದ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ 1959 ಸೆಕ್ಷನ್ 4 ಉಲ್ಲಂಘನೆಯಾಗುವ ಸಾಧ್ಯತೆ ಇರುತ್ತದೆ. Violation of section 4 is there. There may be a reason condition that it may violate section 4, your lordship. ಅಲ್ಲದೆ ನಬಾರ್ಡ್ ನಿಬಂಧನೆಗಳು ಉಲ್ಲಂಘನೆಯಾಗುವುದಿಲ್ಲ. ಕಾರಣ ನಿಯೋಜಿತ ಸಹ್ಯಾದ್ರಿ ಉದ್ದೇಶ ಸೊ ಅಂಡ್ ಸೊ ಇದಕ್ಕೆ ಷೇರು ಅನುಮತಿ ನೀಡಿದಲ್ಲಿ ಸದರಿ ನಿಯೋಜಿತ ಸಂಘದ ಉದ್ದೇಶಕ್ಕೆ ಕಾರ್ಯಕ್ಷೇತ್ರವನ್ನು ಹೊಂದಿರುವ ಈಗಾಗಲೇ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಸಹಕಾರ ಸಂಘಗಳ ಪರಸ್ಪರ ವ್ಯಾಪಿಸುವಿಕೆ ಉಂಟಾಗಿ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ನಿಯಮಾವಳಿ 1960 ರ ನಿಯಮ ರೂಲ್ 3B3 ಇದರ ಉಲ್ಲಂಘನೆಯಾಗುವ ಸಾಧ್ಯತೆ ಇರುತ್ತದೆ. There may be a violation of section rule 3B3 of cooperative society, your lordship. Hence, there may be a violation of 3B3, your lordship. Maybe. As discussed in the operative discussion point, your lordship, as there is a number of population and already there are 2 societies are in existence.
What is it mentioned? What is the how much population living
population? It is in discussion. It is there, your lordship. Page number 44.
It says how much?
3040 population is there in that village, your lordship. And already there are 2 societies are already in existence, your lordship. So there may be a financial problem ಅವ್ರಿಗೆ ಅರೋಸ್ ಆಗ್ಬೋದು ಅಂತ because as per the report given by the village accountant, your lordship, the population is
finds place in the order.
Page number 44 and 45, your lordship. The chart is there, your lordship.
No, this order is like let him go through this 3-3. Then after at the stage of 3B, then the same order can be passed. No, what this order says here, you collect the share cap, whatever that formality at 3, let it be done. Same issue will come at 3B. So at that time, if he is not satisfying, then rejected.
Millards, also
ultimately same issue will come.
Millards, since
either at 3-3 or 3B, same criteria.
After collection of the shares, your lordship, if again he is not satisfied, same order.
But the impugn order is passed
No,
without
this order, for the sake of an order, you will have this order. Please come.
Millards, one more submission, Millards. The order is passed under section 7, Millards. I am not before the authority under section 7, which talks about registration. I am before him for pre-registration.
What I am saying.
Yes, Millards.
So you are under
Rule 3.
What is this? 3(3)
Yes,
before the
Lords.
authorities.
Now the
When it
author-
comes to 3B, 3B, whatever are the conditions at 3B and the satisfaction at 3(3) is one and the same.
Lords, but the order is passed under section 7. I am not before him under section 7, which is for registration itself.
Whatever is section?
Section 7, my lord. Section 7.
Not section 7. That's 3B.
No, my lords. The impugned order at page 46, my lords, it is passed.
Factors to be considered by registering authority at the time of registration.
My lords, the authority has passed under section 7. He has passed it under section 7. That is also an infirmity, my lords, which talks about registration. Page 46, my lords.
The present petition is filed. Sing the following prayer. This is a case of the petitioner that petition is an agriculturist in the permanent residence of Appachwadi village. The villagers who are deprived of getting government benefits are deprived of getting the government benefits such as financial assistance for development of their agriculture and cultivation of commercial crops. It is stated that the government of Karnataka had taken a policy decision to provide financial assistance to the farmers or the members of the primary cooperative societies without charging any interest. That is 0% interest for the economic development and agriculture improvement of the farmers in the village. Petitioner and other villagers have called Grama Sabha on 29/8/2025. And in the meeting, the problems of the villagers were discussed. And they have decided to have a new society in the form of proposed Sahyatri Vividodesh Prathamik Gramina Krushi Sahakara Sangha Niyamit Appachwadi Taluk Nipani district Belgavi for the welfare of the farmers in the village who desires to become the members of the proposed society. The petitioner, being the chief promoter, has collected relevant documents and presented the proposal to the competent authority. That's respondent number 2, requesting the authority to grant share collection for registration of the new cooperative society by comprising the villages with the area of the operation as provided under Rule 3 of the Karnataka Cooperative Societies Rules. It is a case of the petitioner that Appachwadi village is very near to state highway and there are 30 to 50 kilometers. There are many sugar factories. Stating all these factors, they have approached the second respondent. The second respondent, by way of order impugned, has rejected the case of the petitioner. It is a contention of the land counsel for the petitioner that when they have gone before the second respondent under Rule 3.3 of the rules, the second respondent, without even hearing the petitioner, without considering the contents of the proposal, has rejected the proposal submitted by the petitioner. It is submitted that there are no objections from other societies. It is also the case that the second respondent has not verified the contents, and in fact an order is passed under Section 7 of the Cooperative Societies Act. In fact, the petitioner has not approached the second respondent under
Section 7.
Under Rule 2, under Section 7. Further, land counsel appearing for the petition submits that in an identical set of facts.
Annexure C, my lords, page 47.
In WP number 101599 of 2025.
Annexure D at page 54.
And 100493 of 2024.
And 58, my lords, page.
and WP 108-117 of 2025 were disposed of by the orders dated 23rd June 2025, 6th February 2024, and 21st November 2025, whereby the order passed for the second respondent is set aside, is quashed. And there is a respondent number 2 is directed to grant permission to collect the share amount for pre-registration of society in the name, registration of the society, subject to petitioner satisfying other requirements of law after providing an opportunity of hearing to the petitioner. When counsel appearing for the AGA submits that, considering as per Rule 3, it is subject to the satisfaction of the registrar that the proposed society has reasonable chances of success and is going to be economically viable, then only can permit the chief promoter to collect such amount of share capital. It is submitted that basing on a report from the
village accountant, Your Lordship.
From the village accountant, the second respondent has observed in the impugned proceedings that it is not viable. It is submitted that petitioner is not entitled. It is submitted that the second respondents and the proceedings of second respondents are in consonance with the rules of the Karnataka Cooperative Societies to 1960, and no interference is called for. Next part. Having heard the counsel for the petitioner peruse the material on record. When the petitioner wanted to establish a society, they approached the second respondent under Rule 3.3 of the rules. Rule 3.3 of the rules reads thus: as per the same, as per the above, a bare reading of the above rule makes it clear that before giving the permission to the proposed society to permission to the chief promoter to collect the amount of share capital from the members, the registrar has to be satisfied that the proposed society has reasonable chances of success. It is a contention of the learned counsel for the petitioner that when the petitioner approaches the respondents for registration under 3B, approaches the respondent for registration, then the Rule 3B will come into effect, where they has to consider the population in the area of operation, assessment of economic and financial feasibility, like collection of share funds from the shareholders, also overlapping of the existing similar cooperative societies. According to the petitioner, it is not open to the second respondent to consider all this at the stage of collecting the share capital from the members. The provision section, the Rule 3.3 gives the power to the registrar to be satisfied on the viability. It is a case of the petitioner that the petitioner have placed several other factors to show what is the viability, and those aspects were not considered. In the judgments that are relied on by the petitioner, the coordinate benches of this court have considered and have observed that a reasonable opportunity needs to be given to the petitioner. It is also observed that all these are subject to the petitioner satisfying the other requirements of the law in the light of the orders passed in in WP number 101599 of 2025 by coordinate bench of this court. This court is passing the following order. The impugned order dated so and so, passed by respondent number 2, is quashed. The respondent is directed to collect the share amount for floating of the shares
Appear before respondent number 2, Your Lordship.
granted for permission to collect the, respondent number 2 shall grant permission to collect the share amount for pre-registration of society in the name of so and so that you extract, subject to petitioner satisfying other requirements of law after providing an opportunity of hearing to the petitioner. The petitioner shall be present before the second respondent on
28, my lords.
on 28 January, 28/1/2026, without further notice from respondent number 2. Yes.
My lords, even with regard to Rule 3B, my lords, in the third judgment, it has been considered, my lord. There is a finding on Rule 3B as well. Yes, my lords. Grateful, my lords.
Yes.
Yes.
Yes, seal number 74,
My lord.
Sadiq and Goodwall.
Ink page 7 is my prayer. Seeking quashing of annexure E. Annexure E is at ink page 22. My petitioners are directors of respondent number 5. Before making my lord,
Question the impugned order dated 26/12/2025.
yes. Disqualifying the petitioners. I have been disqualified for 5 years. Before making my lord submission on merits, my lord, I have an alternate remedy before respondent number 3. My lord, I have challenged this order. My lord, without application of mind, this order has been passed.
No, without application of mind is always,
So, my lord,
there can be an appeal.
what they have done is, my lord, I said because there is an appeal remedy. In my lord, for 13 days, they call 3 meetings and say that I have not attended. Therefore, they have disqualified me. Within 13 days, they call 3
There
meetings.
is no application of mind, then only you will get an opportunity to come before any of the forums. So that can be done by before the appellate, which is the appeal
106.
106 of the Cooperative Society.
Yes, ma'am, before respond number 3.
Go there. The present writ petition is filed, questioning the following prayer. Land counsel appearing for the appellant submits that, but petitioner submits that the impugned order is passed without application of mind.
Give it, man, give it.
And by virtue of this order,
Petitioners are disqualified for 5 years.
petitioners are disqualified for a period of 5 years. Land counsel appearing for the, which respondent?
Lordship, he is caveated, Your Lordship.
Not, I undertake to not appear for the fifth respondent.
You are for the fifth respondent. Learned AGA
1 to 4.
representing 1 to 4.
Please.
Submits that the petitioner has an effective alternative remedy under section 106 of the Cooperative Societies Act, and the present writ petition is not maintainable. Land counsel, in response to that, land counsel, the petitioner submits that as there is no application of mind while passing the impugned order, the petition, though there is an alternative remedy, petition has come before this court. Land counsel appearing for the fifth respondent, so and so, submits that the petitioner has an effective alternative remedy under 106. This court has perused the impugned order. When the act provides for an effective alternative remedy, this writ petition is not maintainable. And further, in spite of an alternative remedy, when the petition is coming before the court, there should be there should be a specific reason why this court should entertain the writ petition. The reasons that are stated by the petitioner cannot be the grounds for this court to interfere. Accordingly, disposed of giving liberty to the petitioner to avail the appropriate remedy before the third respondent under 106 of the Cooperative Societies Act. Yes.
Lordship may
For
further
75?
observe that if appeal is filed, it may be considered in concordance with law.
That anyway they will do, for that direction is not.
There is a direction, my lord, they will do it. Therefore, I am requesting.
Otherwise also they will. Otherwise also they will.
Otherwise also they have to do.
They have to do it, but if there is, my lord, they will do it.
Yes,
Therefore,
75.
75.
Yes, next.
Rajkumar.
The beg to appear for the petitioner. The petitioner have filed is present instant seeking not to demolition, not to dispossess without due process of law. But the facts of the case is, my lord, in there, my lord.
Before we go there,
Lord.
let's see who are the respondents.
Please, my lord.
Who are the respondents?
My lord, the respondents, my lord, the respond 8 and 11, my lord, they have executed a registered lease deed in the year 1941, granting, my lord, land in favor of, my lord, the petitioner for a period of 9.
Interfering with your possession.
My lord, the respondent number 10 and 11 interfering. My lord, they have filed a suit for eviction. That suit came to be dismissed in the year 2015. After dismissal, but taking law in their own hands, my lord, they have started interfering in demolition. Then immediately I filed a suit 2 of, my lord, 2025. There is an interim order about temporary injunction. The temporary injunction, in spite of that, on 21st and 22nd of December, but they have demolished a rice mill and godowns. And immediately I approached, my lord, this honorable court and make a petition to the, my lord, the police authority. Police authority says that it is a civil matter. You have to approach the civil court only. But now the rice mill and the godowns are completely, my lord, demolished. Now the residential house.
No, let me understand this. 10 and 11 are unofficial respondents.
Unofficial respondent.
So if they are interfering with your possession, why should you come before this court?
But I already come to appeared before the civil court by obtained a temporary injunction. I brought the notice of the police authority to give a protection that already there is an injunction. In spite of the injunction, respondent number 10 and 11 demolished the rice.
The very same issue, in spite of an injunction, if you want a police protection, the same application can be filed before the court. Why should you come before this court?
But only that is true, my lord. The police authorities are not what I have approached the police authority. Police authority said it is a civil matter, but limited purpose.
Go to the police authority, file an application before in the very same suit, where you have a interim injunction in your favor.
That is true, my lord. But now there is, my lord, there is a threat of the demolition of house and, my lord, shops. Therefore, limited.
No, not limited. When there is a way to approach the court, we can't interfere in every matter under 226.
Now,
That would be setting a bad precedent.
My lord, I made a representation to all the authorities, police authorities, my lord, Annexure N. But they have to consider my representation and to protect. Police are supporting my difficulty is police authorities and the local authorities are support.
In the light of the fact your suit is pending and it is not even a old suit, you have got an injunction recently. Whatever your remedy against the police for implementation of the order, it has to be by the civil court.
That is true, my lord. That is true. But the seeking a violation of temporary injunction is a different. That is true. Violation of temporary injunction. But
seeking police protection also falls under that.
But now.
For implementation of the
Now
order.
my fundamental rights, my lord, they are trying to demolish, my lord. They are trying to demolish. Not
Service your
demolition.
state law remedy is already pending. When that is, you have an effective remedy there.
That is true, my lord. But the
Please proceed.
standing residential house.
Please come. The present.
My lord, may have concepts. Limited time. Status quo, my lord.
No.
Otherwise.
Expanding the scope of 226 by doing all this.
Otherwise, they will complete, my lord, identical matter. Sorry, my lord. I'll furnish one.
In spite of that, I can distinguish and pass an order. Take it. Because I'm not inclined to pass that kind of orders. Everything like the 226, there is a purpose behind it. We can't convert it into a suit. We can't convert it into an IA.
My lord,
if you want, I can adjourn it, but no interim order.
my lord, let me prefer notice at least.
Notice.
Please. Emergent notice.
1 to
yes.
Lord, all respond number 1
9
to
I'll take.
1 to 5 government, my lord.
1 to 9, your lordship.
1 to 9. 1 to 9, AGA takes notice for the other respondents. Look at the
10,
number.
10, 11, 12, my lord, emergent notice.
Issue notice.
Please, my lord. Much obliged. Grateful.
Bill number 76, AB Patil, Dharwad.
Petitioner is the judgment debtor, your lordship. I am ready to pay the amount, Your Lordship, and need breathing time for some time, Your Lordship. The trial court, executing court has issued sale of proclamation, Your Lordship. That is tomorrow, Your Lordship. In this at least 2-3 months. There are 2 matters, Your Lordship. Already one matter is closed, Your Lordship.
What
Last
is it?
month.
Let's look at the
Each
implement.
matter in respect of 10 lakhs amount is there, Your Lordship. There is nothing dispute, Your Lordship. Only I need some time, Your Lordship, to pay the amount.
While passing the orders of file number 2,
Yes, Your Lordship.
hence rectify the same perusal under order 21. During proclamation, the date of sale and place is to be specified. Mistake is rectified. Accordingly, the date of public auction of the sale of property, its spot sale is fixed at 14/1/2026. The sale of property is fixed at the premises so and so. So what is to be done according to you?
Your Lordship, at least 2-3 months time is given, Your Lordship. I will pay you, Your Lordship. There is 10 lakh amount, Your Lordship. The earning money is, Your Lordship, 3 lakhs in this matter, Your Lordship. Earning agreement money is 3 lakhs, Your Lordship. For that property has filed a suit for specific performance. I am the bona fide purchaser, Your Lordship.
You're asking the court to do
Yes.
the impossibility. Yes.
No, Mala, this case is specific for a suit was filed by me
Which year
in
is the suit?
2016.
Your Lordship,
And
it
the
is-
intended compromise 2024 for 10,98,000 with a condition to repay it within 3 months, failing which carry the interest of 12%. He did not pay. Even after taking 18 months time, he is not compliant compromising. And I am not interested in execution Mala, because I want my money. Mala, so that's why only on technical ground going it's adjourned. So if my friend undertakes here, brother, he'll pay it before 31st March. If undertakes, if that undertake.
Affidavit. You're taking affidavit before this.
Yes,
court.
Mala, 31st March.
There are 2 matters, Your Lordship.
In both the matters you filed.
Yes.
Please.
If undertakes, Mala, I am not interested in this.
What I'll record is like whatever is money, the decretal amount
Yes.
as on today, along with interest, if you're ready to pay by 31/3/2026.
Yes, Mala.
They shall be stayed.
Your Lordship. One matter 31/3 and another one matter 31, April or May, Lordship. Because there is first matter.
Oh,
there
one
is no-
matter he says March.
Yes,
Other
Lordship.
matter
Another
it
one
is
matter
May.
is May, Lordship.
No. ಅದು ಆರ್ಡರ್ ಆಗಿದೆ ಅದರಲ್ಲಿ
Yes,
In both.
same. ಎರಡು matter 76
All
and
that
77.
matters are compared one same day, Mala. If they take it, because instead of March, Mala, let
In
me
both
take
matters-
some risk. I'll go to 30th April. In 31st, if they undertake this one, that's one.
Please, Lordship.
31st March and 30th April, that last working day for the, because why,
Will you file the affidavit?
let him file affidavit.
Tomorrow I will file, Your Lordship, subject to filing of the affidavit, order may be passed in Your Lordship. There is tomorrow sale proclamation is there, Lordship.
When is the auction?
It's tomorrow, Mala.
For 14.
Yes, Mala.
Yes, Your Lordship.
The land counsel appearing for the petitioner submits that in both the matters.
Please, Your
In
Lordship.
WP
76
76 and 77.
77, please, Lordship.
Submits that, he is ready to deposit the amount, the decretal amount. It is submitted that he requires some breathing time. In 100239, he requires time till 31st of March. In WP 100240, he requires time till 30th of April 2026.
Number head, correct number head, yeah. Please correct that,
Which
do
date?
correct numbers, which is 31st and 30th April.
Which one 30th, which one April, which one March?
First matter 2000, first matter 30th
30th
March, Your Lordship. 31st March, please, Lordship.
Second matter 30th of April.
April.
Maybe, Your
No, Mala,
Lordship. 2 months.
That's more than
Next 1
sufficient,
month,
because I am reasonable.
What would be the
10
entire
lakhs, Your
amount,
Lordship.
huh?
10 lakhs, Your Lordship. In each matter 10 lakhs, more than 10 lakhs, Your Lordship.
In both the matters put
Yes, Your
together.
Lordship. Each matter 10 lakhs.
Each matter 10 lakhs.
Yes, Your Lordship. Next matter 31st maybe Your Lordship.
So
2
by
months.
1st of May,
Please,
by 1st of
Your Lordship. 31st May.
15th of May,
Please,
in
Lordship.
the second matter by 15th of May, he is
Yes.
ready to pay the entire amount.
Please.
In this regard, the petitioner shall file an undertaking affidavit before this court by tomorrow.
Yes, ma'am.
Please.
If the undertaking affidavit is filed
Please.
by tomorrow, at what time is the sale?
No, it will be then on the spot sale, it will done at spot, Mala.
If the affidavit is filed.
Yes,
yeah, undertaking affidavit is filed
Yes, ma'am.
and served on the
Yes.
respondent
Yes.
by 10 o'clock. tomorrow.
Yes.
The auction shall not be
Yes, yes.
conducted. List this matter on Monday.
Yes, ma'am. Please.
Thank
Yes.
both matters.
Hand delivery maybe, Your Lordship. Interim.
Hand delivery of the order
Yes.
is permitted.
Please.
Preliminary hearing B group matter, seal number 78 urgent, seal number 79. UG Kattimani.
Yes.
Petitioner is a businessman, petty businessman, filed a representation before the respondents seeking direction to the refund the amount, my lords. Annexure A is the page number 10, my lords.
Yes, have you seen?
Your Lordship, first time matter, Your Lordship. First time, Your Lordship, fresh matter.
Notice.
Notice is.
Matter this is.
Notice have served.
Notice is not. Have you
Served,
served a
served.
copy?
Notice.
Copy served.
Sir,
Please.
you have the copy?
No, Your Lordship.
The respondent shall get instruction by 5th of February.
Please.
This
Please.
is March on 5th.
Seal number 80. Nagaraj Appannur.
Please, lords.
Challenging the annexure M, Lordship. Lordship, petitioner is challenged the election process, Lordship, conducted by the second respondent, Lordship. Lordship, in earlier occasion, Lord, members of the Sangha, Lordship, has prepared a writ petition.
Hold elections afresh, including district committee, taluka committee as contained in bylaw in accordance with the law interest of so and so.
Please, Lordship. Lordship, second respondent, Lordship, without inspection of the audit report and all those things, Lordship, proceeded to conduct the election, Lordship. Contrary to the chartered accountant report also, Lordship, without producing any document, Lordship. Lordship may kindly see annexure L, Lordship.
What is challenged before this court, annexure M?
Please, Lordship.
What is annexure M?
This is election result, Lordship.
When was the election conducted?
Election conducted by the second respondent, Lordship.
When?
Administrator, Lordship.
When was it?
Election on 4/5/25, Lordship.
According to you, that the manner in which the election is conducted is bad?
Please, Lordship, since the administrator was appointed, Lordship, since Lordship 2018 and 19.
File your objections to this.
Not at Your Lordship. I'll get
The AGA shall file the objection, the respondent shall file the objection within a period by 17th of February. Please.
Lordship, meanwhile, interim order maybe.
Yes, 81.
Number 81. Sadikan Gudwala. Sangram S. Kulkarni.
My lord, seeking short observation.
This is matter in the month of March.
My lord.
My lordship, I am per petitioner, my lordship. The petitioner invested the huge amount in the construction, my lordship. Kindly keep it in the next week, my lordship.
Next week.
No, you are asking for adjournment.
I am per petitioner, my lordship.
This is matter.
Serial number 81, my lordship.
81.
This is matter in the month of, on 16th February.
16th February.
Shivraj Hiramit filed in a memo for retirement, lordship. This 81, kindly delete.
Where is that retirement memo?
Retirement.
Please give it.
Yes.
Sir.
A memo is filed by the council appearing for respondent number 1. A memo of retirement stating that respondent number 1, Chief Town Panchayat Khanapur, Belgavi district adopted no objection from the council on 8/12/2025 in order to engage the other council. Hence, he may be permitted to retire from the case. And also file the acknowledgement delete the name of, so-and-so is permitted to retire from the case. Delete the name of Mr. Shivraj Hiremat. Print the name of print the name of R2.
In fact, I filed a wakalat from R2.
For R2, you filed wakalat.
My name is already shown. Hanumant Reddy Saukar.
Already Mr. Hanumant Reddy has filed wakalat for R2.
Yes.
Yes, next.
Seal number 82, 83?
Yes, 83.
82, seal number 83. Final hearing matter, Ravindra R. Mane.
For the respondent, my lord.
Where is the counsel for the petitioner? 83. 83. Huh?
I am appearing for the petition.
Yes.
Eighty.
83, Ravindra R. Mane. Suraj Mutnal.
For the
Where is 83?
Final hearing matter.
Ravindra Mane, sir.
No representation on behalf of the appellant. Counsel for the respondent is present. This is matter in the month of March.
I will submit, my lord, on the next week, any date, my lord. It is a 2022 matter, my lord.
But what to do?
Suraj Mutnal.
Any date in the next week, my lord, I'll.
Yes, let's just matter next week.
Next.
Please.
Oh, insurance company is in appeal.
Insurance.
This is matter for dismissal, no representation. 83.
R. Mane. Submission.
Serial number 83.
83.
Yes.
My lord, can you post it next week, my lord? Because I have to rely on certain judgments, my lord. I have to come physically. Today I am not well, so I could not come. Next week, my lord, I will. Any day.
Yes, 84.
84. Seal number 84. Bahubilian Kanabargi. M.K. Saudagar.
No representation. This is in the month of March. Yes. 85.
Number 85. Harish Maigur.
Appearing for the appeal.
Which is the insurance company?
It's my brother.
Yes.
These two claim petitions, my lords, appeal were filed by the my lords son, parents and in-laws of the my lords.
What are the numbers? First is?
First, my lords, first number MFA 105533 is arising out of MEC 1238/21. It is filed by the my lords deceased Yellappa. Filed by the my lords parents and his son and in-laws, my lords.
Then next one?
Next one, my lords, death of my lords, his wife, deceased Yellappa's wife, Rupa. It is filed by the my lords parents, son and my lords, her parents.
Now in the accident, both wife and
Yes,
husband died.
yes.
As far as the husband is concerned, husband's parents
Husband's
and the
son
were the claimant.
and in-laws also.
They have made a party to
One
the
second,
in-laws. also.
one second.
MVC 1238.
Yes,
In both the petitions, my lords, in-laws, parents and son is a party. 5 persons are party. Please. My lords,
No,
in,
on what ground you are before the court?
my lords,
now for
before your
enhancement?
lordship, my lords, in first case 105533, he's agriculturist having 6 acre 9 guntas of land.
You are seeking enhancement of the compensation.
Yes.
No dispute with regard to the apportionment.
No dispute, but my lords, in one case, my lords, deduction in his son case, Yallappa's case, 1/3 is deducted, ought to have 1/4. Because here,
Cannot consider the mother-in-law and father-in-law as dependents of.
but my lords, there is an evidence, but apex court in one judgment, on the last occasion, your brother lordships have produced that document, ruling of the apex court. So I am going to leave it to your lordships. I am not.
Consider that mother-in-law and and they can't be dependents. They can't be dependents and
But
we
it
can't
is,
get
my lords, in
any-
Indian, my lords, in villages.
in either consortium or that we can't give to the mother-in-law. or
Yeah,
father-in-law.
yes. And my lords,
In case, like, in case of the daughter, then we will consider.
yes.
So far, considering the Yellappa case, my lord, that they 3 hours were the dependent. Mother-in-law,
I-
father-in-law,
that's why
they
we
are
are-
not legal, they are also not entitled to any compensation under, in this case.
Oh, what we do is, please come to the table in MBC 1238.
My lords, here, my one contention in
Straight away come to the table, then you can submit.
Yes, ma'am.
1238, my lords, at page number 32, my lords,
Paragraph number 17.
para 17. My lords, loss of dependency.
Only son and the parents of the deceased or the claimants.
Yes.
Which is-
No. And in-laws also claimant here.
That is, but we have to now,
But my lords, so what?
who
my
has
lord?
considered them as a dependent?
No. That's why under head of consortium.
Consortium, mother-in-law, father-in-law, how can the consortium be granted?
Please, leave it to your
Now
lords.
in every case.
No.
Mother-in-law and
It is my
father-in-law.
contention, my lords.
So
Because
in that case, if you don't want that, loss of dependency has to be revisited or not? Loss of dependency, we have to calculate or.
once again, we have to recalculate it because
So please tell the court now, which year is the accident?
2021.
How much was considered by the?
My lords, 14,250.
As per chart. As per chart.
One second, please.
As per chart, I just, I'm not intervening your argument, just ask.
My lords, I have relied, my lords, exhibit P23, record of rights, having 6 acre 19 guntas. My lords, in the absence of that, my lords, that chart will follow. It is my submission is that, my lords, here, my lords, he's having 6 acre 19
What
guntas.
is the income is deriving out of it? What is the evidence for that?
My
There should
lords-
be something, how can we calculate without that?
Leave it to your lordships. But, my lords,
Don't leave it to
one
the-
contention
Don't
is,
leave it to the court. Whatever argument whatever you
my
submit,
contention
take
is,
it to some logical end.
my contention is that, my lords, he's having 6 acre 19 guntas of land.
So now it is about, no, because he is not there, it is not, only the son will succeed, he will earn out of it.
Yes.
Isn't it? That
Yes,
amount.
ma'am. But his services cannot be, my lords.
That is for that, this
My
amount,
lords-
whatever the court is granting at 14,250 will serve the purpose.
According to me, my lords, income ought to have taken much more. Is my submission.
He's an agriculturist.
Yes.
That's why, because there is no other evidence on record, court is taking, whatever the land that is available, the son will also do. So as far as loss of dependency is concerned, there is nothing to interfere. 227,13,200. Funeral expenses 36,000. Then consortium already court had granted on the high. It's 44 into 3. How much it is?
1,32,000 it will come.
44 into 3 is 1,32,000. So if we calculate, it would be less than what is granted, I think.
No.
12,000 is enough.
No,
27
1/3
lakh,
deduction is already.
13,200 plus 36,000 plus 1,32,000 plus 10,000. It comes to 2 lakh, that's what I said, 28 lakhs 91,000.
Here, 28 lakh.
Marginal
66,000.
enhancement.
Hmm?
Marginal,
Marginal.
please.
In that 10,000 are legal expenses.
No. In that case, death case, my lords, what?
Oh, I have granted 10,000 legal expenses. That's why it is made, it's coming to 28 lakh 91,000. Otherwise it would be 28 lakh 81,000. Court has granted 66,000. Yes, next.
According
Next
to chart,
case, my lords.
according to chart, we have to follow. Then, if you have followed the chart, then would enhance it probably under the head of loss of consortium that to 12,000.
That's what.
Yes. There is no legal.
No. There is, it's a basing on a
No,
judgment
we have already paid the entire amount there in trial court only.
that you can challenge always. I've
No,
been consistently.
no, that award is already just and reasonable, so we have complied it. Preferring appeal, again the preferring appeal, it doesn't arise in this case. So under such circumstances, the legal expenses will pay for the
Legal
preferring the appeal.
expenses, I am granting in all the matters, I have granted in hundreds of cases. So now this is, case is not one exception.
No, Generally, if it is arise that to prefer the appeal, then it may be considered.
Yes, what is that?
If it is, trial court has not reasonably awarded, then if you prefer the challenge quantum, then my lord, may consider for the legal expenses. Here already court is sufficiently granted.
That's not the purport of the judgment of the apex court in Malathi. Yes, now come to issue now, this MVC 1239.
1239, my lords. Aged about 22 years.
Anything to be looked at, loss of dependency?
And loss of dependency, my lords. Here, tribunal has considered age of the younger parents. Age of the younger parents. Here. A son is also, my lords, there.
Now let's see. What was the age of the deceased?
22 years.
20?
2.
You said accident is in the year?
21.
21.
Yes.
14,250.
Yes.
Plus 40%. Future prospects would
Yes,
come to 5,700. 250. It comes to 19,950.
But here, my lords, deduction, what my lords has opined, there are 5 dependents. Leave it. My contention is that, my lords.
Already mother and father are considered as a dependent in the earlier case.
But
in
here,
this case, trial
death
court has
of
considered
daughter.
Only the son is a single dependent. So 50% is deducted in this case. Mother, son is only the dependent in this case, madam. Out of this.
What is the evidence that is written with regard to the mother-in-law and daughter?
No, that para 13, my lord.
Para?
Para 13, where it is specifically stated about the petition number 4 and 5. Internal page number 19. In 4th line, madam, issue the petition number 4 and 5 being the father-in-law and mother-in-law were having their independent family and were residing in their family. So they are not been residing with this deceased family. They are residing with their family and they have the independent earnings.
What is the multiplier?
Multiplier is 18.
18.
It's coming to 21,54,600.
No, my lords. Deduction.
50%.
No. Ought to have, my lords, 1/3 because one judgment of Supreme Court and a division bench of this honorable court, Sarala Varma, by relying Sarala Varma, my lords. So 1/3 in case of married, 1/3 deduction has to be made.
Where is that? Let's see.
That judgment is misplaced.
So
I will
Saral
produce.
Varma judgment is very clear. Saral Varma judgment is very clear.
Sarla Varma says one and above.
No. That
Married.
interpretation is, my lords.
Okay, what it says is.
My lords, 1 second.
2 to 3, 1/3.
Yes.
No. Recent Supreme Court judgment also, my lords. I am very sorry, my lords. It is with me, my lords. 2025, page 726, my lords, where in Apex Court, confirming the order passed by the Orissa High Court, held that in case of married, 1/3 deduction is proper. So,
In case of marriage, that is if I have also passed orders.
Last
the
bench
principal
also-
bench, if the wife or the husband or the claimants, then it's a different case.
no, my lords, here minor son is there. Because in case of married, it includes, my lords, everything, my lords.
Because I have also passed orders considering
Last
1/3.
last bench, division bench has also considered this
Because
aspect and considered
Apex Court
50%. 50% for if he is married and single dependent is.
No. In several matters, I have
Yes.
passed orders
Yes.
where I have considered 1/3 in case of a married person.
Married. No.
It is only that 50% should be in case of unmarried.
No. In Saral Varma, if you are last, in my case only division bench has to discuss this issue. And if he's married,
Judgment, get the judgment.
Babita, my lords, 2024 is.
Get it.
Please.
This is matter on Tuesday. as partner.
Please.
Tuesday.
That the
Then,
calculation is.
my lords, what about my lords in-laws? When they are residing together, it is my lords.
What is the evidence, please tell?
Please. I will, so, please.
Yes.
Seal number 86. Baswaraj Matapati.
Claimant's appeal, your lordship, for seeking enhancement.
Who appears for the respondent?
My lord, the respondent is, my lord, the summons is served and not represented.
Owner of the vehicle.
My lord?
Insurance company is there.
No, your lordship, the private parties, your lordship.
Only owner of the vehicle. Yes.
My lords, I have produced the additional documents, the medical
But
bills.
this
your
has to be considered now.
My lords,
How can we consider all this without any evidence?
lords, may I pray for remand back the appeal to the tribunal. Your lordship.
Please come. The present appeal is filed. Agreed with orders passed in MSC number 152 of 2022, date 31st August 2024 by so and so. The tribunal has granted compensation of an amount of rupees 25,000
Globally.
globally. The land council, an application is filed before this court under order 41 rule 27, whereby he has placed before the court certain documents to show that he has spent money towards treatment. All these documents, this court cannot consider without letting in evidence. In that view of the matter, the award, next before that, though notice is served and the respondent none appeared. Hence, this court deems it appropriate to set aside the award date so and so, and remand the matter to the court for fresh consideration. And all the contentions are left open. And the petition is liberty to mark these documents subject to the law of evidence. Yes.
Grateful, your lordship.
And the court, without further, the court shall dispose of the matter as expeditiously as possible. Yes, next.
Unlayering matter, seal number 87. J. Shetty. MB Kanvi. Lord.
Matter pertaining to the order passed by the Work Tribunal under section 83 of the Work Tribunal Act, Work Pact, wherein the present respondent has filed a suit in
Work
the
board is the petitioner.
Malad,
Work board is the
Work
petitioner.
board is the petitioner. The property in question, Malad, has been registered as a work property. Property in question, Malad, has been registered as a work property. And they filed the suit before the Work Tribunal. The said suit has been filed under before annexure D, annexure.
We'll read the order.
Before that, short point, I will want to, before going to, before, only question is, whether the suit filed by the respondent before, the court is maintainable or not. It is only the question.
Whether the Union of India can maintain a suit before the
that is not the question. But I am saying that this is the suit filed beyond the period of limitation, as prescribed under the Work Pact. The Lordship may kindly see the annexure B, annexure D, copy of the plaintiff, annexure C.
Please refer to the page numbers.
Page number 59. It starts from 53. The relief sought for by them is at page number 59. What they are seeking is, it is declared that the Gazette notification, page number 59, Lordship got it. Page number 59. The relief which they have sought. It may declare that the Gazette notification dated 5/8/2008 of registering the suit properties in their register as work wide so and so dated.
When is the suit filed?
My lord, suit has been filed on 20/2/2013. Next page, page number 60. 20th February 2013. 13. Yes, my lord. What they are seeking that 2008 is the gazette notification. That should be declared as my lord, null and void. That suit has been filed in the year 2013. My lord, there is undisputed. These facts are undisputed.
What, according to you, what is the limitation?
My lord, the limitation, my lord, as provided under my lord, the then act is my lord, only 1 year from the date of my lord, the notification. Your lordship may kindly see the section.
No, you do it on your own unilaterally. How will the other party will know about it?
My lord, my lord, it is not the fact that my lord, they were not aware of it.
Let
They-
us know, let us see.
Yes.
How, when they know, when they came to know about it.
My lord, that's a page number. Your lordship may kindly see the page number. The explanation, my lord, which they have given, my lord, page number 57, para 8.
Yes.
My lord, in fact, 7, it is submitted, it starts, my lord, it's submitted that now by taking undue advantage of illegal entry of the suit properties. And my lord, 2000, para number 6, my lord, they have mentioned the other details.
The
So far as the
defendant number
registration
one
is concerned.
got registered the work behind
Yes.
the back of the
Back,
plaintiff.
yes. Then, my lord, they say that it is submitted that after learning the said fact of illegal registration of the work pact, by showing the suit property as the ex property, the plaintiff had addressed a letter to the defendant number 2 on 5/10/2010 and thereby requested to get cancelled the registration. Registration certificate, registration of the
Of
defendant.
action, what did he say?
Yes, my lord, cause of action, my lord, what they are saying that. My lord, page number 58, page para 9.
17/3/2011,
17/3/2011
when the defendant number 2 issued a letter,
issued a letter. My lord, that can, whether that can be a cause of action.
then they have issued a legal notice on
Yes.
13/10/2012.
30/10/2012. My lord, whether that can be considered as a, my lord, cause of action for filing this suit. That is the question. Your lordship may kindly see the so far as, my lord, the gazette note issuance of the gazette notification is concerned, my lord, there is no dispute as such. It is on, my lord, 5/8/2008. And, my lord, even according to them, they came to know about, my lord, the same entry on 5/10/2013. My lord, even according to them, my lord, it is, my lord, stated at page number 58, at para number 8. So, my lord, if that is the case, what is the time period, my lord, for filing up, my lord, the suit before the work tribunal? My lord, I want to, in this regard, I want to bring your lordship's kind attention. My lord, section 6. 6.
Section?
6 of, my lord, the work pact,
Yes.
1995 act, my lord, in fact it is. 1 minute. Dispute regarding work. My lord, your lordship, got it, my lord, page, section 6. If any question arises, whether a particular property,
6.
6, my lord, yes. If any question arises, whether a particular property specified as a work property in the list of work is a work property or not, or whether the work specified in such a list is a Shia work or Sunni work, the board or mutawali of the work or any person aggrieved may institute a suit in a tribunal for the decision of the question and the decision of the tribunal in respect of such matter shall be final. In respect of such matter, it shall be final, provided that no such suit shall be entertained by the tribunal after the expiry of 1 year from the date of publication of the list of work. My lord, even according to them, my lord, the list of work was published on 5/8/2008. They came to know about the said fact on 5, my lord, it is according to them, according to the plain governments itself, that they came to know about the same on
Yes.
5/10/2010. They have issued a notice, my lord, issued a letter on that date. So, my lord, for all practical,
How was that decided by the Tribunal.
Tribunal has not considered that aspect.
Have you raised that? Aspect?
Yes, my lord, we have raised the contention.
Where is that?
Yes. But the question is, my lord, another aspect, my lord. Right, your lordship may kindly page number 19
Yes.
regarding the issues, my lord, framed by the work tribunal. Where the plaintiff proves that the gazette notification dated 5/8/2008 and inclusion of the suit property as the work property is illegal, null and void.
Suit is barred by limitation.
Whether the suit is barred by limitation is the my lord, one of
Who
the
decided?
my lord, the findings of the work tribunal. My lord, at page number
With regard to issue number 4.
issue number 4, my lord. Page number 44, para 41.
Please read.
It is further contention of the dependents number 1 and 2 that the suit is barred by limitation as the suit has not been filed within 1 year from the date of gazette notification. The dependents to substantiate the same have relied on the notification, etc. Now it could be inferred that the plaintiff had addressed a letter to the dependent number 2 on 5/10/2010 requesting to cancel the certificate of registration by inclusion of the suit property as work properties. But dependent number 2 had issued a letter dated 17/3/2011 stating that the board by its own order cannot revoke its registration as per the Work Act 1995. Therefore, the plaintiff has approached this tribunal by way of filing the declaratory suit in the year 2013. Malad, that is the reason, Malad, which has been. So also the cause of action as a result to the filed suit when the notice dated 31/2012 was not replied. Therefore, in that context also, the suit is well within time. Malad, how can it, Malad, when the act says that it is from the date of gazette notification.
Court has
Malad,
that the limitation was calculated from 30/10/2012.
yes, Malad, in fact, limitation is Malad 30/10/2012. Malad, it has been taken into consideration by the tribunal. That is not, cannot be, because
It's a continuous cause of action. Initially on so and so date.
Malad, in fact,
Then there was further correspondence between both.
When the act specifically states that, Malad, Lordship, that's why, Malad, I want to bring your Lordship's attention regarding the another provisions. When it becomes a final, when the gazette notification, Malad, issued, Malad, it becomes final. That is also a crucial to, Malad.
No, that's what the act says. How
Act
could
says.
any, no, you people sitting in your office, you declare some property.
No,
as
Malad,
a work
that
property.
may be, Malad, that available, that may be, that fact may be available to them, Malad.
So in that case,
Yes.
it's from the date of knowledge.
Yes, it is from the date of knowledge. What I am saying there, it is from the date of knowledge. Even according to them, Malad, the date of knowledge is that, Malad, on, Malad, even according to the,
But that is on the question of limitation. Then
no,
the
on 5/10/2010.
that is of the matter, what is the case?
Malad, on merits also, Malad, we have got, Malad, case.
That also you
Malad, yes.
submit.
In fact, your Lordship may kindly see the, before that, Malad, I want to bring your Lordship kind attention. Malad, section,
Yes.
Malad, 6 subclause proviso, Malad, your Lordship may kindly see.
Yes.
It says that provided that such suit no such suit shall be entertained by the tribunal after the expiry of 1 year from the date of publication of the list of work. So, Malad,
That I see.
yes. Then, Malad, provided further that no suit shall be instituted before the tribunal in respect of such properties notified in a second or subsequent survey pursuant to the provision contained in section 6 and 4. Then, Malad, then in fact, section 5, Malad, in fact, section 5 may also be.
Yes.
5(2). Become final ಅಂತ ಹೇಳಿದೆ ಅಲ್ಲ. The
No, whether this notification
yes,
is in consonance with section 5 of the Work Act.
section 5(1), yes, Malad. Section 5 as well as, Malad, section 38. Malad, Lordship may kindly this 38. 38, my lord, it should be read in consonance with my lord. It is my lord, your lordship may kindly see the register of work. Thirty-six, my lord, 36. Your lordship may kindly see the annexure B. Annexure B may kindly be seen.
36, 14, we'll read complete this
Yes.
registration.
Page number 36, my lord.
Yes.
36, my lord, is regarding the registration. Every work, whether created before or after the commencement of this act, shall be registered at the office of the board. Application for registration shall be made by the Mutwali, provided that such application may be made by a work on his or his dependents or the beneficiary of work or a Muslim belonging to the sect to which the work belongs. An application for registration shall be made in such a form.
Is it relevant?
Malad, in fact,
What is relevant is notifying the proper.
yes, what is relevant is Malad notifying.
Notifying a property
Yes.
as a work property. That
Yes.
is,
How to Malad get it registered
that
is,
is registration of work,
Work.
but registration of the property.
yes,
Notifying the property are two different things.
yes, Malad, registration of the work as well as Malad, registration of every work, whether created before or after. Malad, it says that it is required to be registered. So then Malad, it is registered in accordance with the provisions of section 36. It should be read Malad as registration under section 6.
Was this work registered?
Malad, that is Malad, first time Malad, it is registered on 5/8/2008. Before that also it is a work.
5/8?
5/8/2008 certificate of registration was issued.
Then while notifying, while notifying these properties, what is
Yes.
the procedure that is followed?
That Malad, all that has been followed. Survey was conducted and Malad, thereafter Malad, the objections were called for.
Please come to the order. Why
Yes.
the court has,
Court Malad has stated that Malad, in fact, Malad, your lordship may kindly see before that. I want to Malad, bring your lordship's kind attention to page number 47, Malad, 46 and 47. What are the documents produced by the other side to show that they are the owners of the property in question? To counter that, Malad, it is the documents, Malad, which is page number 46 and 47. What they are saying that authorization letter, letter of survey of work property, then extract of survey number 245 to 248, sketch map, and then so and so. No other documents has been produced. But the tribunal Malad, refers to some documents, Malad, which is not at all been Malad, marked as exhibits. And it says that Malad, there was a suit which was filed by earlier Malad, the Mujawar, one Mujawar, before Malad, the civil court, and which is ended up to Malad, the High Court of Mumbai, wherein Mujawar has failed in its.
how this property has become the work property?
Malad, it is by virtue of Malad, it is earlier Malad, it is a property belongs to Malad, the Adil Shah of Bijapur. It was Inam was made in favor of Malad, the work. And as such, Malad, this property is concerned, there is a graveyard of the Muslims, several graveyard of Muslims, wherein several tomb was also Malad there since inception. And subsequently, Malad, after independence, Malad, it was declared as a
So that
cantonment area.
read the order. so
Yes,
that
Malad, in
the
fact.
Things will be clear.
Yes, Malad. Page number 20, Malad, in fact, starts. The reasons, Malad, your lordship. Since these issues are interrelated and are answered together,
Paragraph number 35.
paragraph number,
35.
yes. Malad. Thirty-five, Malad, page number 33, Malad, your lordship. The plaintiff, in order to
Number 35.
35. Yes, ma'am. The plaintiff, in order to substantiate as to its claim, further got added that oral evidence of PW1 was quite categorically deposed as to the averments of the plaint in the chief examination part. The learned counsel for the defendants have not elicited anything worth from the mouth of PW1 in the cross-examination part, except some stray sentences. That much has been elicited from the mouth of PW1 in the cross-examination part regarding the authorization of PW1 to depose before the tribunal, which is already been discussed in the above said paras. That on the contrary, PW1 has clearly denied as to the existence of the old graveyards and tomb in the suit properties, but deposed to the fact that annexed to the suit property there is a tomb and dargah, which has been suggested by the learned counsel for the defendants themselves. But even the document which has been produced by them itself clearly shows that it is there is tomb are in existence, apart from there is a dargah. Therefore, that suggestion goes to show that dargahs and tombs are not situated in the suit properties at all. This is not correct. Moreover, it has clearly been deposed that in the year 18,000 itself, in the regime of British, the cantonment area was in existence. That merely because the photos have been shown by PW1 would not suffice to say that dargahs are situated in the suit properties. The learned counsel for the defendant number 2 has made a suggestion to PW1 that regarding the year 1950, the suit properties were registered under the BPT Act as a Devasthan Inam land, and same are being given to the defendant number 1, for which PW1 has pleaded ignorance. But even before that, this is governed under the provisions of the Bombay Public Trust Act. It has been administered by the trust, which has been created by the the charity commissioner was the head of the having the supervisory power under the Bombay Public Trust Act. The defendant number 2, on the contrary, has absolutely not placed any scrap of paper before this tribunal substantiate the same. Therefore, apart from that, nothing worth has been elicited from the mouth of PW1 in the cross-examination part, which would discard the whole case of the plaintiff. Then that on the contrary, the defendants to substantiate as their contention to the written statement got produced the documents exhibit D1 to D7, which are said to be the proceedings of the administrator, certified copy of the registration certificate, public notice, Mahazars, letter of DWAC, Belagavi, letter of superintendent of police, Belagavi, and authorization letter, that these documents would not throw any light on the case of the defendant number 1, and to demonstrate before the tribunal that the tomb, graveyards, and the garden are situated in the suit properties. It's not the malad at all the case of the defendants, the plaintiffs also. That merely because the suit properties are registered under the Waqf board and certificate of registration was issued would not suffice to say that the suit properties are the Waqf properties. Moreover, before issuance of the certificate of registration and registration of the properties in the Waqf, no notice had been issued to the plaintiff, who is the owner of the properties. Therefore, the registration has been done behind the back of the plaintiff. Moreover, the public notice as per Exhibit D3 had not published in the newspaper, and thereby no wide publicity has been given. So also, as per Exhibit D4, no proper measure was done, since the same has been being done in the office of the District Waqf Advisory Committee, Belagavi. So also, as per Exhibit D5, which is said to be the registration of additional properties in respect of Hatti Asad Khan Dargah, Camp Belagavi.
No,
Not
this, at paragraph number 40.
40,
Who
Malad.
appears for the Union of India?
Malad?
I appear for. So at paragraph number 40, this court says, therefore viewed from any angle from the point of oral and documentary evidence, the plaintiff has successfully demonstrated before the tribunal that the plaintiff is a owner of the suit properties and the gazette notification, so and so.
Yes.
What is the evidence faced by
Yes,
you
ma'am.
before the
Lordship
court
kindly peruse.
to show that you are the owner
Yes,
of the
owner.
property?
Yes, Lordship kindly peruse page number 29.
Let's go to 46.
Yes, 46.
46.
Documents which they have.
Well, documents exhibit P3 to P4, that is.
That's what we are looking at. What are the documents? Let
That
us
is
see.
explained
No,
by the.
before that we'll see here.
Please. ma'am.
Authorization
GLR.
letter, it has nothing to do.
General land records, my lord.
Letter of survey of work property, that has also nothing to do.
Yes.
Sketch map, What is this letter of
P3,
CEO
P3
Bangalore?
to, my lord, there is correspondence and other things. Important documents are exhibit P3 to P6, my lord.
P3 to?
3 to 6. Extract from
Survey number.
survey number 245 to 48. These are general land records maintained by the cantonment. The Honorable Apex Court in several judgments, my lord, has held that GLR are the concrete proof of evidence.
The record is there.
Yes, my lord.
Yes, go ahead. What is this 245 to 248? Exhibit 3 to 6.
Whether malad the revenue entries malad would confer any title. That's the another aspect.
My lord, if lordship permits, I'll read one paragraph, it will make it clear, my lord.
It is 3 to 6.
3 to 6.
General land records.
Land register.
Yes, madam. These
I'm
are
looking at P3.
P3, P4, P5, all the three, my lord. My lord, the Honorable Apex Court in several judgments.
No, let's forget about
Yes,
the
ma'am. Yes,
judgment.
ma'am.
Let's forget about.
Yes, ma'am.
Please come to the factual aspect.
Yes, ma'am. General land records maintained by the cantonment board.
What it says?
It says that owner is the central government.
Where do you get all the details? Come to that. You don't have the register? Extract?
Documents, extract.
Area
also-
5.090 acres.
Yes, ma'am.
Description, sanitary cordon.
Hello.
Where do you get the details? That's what I want to know.
In that, my lord, it will be mentioned as a central government, ownership, central government, and there will be one.
And to which property the central government is the owner?
Yes, ma'am. Survey number will be there. Sorry, my lord.
Malad, that
Because-
is,
because-
malad, just before filing the suit, malad, that has been prepared.
No,
Exhibit
no, no,
P.
no. It is 18.
You show it to me.
It is notified records.
Please look at 3 to 6 and tell the court.
Please, please,
Give him the pencil, please mark it.
please. Yes, madam. Column book 1 and 9. Yes. My lord, in all these documents, column number 1 and 9. Column number 1 is the survey number and 9 is the landlord, that is shown as central government.
What is the extent of land in this, in this dispute?
Extent, sorry, madam, because it is there. 5 acres, 9 guntas in survey number 245.
No, survey number 245 will alone not consist of this 5 acres.
Yes, there are 4.
Survey number will have lot of extent of land. No, there should be some identification to a particular property. What is that?
But in this particular land, my lord, these lands are already earmarked. 245 is 5 acres, 9 gunta. Like that, all the 4 properties, the extent is mentioned, my lord. And also in the last column, my lord, lordship kindly see. May I read that portion also, which the tribunal also taken note of. Earlier in litigation, my lord, the matter went up to Bombay High Court, and with cost, my lord, the Bombay High Court has dismissed the suit filed by the Mutawali in a claim regarding these properties as a work properties.
No, he sought for his
Declaration
declaration of
is
his
also
right.
hit by res judicata option.
Unless malad, those documents are produced.
Yes,
Before.
they have produced.
They are not produced. No. What I am saying that now he wants to malad say that malad certain other dispute.
It is there in the record.
No. Other dispute pertaining to malad the
Also
civil
there.
suit between the parties.
That is also
And
there
what
in
he says that he wants to rely upon that document and say that malad is res
the last
judicata.
column, lordship kindly.
So
see.
where that document has been produced?
In all those documents.
Document has not been produced before the court.
That is produced, my lord. In last column, that is explained. The earlier dispute.
This is prepared malad just before malad filing up the suit. Exhibit P3 may kindly be seen. My Lord, Your Lordship, and kindly see exhibit P3.
You can't file this document. You have to file your register.
Yes, registration or otherwise, my
Yes, my lord.
It is
Regarding
nothing-
this
it-
GLR.
It extracts. It is as if like some document
No,
prepared
no,
by
no, my
you.
lord. My lord, lordship, that's why, my lord, earlier only I want to rely on the judgment of the Honorable Apex Court. May I read, my lord? Even the tribunal has also mentioned this one. 3 judges bench of the Honorable Apex Court has held that in not only this case, in several of the cantonment lands cases, the entries in general land register maintained by a cantonment land is conclusive evidence of title.
You didn't understand the court's query. What the court is saying is, I am not on what is the evidentiary value of this extract of the general land register. This is something prepared by you.
No, my lord, this is maintained by the cantonment board.
No, this is something like station Karnataka, so and so 21st
Yes, my lord,
Jan
that is
20.
cantonment board maintained. All these documents are maintained by cantonment boards. GLR.
When it
this
is
document has been prepared on.
Here, something should be mentioned.
Yes, my lord, the notification will be there. Based on the notification, every year, my lord, it will be, the documents will be updated. Whatever, because in this
Cannot,
case.
my lord, on
Kindly, ಇಲ್ಲಾಂದ್ರೆ ನೀವಾರ argument ಮಾಡಿ I'll keep quiet.
Yes.
See, every year, my lord, the general land records prepared by the cantonment board as per the direction of the defense, Ministry of Defense. These GLRs are upheld by the, in several litigations, my lord, upheld by as a conclusive proof of, documentary proof regarding cantonment lands. And my lord, every year why it is prepared and updated is because if any dispute arose, in this case, dispute arose because of their earlier claim.
When is the first entry in this?
That is first entry is 1800, it is there, my lord. That entry is there, my lord. That first
Then what
entry.
you do every year, you update and old entries, where will they go?
No, no, it will not change. Only if any dispute arose, if any changes arose, that one, that is last column will change. Otherwise, the top columns, it will be remain same only.
So this particular property is maintained in your general land register from when?
That is 1800, it is there, man, first record. Yeah. It is mentioned also, my lord, in
But it can't be so vague. By
no,
the
no, my
central
lord,
government.
my lord, not only these GLRs are upheld by the,
They're not saying that what is the evidentiary value.
Yes,
The
madam.
document will not know where from, how will the court understand from when you have generated this on 21st Jan 2013.
Yes.
So they have registered it in the year 2008. From when this particular property is registered in your
in that
general-
case, my lord, the 1800, my lord, it mentioned in the plate itself, the earlier notification copy we have to produce.
That's what, without producing that, by producing some document on 21st Jan 2013, you
Yes,
cannot say that you
but
are-
my lord, yes, my lord, I do understand, my lord, but the tribunal has held that in view of the rulings of the Honorable Apex Court,
We can't
GLR.
apply the judgment of the Honorable Apex Court.
Yes, ma'am.
Isolation. It has to be basing on facts and circumstances of the case. So we can't be, before going into the evidentiary value of a general land register, we have to see when you, no, they say this is registered in the year 2008 or 11, 8 they say.
Ours is 1800. Then we have to get, yes, we have to produce that.
Documents.
Gazette.
And without that, court can, just like that, how can it take it for granted that this land belongs to you? And even on the aspect of limitation also, the findings that are given by the court, there are no specific findings.
But my lord,
in the year 2011, when they have issued a communication to you, you have to question these entries. Why did you keep quiet for an year and you issued a notice to him after 1 year?
but my lord, it is this issue also hit by the res judicata because earlier proceedings.
Judicata, you can't presume sitting in the office. When the property is registered, when they have said that you have to question these entries, your limitation has started rolling from the day in the year 2011. And by creating a subsequent cause of action in 2012, you issue a notice and say that because they have not replied to the notice, so that's my cause of action. No, Your cause of action started in 2011, but not in 2008.
Yes, ma'am. I produced those general land register earlier.
This order needs to go. This order has to be set aside.
No, my lord.
And
my
request
lord,
to be remanded, my lord, for fresh
It is not a one case on such issues. Several of such cases we have done, and in this honorable court itself, my lord, we have got obtained orders in our favor. I produce all those documents and also the earliest notification as far as these lands are concerned. The tribunal itself has mentioned that it is in the year 1800.
Where from they are getting it?
That we have to get it from the defense.
Tribunal, basing on the material before the court, basing on the evidence, let-in has to give the findings. Now, just because making on your oral assertion, court can't say that it is from 1800.
No, my lord, tribunal has said.
Particularly that issue with regard to the limitation without irrespective of this document, that has to go. Because that is not a finding on fact and law.
Because, my lord, the the tribunal has relied heavily on the fact that GLRs are the full proof
Without
of
you
evidence.
producing it.
And, madam, my lord.
Without you producing the original document, it just believes it. Why should we? Because if it is central government, it has its different.
No,
aspects.
my lord. See, these type of GLRs are being produced in several of it is not one.
Can produce. They should be the document from which this particular property. That's a very simple issue. This property is with you from 1890, whatever the time you are saying. That will clinch the issue.
Yes, ma'am. Only one document. Even I also found the gazette notification should have been produced along with this. That should have sufficed.
That is suffice. You didn't do it. And the issue on limitation, how it is dealt with, it is absolutely bad, and that has to go. It is not correct. It's not a reasoned one.
I'll get because I'll go through the documents because the question of limitation now he has raised whether in such cases whether it is whether only work back
even if it is
applicable.
not raised, my lord, section 3 says that it is a bound on duty on the
No.
part of the court. Section 3, my lord, Limitation Act specifically states. Issues has been framed in this case.
Yes,
The court has answered it in a very.
Yes, my lord, I do agree, my lord, but at the same time, my lord, as Lordship also knows, it is all one-sided issues. That's why, my lord, I require some more time to get.
No, that's why. When I said that when you have registered the property sitting in your office,
right.
From that day you can't say that they should be in their notice. But your notice, it has come in 2011. That is on 17/3/2011.
Yes.
Then 30/10/2012 you issue a notice. So from 2000, that is already 1.5 years, you keep quiet.
Well, sometimes what happens, no, my lord, I also, because I am handling several of these defense matters very casually, very casually they'll take and they say these DLRs are sufficient and the rulings is there, something like that. But sometimes, as Lordship pointed out, it requires more specific documents.
When do you want?
My lord,
If that is the case, my lord, he has to, my lord, go before the tribunal also, my lord, to produce those documents.
We'll give him one opportunity. When do you want?
And can you 2 weeks, my lord, so that I'll get the
List the matter on 17th of February.
20.
17th.
Please.
Read from the caption 230.
Yes, ma'am.
17.
Please.
Yes. Passover.
Serial number, list number 1, serial number 58. 58, Malsheti, 58. Shivanand Malsheti.
Give that.
Lord, the first respondent has filed a suit, my lord, seeking for partition and separate position. Annexure A is the compromise decree.
To quash the Lok Adalat compromise final decree dated 13/2/2023.
Please, ma'am.
Who are you?
Lord, I am the, my lord, auntie of, my lord, that respond number 1 and 2.
You are the?
Lord, the mother's sister, respondent number 1 and 2's mother's sister, genealogy, your lordship may kindly see.
No, no, what is the suit for?
Suit for partition and position, my lord, filed by the respondent number 1 against my lord petitioner and respondent number 2.
You were a party to the Lok Adalat award.
Yes, yes, please. I was the party, my lord. The, my lord, respondent number 2 and my lord, 1 and 2 are the, my lord, brother and sisters. My lord, I am the, my lord, wife of, sorry, my lord, mother, auntie, my lord, very sorry, my lords. I am the, my lord, sister of respondent number 1 and 2's mother. I am the sister of respondent number 1 and 2's mother.
The maternal aunt of the.
Paternal property. Lord, in that, Lord, they are both, my lord, respondent number 1 and 2 have agreed.
Before going into that, you are a party to the compromise decree.
Please.
On what ground you are challenging it?
Lord, respondent number 1 and 2, my lord, they have undertaken, there is a condition in the compromise decree. They are undertaking to, my lord, take care of the, my lord, petitioner hearing till her death, my lord. And
That is, there is a clause. No, they have not, they have violated it.
they are violating.
If
Lord,
they
in
have
fact,
violated-
respondent number 1.
They have violated it, what is the remedy?
Lord, for recall, my lord, it is.
No, 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 that's not the remedy. That's not the remedy.
Lord, as per
So
my
if a
knowledge
compromise
is
decree
concerned.
is passed, if it is like any other decree, if there is violation, you will execute it, whatever means you have. But on that ground, the compromise decree will not be set aside.
Lord, now the respondent number 1, she got, my lord, married to some other person, intercaste, and she left the village. The property is, my lord, is not using by anybody. In fact, respondent number 2 also, my lord, he is not taking care of
So what is the
petitioner.
scope of this, if a compromise, a Lok Adalat, whatever decree has to be set aside on limited grounds, the ground which you are saying is not available.
But my lord, they have driven out my lord petitioner from our house. Now nobody is taking care of the petitioner. Even
Notice
she
to
approached
respond.
the, my lord.
Notice to the respondent. We'll see respondent come, but you don't have a case on merits.
Notice.
Yes, notice.
Please.
Seal number 59?
50?
59?
But this matter
Yes.
pertains to tender matters.
You have instructions?
Please, no, it is fresh matter, your lordship, file is there, your
No,
lordship.
he
But
said there
I'm-
is urgency. That's
There is
why
an
I asked
urgency,
you.
my lords. I'm asking for an interim stay, my lords. My lords, on prima facie, my lords, just, my lords can see that there is a technical bid and a financial bid, my lords. Once the bidder is qualified for technical bid,
Go little slow.
Yes.
In fact, you know, you understand
Please,
the
my
facts of your case.
please, my lords. My lords,
To
now,
quash the technical bid evaluation report and the financial bid offer as far as respondent number 3 is concerned. When was it finalized?
my lords, the bid was, the date of publication of tender was 29/8/2025, my lords. Now, the date of receipt of the tender was 15/9/2025. Now, opening of the technical bid was on, my lords, 16/9/2025. The evaluation was done on 13/10/2025, and the final bid as L1 respondent number 3 was declared on 23/12/2025. My lords, my submission is, my lords, now, once the tender applies for the tender, my lords, he has to qualify for the technical bid, my lords. Now,
Where do you stand?
my lords, I'll just show, my lords.
No, where do you stand?
My lords, that is found in KTPP rules and KW4.
Not about the rules. Who are you? How
My
are
lords,
you?
I am petitioner.
Is also.
I understand you are the.
Is also.
Please, my lords.
How this particular, have you participated in all?
I have participated, my lords.
What happened to your
My lords, I
financial
was
bid?
declared as L2.
He was declared as?
L2, the lowest, lowest bidder.
So this respond,
This respondent is declared L1, my lords. He is not even qualified for the technical bid, my lords. This final bid will come later. Technical bid itself is not qualified. My lords, in the IFT, the final tender, this one, ma'am. But in that particular tender, my lords, certain qualifications.
all in tender matters, the scope of indulgence by this court is limited and without instructions from the respondents. we
But
can't pass
until unless there is this very arbitrary, my lords, I'll just show the
Tomorrow,
technical
instructions
details.
by tomorrow.
Please.
But tomorrow it may.
Towns he has raised.
Please.
Tomorrow.
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 But
Yes,
until
sir.
the interim stay may be granted.
Yes, next.
Seal number 60?
Take
Lords,
notice.
it's an
Notice me. kindly.
extendment order, my lords. My lords, under section 55 of the KP Act, Karnataka Police Acts.
It was issued, your lordship. Notice was issued, your
No,
lordship.
my
In
lords,
page
forcefully they have taken signature on the
Page
papers.
number 70.
Even if, my lords, even if for the sake of argument, the
a notice has been issued to the petitioner. The order passed by respondent number 2 does not disclose under which provision of the Karnataka Police Act it has been passed. And it is covered by the judgment of the coordinate bench of this honorable court. My lords may kindly turn to page number 20 of the petition.
Whatever is the provision, whether he has stated or not.
No, my
what
lords.
If he has not stated also,
Yes, ma'am.
what is the order?
He has extrained from the district of the Hubli Dharwad district.
What,
Yes.
what are you supposed to do?
My lords, yes, my lords, there is a provision for appeal.
You have to go before the
But
government.
it is subject to judicial review, my lords. That is my submission. It is subject to judicial review, my lords. My lords, on the allegation that 4 cases pending against me, they have passed the impugn order. But whereas, my lords, I have acquitted from the 2 cases after a full-fledged trial. Only 2 cases pending against me, my lords. And my lords.
No, it is not. It is not the number of cases.
Yes, my lords. But that is the allegation made in the report made by the respondent number 2 to the respondent number 4.
Go before the under section 58.
My lords, it's a covered matter. I'm relying on the judgment of the coordinate bench, my lords.
Can't give that. In every matter, we can't pass orders like this. Take that. Yes.
Yes, my lords. My lords may kindly turn to page number 20 of the petition, my lords.
Page number?
20. Annexure A, my lords.
No. This judgment you are relying on.
What
is the law laid down?
My lords, the judgment at page number 83, paragraph number 14. May I read the relevant portion? Merely on the apprehension, they have passed the impugn order, my lords.
So, first point is, in cases relating to externment, all police reports and documents, including FIR, statements, charge sheets, are not required to be furnished to the person who is sought to be externed. General information on the material allegations, the police report documents, so and so, to the person sought to be externed. This is not your case.
Indeed, my lord.
This is not your case.
Indeed.
Then the second finding in this judgment is,
Yes, madam.
there is no requirement for the Assistant Commissioner to consider and state as to whether witnesses have not come forward or would not come forward to depose against the person who is sought to be externed if he continues to reside within the jurisdiction. This also will not apply to you.
Indeed, madam.
Then point number 3, whether the principles of natural justice have been followed in the present case.
My lords, that is what.
Principles of natural
Yes.
justice contemplates issuance of notice. According to them, notice is issued, providing an opportunity of hearing and a reasoned order to be passed, amongst other things. Give that.
Order passed under sections 55, Your Lordship, 59 is appealable. Not? Order passed under section 55.
No. He says that the provision is not stated.
Yes, madam.
You know, in this judgment, it says that if an order is passed, whether it is an order passed under clause A or clause B of section 55 of the KP Act 1963 is not known. Where is the impugned order?
Page number 20, Your Lordship.
Page number 20 is the operative portion, my lord. It is in Kannada. In the first line itself, it has been mentioned. In the first line, my lords.
First line, Your Lordship, column 55, section 55.
Only section 55. But section 55 contains 3 subclauses.
Won't we understand from the contents of the order what it is?
Pardon, my lord. My lord,
He has said that there is, whether it is A, B, that's only, that's how this judgment will come to your rescue.
Yes, my lord.
File a translated copy of this order, we will see.
Yes.
The petition shall file the translated copy
Section
of the
59.
order.
In the meantime, my lords, there is a stay, my lords, as he is the only breadwinner and his daughter is suffering from serious health issues. So, my lords, on that ground, a stay may be granted.
Section
I'll file the
59
translated
is
copy.
clear, Your Lordship. Section 59 is clear.
With this judgment, the judge has taken a view that section 60 is, there is a judicial review.
Yes.
But now, only thing is whether that order is passed under 55 ABC, which provision it is, and whether the reasoning is given or not. Actually, all these will not apply to this case. But anyway, is relying on a judgment. The petition shall file the translated copy of the impugned order. This matter on 19th till such time.
My lords, on 22nd, may kindly have it on
No,
22nd.
no. On 19th till such time. There shall be stay of all further proceeding.
Grateful, my lord.
Whatever, look at the interim order, what is sought till such time. Yes, next.
Seal number 63.
application for renewal of passport, my lords, is rejected. There's a recent Supreme Court judgment, my lords, on which I'm relying. Says that irrespective of pendency of criminal proceedings, the passport has to be renewed. Para number 21 of the judgment, page number 16, lords.
Where are you? You're not in the country.
No, lords, he is staying. He is attending to the court proceedings on every day.
No, she was saying that you are out of country.
No, my lords. He has sworn to the affidavit next to this petition also. He is residing in the hometown. He is residing. His passport has already expired, my lords. It filed for renewal.
Who appears for the respondents?
Respond number 3, I'll take notice, Your Lordship.
Respondent number 3, the AGA takes notice. Who appears for the opponent?
Venkatesh Kharvi sir appears.
Name is there, printed?
No,
The
Your
passport
Lordship.
is on.
No.
So and so is directed to take
Union
notice.
of India.
So and so is directed to take notice on behalf of the respondents. List the matter on Tuesday.
Please.
Petitioner shall serve the copy of the writ petition on the council for the so and so. Yes, next.
List number 2. Sitting judge. Number 1.
It is pay and recovery, Your Lordship, I sought for yesterday. That is the only thing. Because it is claimant's appeal, enhancement also for pay and recovery, Lord.
Yes, what is?
My lord, as on date of accident, the rider of motorcycle had no DL, my lord, section 3
That's
and
why
1.
pay and recovery.
Pay and recovery.
He says he is not pressing on the
Yes.
enhancement.
Please.
Agreed by the MFA is against which order? First MFA, MBC,
My lord, 902 and 903, my lord.
first 100618 is against?
Please.
It is 903 of 2016, Your Lordship. MEC 903 of.
MBC of MBC 903.
903 of
Next
2016.
is MBC
1000555.
904.
902.
902, my lord.
Agreed with the award passed in MBC number. This is not a common order.
No, not common.
No, my lord, separate.
Separate order.
Separate order. Agreed with the award passed in MBC number 903 of 2016, dated 5th November 2022. The claimant is by so and so. The claimant is before this court seeking enhancement of the compensation and also also questioning the liability that is fixed on the owner of the vehicle. The tribunal by order impugned had granted the compensation as per the table given below at paragraph number 69, extracted. When it comes to the liability, the court has held that. Where do you get that?
Para 72, Your Lordship.
Para?
72, Your Lordship.
The court, on the ground that the driver of the offending vehicle is not having a valid driving license to drive the vehicle, had held that the the principle of pay and recover will not apply. The insurance company is not liable to pay the compensation, and the liability is fixed on the owner of the vehicle. Next para. Land counsel appearing for the claimant submits that the tribunal has not awarded the compensation, does not awarded a just and reasonable compensation. Further, in the light of the law laid down in Swanensing's case, the insurance company is liable to pay the compensation as the petition is a third party and record the same from the owner of the vehicle. But the tribunal has fixed a liability and on the owner of the vehicle. Next para. Then counsel appearing for the respondent insurance company submits that the court had considered all the aspects and granted the compensation and no grounds or there are no grounds to enhance the compensation. Then coming to the liability, it is submitted that as a driver was not having a valid driving license, court had rightly fixed the liability on the owner of the vehicle and exonerated the insurance company. Next, having heard the counsels on either side, there is a material on record. First, coming to the aspect of compensation, this court has perused the award and the compensation that is awarded for the injuries sustained by the claimant. The court on all the heads has granted a reasonable compensation and this court finds no reasons to interfere. Then coming to the aspect of liability, as rightly argued by the learned counsel appearing for the claimant in the light of the law laid down in Swanensing's case, the principle of pay and recover will apply and the insurance company is liable to pay the compensation and record the same from the owner of the vehicle. Accordingly, the appeal of the claimant is partly allowed. Allowed by fixing the liability, by applying the principle of pay and recover, insurance company shall pay the compensation and record the same from the owner of the vehicle. Yes. Next matter, give the next matter.
Next is also same, Your Lordship, out of same accident, Your Lordship.
Same amount also same.
Amount is different, Your
change,
Lordship.
That I will dictate.
Para 65, Your Lordship. Of this table is mentioned.
All facts are the same, only the MBC will change. So agreed with the
55.
order passed in MBC number 902 of 2016, 5th November 2022. Then the tribunal has granted the compensation
65.
as per the table given below at page number 65 and remaining all contentions are one and the same.
Please.
Yes, partly allowed both. Yes.
Number 2, what is matter?
Direct the insurance company to deposit, Your Lordship. Direct the insurance company to deposit the compensation amount.
That will be there.
Yes.
Within time will also be stipulated. 2. Yes.
2.
My Lordship, I have taken paper publication as against dispo number 5. I have produced it along with the memo dated 22/12/2025, my Lordship.
You have taken out paper publication.
Yes, I have also produced a paper before this honorable court, my Lordship.
Memo is filed having in support of the so and so. It's taken on record and notice to.
Respond number 5, my Lordship.
Huh?
Respond number 5.
Respondent number 5 is held sufficient. Then what about the amendment of the cost?
I'll carry out within a week. I'll carry.
The amendment shall be carried out within a week.
Please, my Lordship.
Next. Yes, 7.
Serial number 7. Hearing on is serial number 7.
Please,
My
for
lord,
the respondent.
This matter pertains to the petitioners are the contractors who are engaged in solid waste management in Hubli Dharwad municipal area. My lord, morning serial number 67, my lord. This honorable court also granted the interim order, my lord. My lord, in this case, my lord, we are seeking time till March 30th, my lord. Because
Court has granted stay.
ಇದ್ರಲ್ಲಾಗಿದೆ considering the earlier order passed by this honorable court.
What is that 67?
My lord,
HDMC matter.
SDMC matter.
Stay till what time? Huh?
Considering
the
No, since in other connected matters, like the present numbers, my lord, wherein the similar interim order granted, my lord, I told that on the basis of that, my lord has granted an interim
yes,
order.
my lord, we
This
are
issue-
not on that point. My lord, we are requested, my learned senior, my lord. Till March 30th, my lord, we have invested the amount as my lord, we have provided the service.
Friend will do.
We have provided the service for 15 years, my lord. My lord, with
Instructions.
my lord, this issue just I'll narrate, my lord, what happens. These, the petitioners, my lord, they are serving, my lord, they are supplier of the, my lord, manpowers, where, my lord, the collection of the waste management to the Hubli Dharwad municipal corporations. They initially in the year 2009, they have been, my lord, a tender was called and they have been given a permission to supply the manpowers for the ward-wise, my lord. That is initially for the 1 year. Thereafter, my lord, they continued, but there was an accident. What happened?
For 15 long years.
Yes.
They continued. What did they do?
Never called for the tender from the last.
No,
15
no,
years.
no. They come till the next orders, no, with the state condition, they continued.
No, the tender, no,
No, yes, my lord. Now their duty is, my lord, they have to supply the manpower. That's only the manpower, my lord. The laborers they have to supply. The meanwhile, my lord, what the duty is, my lord? When they supply, my lord, like in the one tender, they're supposed to supply the 10 laborers, my lord. We have paid the amount to them, the contractor. In turn, my lord, they are paying them, my lord, that amount to them, my lord. Then, after deducting some percentage of amount for that is the only duty. What happens in the meanwhile, my lord? There is a government circular, and also, my lord, there is huge complaints by the laborers whom they have, my lord, supply. Yes, neither they are paying the amount, nor they are giving them, my lord, any material. Thereafter, my lord, we them ourselves, my lord, are supplying them, my lord, all these other materials, everything, my lord, like equipments, my lord, servicing, my lord, them. This is going on. My lord. There is serious complaint is coming. Now, my lord, what the government decided, in order to, my lord, some complaints, FIR filed, some persons were trying to commit suicide because they didn't know salary. So, what the, in view of this complaint, what the government decided, my lord, we instead of, my lord, because their duty is only supply, my lord, they are not, my lord, doing any other than the, my lord, there is what instead of that, my lord, let the government directly pay the amount to the laborers.
Directly.
Yes. So anyway, we have not removed any single persons. We are directly paying. So now they became the, my lord, the employee of the, my lord, the workers of the corporation. And meanwhile,
I have not floated anything else.
No.
No tender, nothing.
No.
Whoever are working, whoever are
Yes,
discharging,
yes.
you have directly engaged them.
Engage them. We are now directly paying them. No, there is no. Now they are saying that, not we have invested. No, I don't know what amount they invested. Now the last time, not.
My lord, my submission is.
What happens, my lord?
My lord, Annexure C in first.
All, you
Please.
have vested right to do something from
Yes,
the last
yes,
15 years.
yes.
That's number one.
Yes.
And you are not working to the satisfaction of the respondent. And it is a case that, like, when you are not properly paying the people who are working for you, now those people are, now they're,
Yes.
they're
Complaint.
so no public interest involved in this, your personal interest.
Yes, my lord, my submission, if any labor complains against the contractor, my lord, then we have no case at all. We have no put before this honorable court also. My lord, my submission is that somewhere else, my lord, some things happen, my lord, up to March. My lord, we are seeking time up to March, my lord. My lord, for that reason, my lord.
When you started paying to the laborers directly?
The last 2 months, 2-3 months.
So then it's happening from Jan and Feb.
2 months. In some case, there is a stay order.
My stay
but
order
the
is
stay,
there,
what
my
the,
lord.
if you see
Stay
the first
is there.
interim stay, it says, no, if the order is not already implemented, the actually the main order stay was granted, saying that if the already not implemented, except one person who already by that time we are paying the directly to the laborers.
My lord, kindly protect our interest till March, my lord. This is our request, my lord, because my lord, we tendered service for more than 15.
You have come up with the suggestion that if there are any complaints against you.
Yes,
out of
yes,
the
my
court,
lord. Yes, my lord. We have no.
Find out. Find out.
No, I can produce one of those. There is no reason.
Please, please.
That is out of the court. We'll discuss the writ petition on that. This matter on 22nd.
Please.
Yes, next.
My lord, interim order is there.
Interim order not granted till now.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಇದೆ ಎಲ್ಲದರಲ್ಲೂ please.
Whatever is interim order extended till then.
Please.
Yes.
Please.
Till number 10.
No, he is not aware like what is he can't take action.
No, they are not taking any action against me.
It is like the moment he gets it on 22nd, we will pass orders.
Please.
Yes.
Please.
Till number 10.
Here for petitioner, my lords.
Appearing as a
Amendment
proxy, I'm appearing as a proxy counsel in this matter, your lordship. I'm seeking for a short accommodation. Any date may be fixed. Counsel on record was having some.
This is matter on 19th of February.
My lords, earlier date. The reason is this, my lords. The amendment was filed after the suit was remanded back.
Have an interim order.
Interim order is there.
We have
I'm
to
in
hear the
possession.
matter.
1974 suit, more than 30 years old suit, that is the reason.
But stay you have obtained.
Yes.
Please. List the
Since
matter
amendment
on-
is allowed,
List the matter on 17th.
17.
Yes.
interim order may kindly be extended.
But sir, either 20 or 21, please. my lord. Either 20 or 21, my lords.
My lords, in the month of January, my lords, may I request
17.
any date in
29th of January.
Please.
Yes.
Grateful.
14.
Seal number 12. 12.
12 is adjourned, I think, no?
No, no, ma'am. 11 is
12.
12.
No representation. List in the month of March. Then
Seal number
14.
14.
Lords, I already complied the interim order by this honorable court. And
Memo for
already,
retirement filed by advocate for petitioner.
I am this as a subsequent advocate. Lords.
NOC.
I have filed an NOC.
Filed seeking retirement. Memo is filed for, memo of retirement is filed by the advocate for the petitioner. Memo is taken on record. And is
Such a law.
permitted to retire as already, Mr. S.H. Edward has filed his wakalat. Yes, list is matter. After 4 weeks, interim order.
Interim order may
is
kindly
extended in that.
Interim order.
Interim order is there?
Is there,
Look
Lords.
at it, if it is there, extend.
Yes.
ಸರ್ ನಮಗೆ ಒಂದು ಆರ್ಡರ್ಸ್ ಕರೀಸಿ
ಚೆನ್ನಾಗ ಇಂಟ್ರಿ ಮಾಡೋ ಎಕ್ಸ್ಟೆನ್ಷನ್
ಯಾವಾಗ ಕರೀತಾರೆ ಇಷ್ಟು ಆರ್ಡರ್ಸ್
ಮುಂಜಾನೆ ಮೇಡಮ್ ಅಂದ್ರಿ ಸರ್ ಮೇಡಮ್ ಅಂದ್ರ 4 ಸೀಲ್ ನಂಬರ್ 2 to 6 ಸೀಲ್ ನಂಬರ್ 2 to 6 ನಾನು ಕರೆದೆ ಸೀಲ್ ನಂಬರ್ 2 to 6 ಅಲ್ಲಿ ಇದೈತಿ ಅವೈಟಿಂಗ್ ನೋಟಿಸ್ ಇದೆಯಲ್ಲ ಎಂಟ್ರಿ ಮಾಡೋದು ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಅವೈಟ್ ಐತಲ್ಲ ಅದಕ್ಕೆ
ಸುಳ್ಳ ವೇಟ್ ಮಾಡಲಿಲ್ಲ ಎಲ್ಲಾರು ಕೇಳಿ 230 ಕೇಳ್ತಾರೆ
ಸರ್ ಅದಾಗ ಆಯಾ ಎಕ್ಸ್ಟೆನ್ಷನ್
ಕಾಡುವಲ್ರಿ ಒಂದು ಮ್ಯಾಟ್ರ್ ಇದ್ದಾಗ ಹಂಗೇನು ಒಂದು ಇರ್ತದ ನೀವು ಬೇರೆ ಊರಿಗೆ ಹೋಗೋರಿದ್ರೆ ಕೇಳ್ಬಿಡೋಕೆ ಬೆಳಗಾವ್ ಹೋಗ್ಬೇಕಲ್ಲ
ಕೋರ್ಟ್ ಒಂದು ಕಿರಿಕಿರಿ ಮಾಡೋದು ಚಲೋ